Okay. All right. We do call for a hearing, case S24Z 1139, as well as S25Z 0722. This is an inquiry concerning Judge Shermela Williams. We ready on behalf of the commission, Ms. Beal?
We are ready, subject to the panel hearing from Mr. Banks about his motion.
Okay. And ready on behalf of Judge Williams, Mr. Banks, and Ms. McFadden?
Judge, if I may.
I know you said you wanted to put something on the record.
Yes, sure.
Go ahead.
Thank you. Good morning to the panel. It's a pleasure to see everybody. Again, my name is Gabe Banks, and I represent, along with Jamala McFadden, Judge Williams. As the court knows, literally at the 8th hour on yesterday evening, we filed a motion to dismiss. I'm not here to argue the merits of that motion based upon the court's gracious allowing us to meet with the court or the hearing panel and advise the hearing panel of the issue that we believe is dispositive. And so, but what I am here to say is that it's important. This is an important motion, and it's important because we learned of the information over the weekend, and we were drastically trying to put together the motion after not having been privy to the information that we learned. No fault of Director Ville and or former Director Chuck Boring. Having said that, the JQC investigative members were aware of this information and they failed to disclose it. And it should have been disclosed. And arguably, the reason why we're here and we filed that motion to quash is because we believe that it creates an appearance of impropriety. More importantly, in the event that both Judge Dorisall and Heydrich should have recused, and this panel decides that and agrees with that, then they didn't have a quorum. And so if they didn't have a quorum, everything is otherwise invalid, pursuant to Rule 3C of the JQC rules. The quorum has to consist of 4 people, at least one being a judge, at least one being a lawyer, and at least one being a citizen. And so, respectfully, I believe that this issue needs to be decided and resolved before we proceed. At no fault of Judge Williams did we learn this information. And right now, she is the accused. Her job is on the line. And ultimately, fairness only mandates and warrants that this issue be resolved before we proceed with this case today. And so for those reasons, I would ask for a continuance. I've talked to Director Ville briefly about it, and I'll let her speak for the JQC, but I do believe this issue needs to be resolved before we proceed. And I know that we talked about all that yesterday. Having said that, I needed and wanted to put that on the record. Thank you.
Fair enough. Thank you. Ms. Beal, response?
So first, I think what you're all wanting to hear, I oppose the request for a continuance. However, I expressed some of this during our conference yesterday afternoon. Again, they have filed a motion to dismiss, a motion to quash, or in the alternative, a motion for an evidentiary hearing that they claim is dispositive. I know that the panel is not interested right now in hearing about the merits of the motion, but I will advise you that there are factual errors and I believe the incorrect legal standard has been applied in this circumstance. There are specific state level, both the statute and the rules of the JQC that I think prevail in this circumstance, and those are the rules that we should be following, the more specific set of rules that apply in this circumstance. Something else that I would like to make clear for the record is Mr. Banks did indicate that the information that some of which forms the basis of the motion that they filed, they had not been privy to it until the weekend. So I found out about this information from Mr. Banks on Sunday at 9 p.m. And I want to be clear, it's not from any discovery or information that I disclosed to them. This information came from documents that they were looking through. And so they were documents that I had not seen before, although I will note they are publicly filed documents that have been available since 2020. So I just want the record to be clear. None of this has anything to do with information that I gave to them. I understand the representation that they were not privy to it until Sunday. However, this motion was filed yesterday at 7:54 p.m. and we were set to start trial this morning at 9 a.m. I understand that the hearing panel, and in the civil context, I think it sometimes happens that a judge will delay a decision on a motion for summary judgment and go ahead and proceed with the trial or the hearing, and I do understand that that is within the panel's authority. I am concerned about not having had the time to respond to this motion in writing. I am concerned about not having had the time to interview multiple of the witnesses that are contained and mentioned in the motion. They're on my witness list, and some of them are slated to testify today. But anything related to the allegations in that motion, I haven't had an opportunity to explore with them as of this morning. And that concerns me, and I think that fairness requires that I be extended that opportunity. I understand that this is not a jury proceeding, and I understand that this panel is very able to and will, I know, sift through the things that are relevant at the end of the day and not relevant at the end of the day, and those things that actually bear on the formal charges and whether they've been proven, and if so, whether they warrant discipline. I understand that, but from where I stand as the director of this commission, this motion is out there. It is now public. And right now, I have not had an opportunity to research it or to respond. And so what I am requesting is not a continuance, but until tomorrow morning. I am asking that we break today and reconvene tomorrow morning. I understand if the panel does not want to hear argument or have an evidentiary hearing tomorrow morning. However, I would like to submit a written response to that motion and talk to the witnesses that have been mentioned in that motion. I expressed to Your Honor yesterday via email, if we do proceed this morning, I would ask, I'm moving in limine, to have the respondent prohibited from in their closing argument touching on this motion or the information that forms the basis of the motion, as well as cross-examining my witnesses about this information that, again, was not submitted to me in a motion until yesterday at 7:54 p.m. And so that is my request of the panel at this time. Oh, one more thing. It was mentioned yesterday during our conference that both sides have been able to pare down our witness lists. Assuming that the respondent agrees to the stipulations of fact that I have sent to them, I believe that my witness list will be 13 people. And so I am confident that if we start tomorrow morning, I'm not going to make a promise that I will finish my case in chief, but I do think it will be close based on the stipulations that we now have.
Finish your case in chief tomorrow or finish your case in chief this week?
This week.
Okay, gotcha.
Thank you.
All right, thank you. All right, with respect to the motion for continuance, I understand and respect why, Mr. Banks, you've made that motion on behalf of your client, as I sort of hinted to you all yesterday in our call and also email last night after I received the motion. At this point, we are not continuing this hearing. I do understand that if you are successful on your motion and the charges result in being quashed, that may mean that we have spent 3 days of our time hearing evidence that we may not have needed to hear. That, however, is a calculated risk the panel is willing to take at this point. So at this point, we're going to move forward with trial. The motion for continuance is denied. With respect to the motion in limine, and I guess in as much as you asked for not a continuance but a stay, we're not pausing this. We're going to start as planned, as I told you. With respect to the motion in limine and limiting mention and opening, mention to witnesses or mentioned in testimony. Did you want to respond or be heard on that, Mr. Banks, since that was sort of bubbled up?
This is a part of Judge Williams' theory of the case, her defense. It goes to mitigating circumstances concerning what the ultimate punishment should be from a disciplinary perspective. While we learned of this information over the weekend, it has been in the ethos, in the atmosphere since 2020, and more importantly, the JQC knew about it. Not Director Bill, not Chuck Boring, but, I mean, presumably Stacey Heydrich and Judge Darasol both knew that they had committed or made campaign contributions to Rebecca Reeder's then campaign or bid for re-election back in 2020, and certainly Judge Heydrich knew that she had a personal close relationship with Rebecca Reeder, Judge Williams' political opponent. And so I'm not sure how the JQC can come in and ask us to limit what our theory of the case is based upon a motion that we filed when we learned of the information over the weekend, when they being members of the investigative panel have always known this information. That is not a fair ruling. That wouldn't be a fair ruling. It wouldn't be fair to Judge Williams. It wouldn't be fair.
Mr. Banks, in fairness, you have been presumed to know that since 2020
Why?
because it's a public filing.
So I have to presume that I know everything in the public?
That is the presumption. That if it's in a public filing, it is presumed to be known. So
Well,
it can't be the theory of your case, since we were getting ready for this trial well before you ever discovered or was already in a public filing. So I don't know how we can't separate what is going to happen in this trial from what your motion is. We can separate those two things, and if we need to have separate evidentiary hearings, we can do that.
Okay. Well, respectfully, Judge,
Can you
I'm not
call me
for.
Member Lopez.
Yeah. Look, I mean,
I lost my honor a long time ago.
Right. So I'm not familiar with that body of the case law that you know you're relying on. I will say this. Then there's no prejudice for us to talk about it. If we were presumed to have known it, and we don't have to share our theory of the case with them, and so we shouldn't be precluded from arguing what our theory of the case is if they were presumed to have known it as well. And so what is the prejudice to the JQC? There's no prejudice for us to be able to argue that theory of the case, given the fact that it was presumably known to everybody because it was a public filing. So there's no prejudice to the JQC. You shouldn't limit our ability to go into those areas of our theory simply because we filed a motion with respect to the matter that was publicly known, presumably to everyone. Thank you.
Thank you.
Okay. All right. Well, as far as the motion in limine is concerned, we don't want to let this issue take over what the focus here is. And the focus is there are two sets of formal charges that have been filed and have been answered. And it is the JQC's burden to prove whether or not those happened, and then whether or not those are violations, if true, of any canon, and whether they warrant sanction or not. So respectfully, I think the panel disagrees with Judge Williams' position as to what is relevant for purposes of this hearing and what would be relevant for purposes of the motion. And I will just say, as far as the motion's concerned, without getting into the merits, I have some serious questions about the timeliness aspect of it that we can explore when we have that hearing. But I'm going to give you a hearing on that motion, what that looks like, and whether that includes evidence or just argument. You know, we'll cross that bridge when we get to the end of the week and figure out the next steps in our schedule. But you will have a full and fair opportunity to explore that theory, as Mr. Lopez said, and put up whatever evidence or record you need to make that argument. It's just our position that much of that, if not all of that, is not relevant to defending against the charges here. So at this point, the motion in limine is granted. Obviously, if something happens where you believe a witness has opened a door to something, or something you think is fair game on cross, please just ask and we'll explore that. But what I don't want is for this hearing to turn into sort of a discovery expedition for the motion that we all know is forthcoming that we're going to have a hearing on. That would not be fair, and that really would be sort of the side issue taking over the main event. So with that, before we start with opening, let me just say I don't know who all is in the courtroom gallery. I know we had a conversation about the rule of sequestration. I know you both want to invoke it reciprocally. So I do need to make sure that you all look around the courtroom and see if you see anybody that's a witness on your witness list in the courtroom. I know somebody's just stepped out. Okay, thank you. And I'll just say, since we're being live streamed, I know that was a concern that was raised by both sides as well. If anyone is watching the live stream who may be a witness in this case, obviously you cannot do that. You cannot watch the live stream broadcast unless and until you've testified and or been excused from your subpoena in this case. So anybody watching the live stream who might be a witness, of course, cannot watch and cannot talk to anybody who might have also watched about what's been said or try to find out any information about what's been said. We'll probably keep this same reminder going. Did y'all have witnesses out there, Ms. Veal, that we need to instruct, or have you already instructed them?
There is one witness that actually, the one that just came in the courtroom, that should probably be instructed.
Good morning. Tell me your name, ma'am.
Adidion Aaron.
Okay. Ms. Aaron, you followed the court's instructions and excused yourself from the courtroom. I think everybody just wanted you to hear the follow-up instruction, which is, as you may or may not know, this is being live stream broadcast through the JQC's website. All the TVs out there are turned off. We've just instructed all the witnesses who may incidentally have logged on and not realized they couldn't, that as a witness, not only can you not sit in the courtroom and hear the live testimony, but you also cannot watch the live stream, obviously. I know that should be obvious, but unless and until you've been excused from your subpoena when you finish testifying, then of course you can watch it or be in the courtroom just like any other excused witness. So those TVs should be off, but obviously don't talk to anybody about who may have watched the live stream. Don't discuss your testimony with anyone until you've been up and down and excused. Okay?
Yes, Your Honor.
Thank you so much.
Thank you.
All right. Are you ready to proceed with opening, Ms. Veal?
Yes, Your Honor.
All right, go ahead. Oh, and let me just say, and I should have said this, I'm sorry, and Ms. McFadden mentioned it yesterday. I know it's been in several scheduling orders that the parties wanted to combine these matters because there's two different matters, obviously, S-24 and S-25, but everybody wanted to, as I understood it, consolidate this for the purpose of having one hearing, and so that any evidence that's presented by either side in this is fair game to be considered in either of the two sets of charges. Is that right, Ms. Veal?
That's correct.
Is that right, Ms. McFadden, Mr. Banks?
Yes.
Okay. we can. Can we, Mike, can we put the PowerPoint on this one too, or no? Perfect. Thank you. Perfect.
The Georgia Supreme Court has told us that the purpose of judicial disciplinary proceedings, above all, is to ensure that the public is able to trust the judiciary, which makes sense. Because also, as our Supreme Court has told us, for judges, their only power is their judgment. And that fact should shape the kind of conduct that we insist upon from our judges. Now, more than ever, when the public walks into our courtrooms, any courtroom, any level of court, it is important that the public have respect for the judiciary, that the judge not give the public reasons to question its integrity, which lead to questions about judges' judgment. What I expect you will hear during the course of this proceeding is that again and again and again, Judge Williams has demonstrated disregard for the Code of Judicial Conduct and disregard for the way in which she should behave as a jurist on our highest level trial court in this state. That conduct began in 2022, or at least the JQC's investigation began in 2022, after Judge Williams successfully defeated an incumbent on the Fulton County Superior Court bench during an election in June of 2020. She took office in January of 2021, and she first received notification of complaint 22-102 in February of 2022. What you'll hear about this complaint is a petition for modification of child visitation and contempt was filed in the Superior Court of Fulton County in September of 2021. The respondent in that petition was an attorney that appeared in front of Judge Williams as a guardian ad litem, and in fact, Judge Williams had appointed her to multiple cases as a guardian ad litem. And it was a dispute that this attorney had with her ex about their minor child. What you will hear is that upon learning that the petition had been filed in Fulton County, the respondent, Ms. Alexander, was immediately concerned because not only did she have pending matters where she had been appointed as a guardian ad litem in front of Judge Williams, she had those matters pending before every other judge on the Fulton County Family Division. And there are 4 judges in that division. You will hear that this greatly concerned her because she appeared frequently in front of each of the judges, not just Judge Williams, and she expressed this concern to her attorney, Ms. Franklin. Ms. Franklin, in response, and they discussed getting a senior judge to hear Ms. Alexander's petition. Ms. Franklin then contacted Judge Williams' chambers. That day was the first day for Judge Williams' new staff attorney. She had had turnover in her staff. She did not have a judicial assistant at the time, so a floating judicial assistant was assisting that day. She had a brand new staff attorney. This was October 18th of 2021. It was her very first day. and she had a case manager. And when Ms. Franklin called the chambers of Judge Williams, Ms. Franklin will tell you that she spoke to Judge Williams' brand new staff attorney, Janelle Bowles, and explained that she represented Ms. Alexander in a petition that had recently been filed and inquired about the status for the process by which one obtains a senior judge. Because it was a staff attorney's first day, she didn't know, and indicated to Ms. Franklin that she would inquire of the judge and call her back. Once the judge becomes aware, and I expect what Judge Williams will tell you was that she was in court that day, took a recess, came into her chambers, and was handed a Post-it note that didn't have very much information on it about the case. I expect she will tell you that she found out that Brandy Alexander was somehow involved, and so Judge Williams, instead of having her staff call, instead of asking for additional information, calls Miss Alexander directly on her cell phone at that time. I expect what Miss Alexander will tell the panel is that when she received the phone call, she was in her office that she rented at the time from attorney Don Smith, and Judge Williams immediately wanted to know why she was requesting a senior judge on her case. I expect Judge Williams is going to tell you at the time she made the phone call, she did not know that the case was Miss Alexander's personal case, but just thought it was about one of her guardian cases. But Miss Alexander will say that Judge Williams did know. There was no confusion about the case she was calling about. Explained to Miss Alexander they couldn't get a senior judge, and let her know that their conversation that they were having was okay because they were sorority sisters. Miss Alexander will tell you that Judge Williams told her that, hey, my new staff attorney, Miss Bowles, said to me before I called, hey, should you make that call? Isn't that ex parte? And she told her no, it was okay because they were sorority sisters. I expect that you will hear from Miss Alexander and Miss Dawn Smith, who overheard a portion of the phone call because Miss Alexander went into her office and turned her phone onto speaker. And I expect you will hear from Miss Smith that she heard Judge Williams multiple times reference the fact that the two were sorority sisters. Judge Williams wanted to know, again, why Miss Alexander wanted a senior judge, and Miss Alexander explained she didn't want her dirty laundry aired out in front of the judges that appoint her to cases and that she practices before. Judge Williams assured her that, you know what I'll do to save you from any embarrassment in front of people you might represent or attorneys you might work for. I will pull your case from our standard 30-day status calendar, which are mass calendars that are typically heard in front of judicial officers in Fulton County. I'll pull your case from that calendar and I will set it on an individual calendar alone, and I will close the courtroom for your case without request for Miss Alexander. But Judge William offered that as assurance that Miss Alexander would not be embarrassed in front of other people. And then toward the end of the phone call, Judge Williams inquired, hey, do you want to loop your attorney in and to this call? And Miss Alexander said no. She hung up the call and later reported to her attorney what happened. And again, Ms. Smith heard a portion of that phone conversation. What you will then hear is that a motion to recuse was not filed at that point. And we will explore the why of that, I'm sure, in great detail. But there was a subsequent hearing. The 30-day status hearing was supposed to occur October 28th, when the lawyers contacted the judge's chambers to inquire about the link for the hearing. They were provided the link, and then thereafter they were told, hey, Judge Williams is going to hear everything on this case. So that 30-day status conference hearing was canceled without any explanation. They then proceed to a motions hearing in December, where Judge Williams on the record raises only the issue that Ms. Alexander was a guardian in front of her. The petitioner and his attorney at that point indicate they would like for Judge Williams to recuse because it made him uncomfortable that that Ms. Alexander had pending cases before Judge Williams. And Judge Williams then took it upon herself to talk the petitioner and his lawyer out of that by, and there's a transcript of this that you'll have, by explaining that, well, if I have to recuse, then every other judge in this division has to recuse because she has cases in front of every other judge in this division. And in fact, Ms. Alexander, where else do you have cases? You have cases all around the metro area, and so those judges would have to recuse. So then what? And after all of that and that exchange, finally the petitioner and his lawyer say, you know what, we're withdrawing our request. Ms. Alexander and Ms. Franklin at that point did not move for Judge Williams' recusal. Ultimately, after the temporary hearing in January, Ms. Alexander engaged another lawyer, not Ms. Franklin, to file a motion to recuse Judge Williams. That motion will be before you. It included additional information beyond the ex parte conversation. That motion was served in January. You will hear that in early February of 22, Judge Williams made a phone call to Edidian Aaron, who is an attorney in the metro area. She does family law. And Judge Williams made a phone call to her, and I think the evidence will show that she wanted to vent about the fact that somebody had filed a motion to recuse her that she did not like. And she was defensive about it. The evidence is going to show that she was upset, that she felt like the lawyer, Ms. Alexander, had made the matter personal. She didn't understand why the parties needed to make it personal. And she expressed concern to Ms. Aaron that if she were to recuse from the case, it would make her look as if she had done something wrong, and it could harm her in a future election. And this is when the motion to recuse is pending. During that conversation with Ms. Aaron, Judge Williams also spoke to her about the fact that she had given Ms. Alexander business, and so again, she didn't understand why Ms. Alexander would come after her personally, and that she had essentially been a mentor to her, and so again, she was very bothered by it. Understand that judges are human, and that happened, but she makes this call either without regard for or knowing that Miss Aaron is a good friend of Miss Alexander's. So she's talking to a mutual friend. Again, and Miss Aaron currently has cases before Judge Williams. Also in the call, Judge Williams talks about, and I expect you're going to hear evidence, that Judge Williams has a reputation of being a father's judge, meaning she often rules in favor of fathers on custody issues. And I believe if you ask any member of the bar that comes in here, they would probably be able to tell you about that. Ms. Aaron mentioned that to her during this phone call, and Judge Williams explains that she is sick of women laying with men and then trying to get her to take custody of those men's children from them. And that her view is that the way custody should work is she starts at a place of 50-50, right, joint, and the parties need to walk her away from that, which of course is not the standard. The standard is what is in the best interest of the child. After that phone call, Miss Aaron, or during the phone call, Miss Aaron texts Miss Alexander and says, Judge Williams has called me and she's talking about your case to me. So understandably, Miss Alexander is upset. They don't speak on the phone until the next morning, the 9th. During that phone conversation, Miss Aaron relays to Miss Alexander what I've told you, obviously alarming, but Miss Alexander will tell you the most alarming thing that Miss Aaron relayed to her was that during her gripe about the parties making the matter personal, Judge Williams said, I'm going to show her personal, and I'm going to take that kid and give the kid to the father. That's what sent Miss Alexander into orbit, and I expect you'll hear she made multiple hysterical phone calls to people. As she was talking to Miss Aaron, Miss Alexander obviously expressed her concern, and Miss Aaron said, "Do not bring my name into this. Do not bring my name into this," despite the fact that they were apparently great friends. "Don't bring me into it." So Miss Alexander spoke to her attorneys, and her attorney said, "You have to get your friend, who you won't even name to me, to write an affidavit. You have to do it. We have to have an affidavit for another motion to recuse or to supplement our motion to recuse." Miss Alexander called Miss Aaron back, and she said, "Nope, not doing it. Won't sign an affidavit for you. I have a business to run, and I'm not doing it." So the JQC was engaged at that point. The matter was reported to the JQC. We sent Judge Williams an early notification letter, given that the motion to recuse was still pending. And she responded to that notification letter, and she ultimately denied the respondent's motion to recuse. She indicated that it was not timely, and she also did what our Supreme Court tells judges not to do, which is refute the allegations or offer up information and evidence to refute the allegations, because when judges do that, they make themselves an adversary of the party seeking their recusal, and that's exactly what she did. She then, after she entered the order denying the motion to recuse, a few minutes later turned around and voluntarily recused from the case. And so when she responded to the JQC, obviously a piece of that inquiry was, "Hey, I voluntarily recused from the case." And lucky for everybody involved, that happened before she made any further decisions in the case. Complaints beyond the first one that I just talked about, I've listed all of them out here. They're in the formal charges, and I'm not going to read them out. There are a whole lot of them. And these are the complaints that relate to the delayed issuance of final orders. They are contained in both the 24 formal charges and the 25 formal charges. And then there are some of the complaints that contain allegations that Judge Williams did not timely decide motions as required by the law in the state of Georgia. Based on her county size, she is required to decide motions within 90 days of submission to the court without argument, or 90 days after argument. And so there are allegations in there that contain to some failures to decide motions at all, and then failures to issue orders on those motions as also required by that statute. I'm not going to use the panel's time going through all of the details of all of the failure to rule complaints. However, they range from delays between 13 months to over 2 years. Judge Williams has decided that she is going to admit the majority of the allegations related to the delayed orders and rulings, and what I expect is that she's going to offer information about the functioning of her office and issues that she was having with her staff attorney at the time, and offer that as an explanation for the delay in order. I also expect the evidence to show that multiple of the lawyers that were involved in the cases that form the basis of these complaints contacted Judge Williams' chambers over and over and over and over and over again via email, some of them via phone call. You are also going to hear from some lay witnesses who attempted to pursue getting their orders on their own, one of which showed up to Judge Williams' chambers. And so you're going to hear from those individuals and how they were impacted as well. And I expect the evidence is going to show that there was a problem with Judge Williams' staff attorney during the beginning of these issues, completing her tasks in a timely manner. Recognize that happens when you are a judge and you have a lot of turnover on your staff, and you have a new staff attorney that's trying to get up to speed. But I would submit to the panel that this was a pattern, and not just a pattern. A lot of these delays are egregious delays, and the information related to the fact that there were delays was not contained just to the staff attorney that was having issues timely completing her duties. I'm now going to move to complaint 24691, which is contained in the 25 case. This complaint and the final complaint I'm going to discuss are the most recent allegations that Judge Williams has violated the code. And so I know in the past we have had judges before the panel who were new judges, and essentially came before the panel and said I was new, I was finding my footing. All of those things happened. I'm doing better, and here's how I'm doing better. And I believe the evidence is going to demonstrate to you that in many ways there is not much doing better with Judge Williams. In complaint 24691, Judge Williams presided over a final hearing in a divorce case at the end of 2023. During that hearing, and nasty divorce, by the way, I think many that concede to trial are, the couple's adult daughter, in her early 20s at the time, testified. I believe the evidence is going to show that the daughter at the time had a good relationship with her mother, a strained relationship with her father, and she testified about entering her father's apartment and doing damage to his apartment. Obviously, Judge Williams didn't like this, and during closing arguments in the case, the lawyers were up giving their closing arguments. The daughter is sitting in the back listening to closing arguments. Judge Williams mentions, about this issue with Molly. You know what, Molly, you're back there, stand up, and instructs the deputy right then to take her into custody. No legal findings, no determination, no advisement that, I find you in contempt, no mention of perjury, no any of that. Just stand up as you're sitting back there listening to your parents' closing arguments in your parents' divorce case, and deputy take her into custody, and has her brought up to the front of the courtroom, where she proceeds to, the judge, cross-examine this girl about all of the offenses the judge claims that the girl admitted to on the stand. You entered your father's apartment and broke these things. Burglary. Do you know how many years you could go to prison for burglary? 1 to 20. Criminal trespass. Do you know how long you could go to prison for that offense? Lists off all of these and then tells her at the end, and the girl answers every time she doesn't know. And the judge, continues to ask these questions, tells her at the end, what you've admitted to is 20, 25, 30, 35 years here today, and then instructs the deputy to take her back into the holding cell. And that's where she sat until closing arguments had concluded. After they concluded, and after Judge Williams thought, maybe she's been back there long enough to be scared straight, right? That's kind of what it reminds you of. Let me scare her and intimidate her based on what she said here today. After Judge Williams thought, you know what, I've scared her straight, deputy, bring her back out, and the first thing she says to her is, Molly, how was that for you? She then went on to give her a speech where Judge Williams talked about her personal experiences, talked all about a movie that she loves, I think in an attempt to try to convey some, impress upon this young lady some life lessons. But as we all know, as a judge, that's not her role. If she wants to be involved in a Scared Straight program, Maybe she can find another way to do that. But in that setting, it was highly, highly improper. And so you're going to hear from Molly about that experience. The last complaint you are going to hear about is Judge Williams in 2024 had an uncle that had been served with a petition for contempt. That petition had been filed by family law attorney Patricia Shoemaker and her associate, Bonnie Stinson. It was filed in the Superior Court of Fulton County and randomly assigned by the clerk to Judge Kevin Farmer. After the petition was served, of course we all know, generally people have 30 days to submit their answer. And so the answer would have been due April 24th of 2024. On April 22nd of 2024, Judge Williams took it upon herself to call the Shoemaker law firm. And she left a message with a receptionist where she indicated, I would like to speak to Bonnie Stinson, Bonnie being the associate, brand new lawyer on the case. And here is my personal cell phone number. Have her call me after hours because I'm in a jury trial. So that message gets to the brand new associate, and of course she freaks out, and this is what you're going to hear. She went to Ms. Shoemaker and said, do you know what this is about? There was no indication what case it was about. Do you know what this is about? Neither one of them could come up with anything other than the fact that Ms. Shoemaker at the time did have a case pending in front of Judge Williams, and they thought maybe Judge Williams had had a lot of turnover on her staff. Maybe she's calling about a job. Who knows? But the judge called you, call her back. So the associate calls her back. They speak after hours, an extended phone conversation, 40 to 45 minutes, where Judge Williams begins the conversation by saying to Ms. Stinson, hey, it's Judge Williams, but I want you to know I'm not calling as a judge. I'm not calling in my judge capacity. I'm calling for my uncle, who is a respondent in a petition for contempt that you all have filed recently. Anyway, I'm calling on behalf of him. We've had some deaths in the family. He's having a really hard time. And can you please give him 60, 90-day extension to submit his answer? And Ms. Stinson explained to her, I don't have the authority to do that. This is my partner's case. Any request like that would need to go to Ms. Shoemaker, and then we would have to talk to our client. I don't have the authority to do that, but she asked for the extension, and then she proceeded to tell Ms. Stinson what was wrong with their petition for contempt. It was related to military benefits. I understand that's a complex area of the law Ms. Shoemaker specializes in, but Judge Williams wanted to let Ms. Stinson know why their petition was problematic. And so she proceeded to argue the merits of the petition to this associate that she has called up at this law firm. And, the associate tells her, listen, I'm not an expert in this area. Again, this is Ms. Shoemaker. She'll need to respond to this. And then at some point, she asked Judge, do you represent your uncle? Do you represent your uncle? Because that's what it was like, talking to opposing counsel and debating the merits of something that they had filed. Judge Williams says, no, she didn't, and they conclude the call, and Ms. Stinson reiterates any request for extension needs to come to us from him in writing. That comes 2 days later on the day that the answer is due, and they agree to the extension once he asked. And the matter moved along. Ultimately, Judge Farmer presided over a hearing on that where Judge Williams' uncle did not appear, and the matter was concluded. As a result of what happened, which Ms. Stinson immediately reported to Ms. Shoemaker thought it was best to remove Ms. Stinson from any further involvement in the case. She didn't want what Judge Williams had done to negatively impact the case at all. And so the associate was removed from the case, and I believe that you'll hear, and I'm sure there will be questioning about the time frame within which that information ultimately made it to the JQC, and what I expect you will hear is that there was interest in seeing that that case was concluded before Judge Williams' colleague who was pending in front of at the time. To conclude, at the end of this hearing, in closing arguments, I will be going over all of the constitutional grounds for discipline. I have them up here. There are 5 of them, and I believe the evidence will show that Judge Williams' conduct, the violations that are contained in the code, constitute willful misconduct in office, willful and persistent failure to perform the duties of office, and conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. And again, I expect the evidence will prove the charges as we have alleged them, and that those charges, again, will give this panel one of those 3 grounds for discipline when it is forming its decision. Thank you.
All right, thank you. Opening on behalf of the respondent, Ms. McFadden.
Thank you. Thank you. Good morning, members of the hearing panel.
Morning.
My name is Jamala McFadden, and before I get started with the opening on behalf of Judge Williams, I just wanted to make a few comments. One is I didn't want to interrupt the director, but if I did, I would have objected. I would have objected several times to issues that were raised that had nothing to do with the formal complaints against Judge Williams as alleged in the charge, including, for example, this issue about father's rights and comments surrounding that. That has nothing to do with the issue of the ex parte communications, and it was inappropriate to raise in opening statements. Secondly, I want to ask that the panel reconsider its decision on the motion in limine. One, it's untimely because Your Honor had ordered the motions in limine to be filed by May 5th per the scheduling order. 2, we take the position that the director has opened the door to some of the issues that are subject to our motion to quash. Namely, the director started with principles of fundamental fairness and how it is important for the public to respect the judiciary and to not question the integrity of the judiciary and, by extension, its institutions. That is the fundamental principle that we raised in the motion to quash. So we'd argue that the door to those issues have been opened. Third, we just saw in the director's last slide alleged charges against Judge Williams that we'd never seen before in the almost 3 years, 2 years since this investigation has been going on, excuse me, and are not included in the formal charges, including this, I tried to scribble it down quickly, conviction of a crime involving moral turpitude. Judge Williams has never seen that before right now. Habitual intemperance, that's not part of the formal charges. So we're not sure what the director intends to do on those issues in the course of this hearing, but it is improper and we just wanted to raise it at this time. Okay.
I thought I understood that just to be the enumeration of the grounds for which any judge could be removed, but not necessarily that she met all 5 of those. That I think you said y'all's allegation was she only met 2 or 3 of them. I think, right?
What I indicated was that our evidence would demonstrate those violations of the code constituted discipline under one of those constitutional bases
One
for
of the
discipline,
five,
right?
right.
Those are not standalone charges.
That's how I understood it as well.
I just want to make it clear
Right.
for the record to the extent that there's any confusion about
Sure,
that.
yes, and just so our record's clear as well, I note your oral motion for reconsideration, and it is denied, so we'll just move forward as previously instructed.
As I mentioned, I'm Jamala McFadden, and I'm here with lead counsel Gabe Banks, and it is our honor to represent Judge Shermela Williams in this vitally important matter. Judge Williams was elected by the people of Fulton County on June 9th, 2020, in a history-making election. She ran a hotly contested race against Rebecca Reeder, an incumbent who was a gubernatorial appointee. Judge Reeder had served on the bench for 2 years before Judge Williams dared to challenge her. Not since 1996 had anyone beat an incumbent on the Fulton County Superior Court bench, though many had tried. It's a rare feat. But Judge Williams did it. Judge Williams and her team and the citizens of Fulton County did it. Over 200,000 people voted in her specific race, more than any other local race on the ballot. She won by more than 10,000 votes. The people of Fulton County spoke resoundingly in putting Judge Williams on the bench. The people's choice, it matters. The people who voted for Judge Williams certainly celebrated her win. Judge Williams was born and raised in Atlanta, Georgia, and is a product of Fulton County, the very people she serves. And when she took the bench, she was 38 years old. She had had a distinguished career both in civil and criminal law, as well as a demonstrated track record of service to the community. While some people celebrated Judge Williams' win, others were extremely upset that she won. Now, you might not think that any of that matters here today. You might not think that this goes to the fundamental issues in the case, but it does. Context matters. Those people who were upset about Judge Williams' win, they believed, and they said publicly, and they said to Judge Williams, that Judge Reeder's seat was stolen. They weren't happy that she was there. Those unhappy folks included judges and members of the closely knit family law bar that you'll hear from during the course of this trial. Former Judge Reeder was and still is a prominent, respected member of the family law bar. Before the upset, Judge Reeder served in the Fulton County Superior Court's Family Division, and that's where Judge Williams began her tenure on the court as a brand new judge. Almost immediately upon taking the bench on January 1st, 2021, Judge Williams was subject to intense scrutiny. Really, she was under attack since day one. Judge Williams drew her first JQC complaint in early 2022, and they've piled on since then. The complaints against her, some of which were even solicited by the family law bar, were not secret. They weren't secret because the lawyers told folks about it. The fact that she was under JQC investigation wasn't secret. The media picked it all up. Even still, the people spoke again. The people elected Judge Williams again, despite these allegations against her, despite the complaints against her. On May 21st, 2024, the people re-elected Judge Williams. The people's choice, the people's voice, their voice matters in our system of justice. And that's really at the heart of why we're here today. The JQC investigative panel and the people who were upset that their candidate lost an election should not be allowed to trump the people's voice. In pursuing these charges, the investigative panel wants to ignore, sidestep, mute the voice of the people and remove Judge Williams from the bench. But the JQC's job is not to supersede the will of the people. Removal is the most extreme remedy available. And I'm not saying that just because Judge Williams was elected by the people, she should be immune from potential removal. That's not it at all. It might be appropriate in certain situations, even for elected judges, but not here, not in this case, not on these facts. In this case, you won't hear that Judge Williams committed any crimes. physically assaulted people, engaged in corruption or scandal, or stole people's money. You will hear none of that. And by the way, other judges have done all of the above and have not been removed from office. Instead, in this case, you will hear about a judge new to the bench who was trying to figure it all out and made missteps along the way. But missteps are not misconduct. Missteps don't justify removal. Removal is reserved for those who demonstrate a fundamental unfitness to serve. And that's not the situation before you. Judge Williams does not fit into that category. Removal is also inappropriate here for the reasons that we've outlined in our motion to quash that we won't go into. But during this trial, you will certainly hear about things Judge Williams could have and should have done differently. She will admit that. She is accountable for her actions. She understands that the charges before you are serious. And as a consequence of her actions, she understands that you might decide that discipline is warranted, but removal is not. The charges against Judge Williams focus on 4 issues that I will discuss in turn briefly in a moment. As you listen, and more importantly, as you listen to the evidence over the course of this trial, we ask you to consider the context. Context matters. We ask that you consider Judge Williams' intent. It matters too. We also ask that you pit the evidence on each issue against the question of removal. Is it really enough to disregard the will of the people and remove Judge Williams from office? Now, the first issue. The commission has charged Judge Williams with issuing delayed rulings in a total of 15 cases. Judge Williams admits that her rulings were delayed in those cases, and she neither disputes nor minimizes the impact that delayed rulings have had on the parties involved. Timely orders, timely justice, it matters, and Judge Williams acknowledges her responsibility to deliver on that. But we ask you to consider those 15 cases in the broader context of Judge Williams' work. When she took the bench in 2021, she inherited a caseload exceeding 636 cases, which meant that she had more cases than any other judge in the family division at this time. And the document that I put up here before you shows the monthly stats for judges in the family division. There were 4 judges in the family division of the Fulton County Superior Court. And this shows the monthly stats from January 2021, which is when Judge Williams took the bench. It shows that she had 636 cases assigned to her, more than any other judge. Some of those cases that were assigned to Judge Williams dated back several years before she even took the bench. The evidence will show that during her time in the family division, Judge Williams received not less than 90 new cases each month and disposed of more than 100 cases per month on average. So the 15 cases at issue here, they account for less than 3% of her total monthly caseload. Despite a backlog and during a time period when courts were overwhelmed by the effects of the COVID-19 pandemic, Judge Williams resolved over 1,200 cases annually. In fact, she disposed of more cases than any other judge in the family division during her time in that division. She's not in that division anymore. Through hard work and dedication upon the completion of her term in the family division and her transition into the general jurisdiction docket, Judge Williams had the second lowest caseload. This is the December 2024 caseload summary report, which shows Judge Williams' case count at 548. Judge Williams had that second lowest caseload in the family division. This is not a judge. Judge Williams is not a judge who neglected her duties, was absent, didn't want to work hard. Quite the opposite is true. And you will hear from members of the family law bar during the course of this trial that Judge Williams isn't the only judge who issued orders more than 90 days after a hearing on a motion after a hearing on a motion was filed. You'll hear that judge, that's not unique to Judge Williams. Any judge under the sound of my voice will know that that's not unique to Judge Williams. Through the evidence, we'll show that these delays you'll hear about were not the result of neglect, nor are they indicative of willful misconduct. These delays reflect the practical realities faced by a conscientious new judge tackling an immense volume of deeply personal and complex family law issues. She didn't just rubber stamp any orders that she received. Judge Williams worked tirelessly to resolve the cases with compassion, professionalism, and diligence, always guided by her goal to provide families with thoughtful and fair resolutions. The delays you will hear about are attributable to structural and operational challenges, including serious personnel issues that have since been corrected. You'll also learn that at some point during the time period of these delayed orders, Judge Williams' mother and number one supporter was diagnosed with cancer and subsequently passed away, and her grandmother died 5 months later. And Judge Williams was her primary caretaker during that time. Having said all of that, those are not excuses, but that's the context. Judge Williams understands that she is ultimately responsible for the movement of her docket and the impact that the delayed rulings have on litigants. You will hear her accept responsibility for that in a genuine way. The second issue, Judge Williams is accused of engaging in an improper communication involving Brandy Alexander. These claims are more nuanced than they might first appear. Judge Williams knew Miss Alexander. She knew her because Miss Alexander served as a guardian ad litem on several cases assigned to Judge Williams. So when Judge Williams received a vague message with Miss Alexander's name on it, she called her back. At that time, Judge Williams did not know that Miss Alexander had a personal case pending before her, or that it was her lawyer and not Miss Alexander herself who had called about the case. During their call, the judge and Miss Alexander discussed the procedural issue having to do with transferring a case to a senior judge. And that's important. The conversation was about a procedural issue, not substantive matters affecting the case facts or rulings, and Miss Alexander even admits to that. As the evidence will show, there was never a discussion about the facts of the case or Judge Williams showing favor to Miss Alexander because they are members of the same sorority or any other made-up reason. When Judge Williams became aware that Miss Alexander was a litigant in the case and not the guardian ad litem, she acted immediately to address her incidental ex parte phone call. She immediately instructed her then staff attorney, Janelle Bowles, to notify all parties involved. You will hear that you'll hear from Ms. Bowles, and you'll hear that she didn't do what Judge Williams asked her to do, unfortunately. She didn't instruct her to alert the parties of the conversation and the content, and she didn't tell the judge that she had not done so. Another important point about Ms. Bowles, she will tell you that even though her initials appear in the formal charges in the complaint, and even though the director mentioned her name several times in her opening, nobody reached out to Ms. Bowles to ask her whether the allegations or the comments attributed to her in the formal charges were even true. Nobody from the JQC investigative panel or staff reached out to Ms. Bowles until a week before this hearing. The third issue. The commission asserts that Judge Williams improperly detained the adult daughter of litigating parents in a contested, high-conflict divorce case. You'll hear that the 22-year-old had admitted on the stand to engaging in multiple felonies, including burglary, theft, and criminal damage to property. You will also hear that at numerous times during the hearing, Judge Williams admonished the mother and daughter about their inappropriate courtroom behavior and conduct. After the close of evidence, Judge Williams seized the opportunity to impart a teachable moment aimed not at punishment, but at accountability and personal growth. By exposing the young woman to the potential consequences of her action, Judge Williams sought to underscore the gravity of her choices and encourage her to move forward more responsibly. Judge Williams' actions reflect her compassion, her commitment to mentorship, and her deep sense of her responsibility to guide and protect young people teetering on the edge of harmful behavior and potentially making life-altering decisions. You will hear from the young woman's father, who supports and appreciates Judge Williams' efforts with respect to his daughter, even though he didn't appreciate all of Judge Williams' rulings in the case. You will hear from a lawyer who was there in the courtroom at the time. He believed the young woman who had behaved in a contemptuous manner. Judge Williams was well-intentioned, but she will even tell you now that though well-intentioned, in hindsight, she would have handled the matter differently. She would not have done what she did. And even still, the facts don't support removal. The fourth issue. Members of the panel, the charge that Judge Williams engaged in judicial misconduct by making a telephone call related to her uncle's legal matters fails to consider the complete context and lacks critical nuance required in evaluating her intent. The evidence will show that Judge Williams acted as a concerned family member during a time of immense personal grief, following the loss of her uncle and her mother over a period of just 5 months. In fact, her grandmother died just 3 days after Judge Williams placed the call to the lawyer's office. Just days before the call, Judge Williams, who was her grandmother's power of attorney and primary caregiver after her mother died, received a call from her grandmother's medical team that she likely would not make it through the night. Judge Williams immediately left work and rushed to her grandmother's side and stayed there until the following Monday, when she was set to start a jury trial. While she was by her grandmother's side with other family in the house, Judge Williams was given the contempt petition against her uncle. She had a lapse of judgment at the moment. She called the attorney on the pleading about an extension of time for her grieving uncle. Importantly, the nature of Judge Williams' communication with the lawyer did not compromise the integrity of the proceedings that were the basis of the call. It was not an attempt to exploit her judicial position for gain, and it was not an intent to influence the case's outcome. Judge Williams acknowledges and will tell you that in hindsight, she absolutely would not have made that call and will not do anything remotely similar in the future. So against the backdrop of the JQC's charges on these 4 issues, you'll hear testimony about Judge Williams' empathy and dedication during particularly hard moments in people's lives. You'll hear witnesses speak to the integrity she's shown in her decisions, the meticulous care with which she has approached and handled each case, and the impartiality she has exercised as a judge, even in particularly challenging circumstances. And you will also hear that Judge Williams has taken these JQC charges to heart. She's made changes in and out of court. She has new staff who help her move cases along and new systems that help her do things more efficiently. She sought mentorship and guidance from more experienced judges. And unfortunately, she doesn't engage as much with lawyers and has declined requests by young lawyers to mentor them, which is a true loss for our legal community. She's done so in an attempt to ensure that there is not even the appearance of a violation of the judicial canons. You'll hear about her continued commitment to the citizens of Fulton County and unwavering work in the community. As I conclude, I'll say this. The charges brought against Judge Williams failed to account for the actual circumstances surrounding her actions. Through the evidence presented during this trial, we intend to provide clarity, context, and the true nature of Judge Williams' actions and intent, because context matters. By the end of these proceedings, we are confident you will see these charges for what they are, an exaggerated interpretation of fallible human judgment in an extraordinarily difficult role where she faced political retaliation, unfortunately. The Code of Judicial Conduct does not demand perfect judges, and as the U.S. Supreme Court has acknowledged, all judges make mistakes. Judge Williams is no exception. She has learned and has indeed grown from her mistakes. Judge Williams is not a derelict judge with no regard for the people that she serves, the lawyers or litigants who come before her. Despite the allegations in the formal charges, the truth is Judge Williams is a dedicated public servant and a respected and beloved sitting judge, known for her heart for the people, knowledge of the law, and personalized common sense approach to cases. She has carried out her judicial responsibilities with integrity, diligence, and an unwavering commitment to the pursuit of justice. Judge Williams' mistakes and missteps do not amount to willful misconduct, not a willful and persistent failure to perform, not conduct prejudicial to the administration of justice, and certainly not grounds for removal. Judge Williams deserves to stay where the voters of Fulton County put her, on the Fulton County Superior Court bench. Thank you for your time.
Thank you, Ms. McFadden. All right, if you'll call your first witness, please.
We have, before we begin with witnesses, the respondents' team has given me their printed out stipulations and admission to formal charges that I would like to go ahead and get into the record before we begin. And this document, I believe, Mr. Banks, you're going to prepare a new version of this document, but we're going to submit this at this time and have it on the record. So Judge Williams admits the conducts described in counts 8, 9.
First set of charges or second set of charges?
The first set of charges.
Okay, start over.
Counts 8, 9, 11, 12, 13, 14, 15, 16, and 17. And with that, she admits the allegations contained in the formal charges in paragraphs 48 through 51, 58 through 62, 63 through 70, 71 through 78, 79 through 86, 87 through 81, and 92 through 100.
Those first set of paragraphs, just to be clear, are 48 to 57. My 7 may look like a 1.
Okay. And I think you also said 87 to 81, but I assume that was 91. Just want to make sure the document's right. Is that right?
87 to 91.
Okay, got it.
And then in the second set of formal charges, the 25 set, she admits the conduct in counts 7, 8, and 9. And 11 through 15, as well as the facts alleged in paragraphs 25 through 32, 36 through 41, 42 through 49, 50 through 54, 55 through 58, 59 through 62, and 63 through 65. Also related to the 25 set of charges, I am withdrawing count 6 as it is duplicative of a count in the 24 charges, and the corresponding paragraphs in the 25 charges are 28 through 31.
That it?
Yes, sir.
All right, thank you.
If I may, there's a little bit more to the stipulation. It doesn't go to the charges. And so on behalf of Judge Williams,
We'll just read into the record the language that accompanies the stipulations that you'll see.
Okay.
And that is, notwithstanding the foregoing, Judge Williams reserves the right to withdraw the above stipulations and admissions that you've just heard about, should the hearing panel grant her threshold and dispositive motion to quash formal charges, or in the alternative, her request for a stay of the proceedings and an evidentiary hearing, which is pending at the time of that these stipulations were entered into. Further, and notwithstanding the stipulations and admissions herein, and assuming the motion to quash is denied, Judge Williams reserves the right to present mitigating evidence on each of the admitted counts herein.
Okay, thank you.
So is it correct, we're proceeding only on the ones that you've identified where the judge admits, or we're proceeding on everything else? You've only dropped count 6, correct, in the second set?
That's correct.
Okay. So the stuff that she admits to, I'm assuming there's no agreement between the investigative panel and the respondent?
Those admissions.
Just deal with those and take evidence or hear explanations of the ones that she admits.
So those admissions only relate to the delayed rulings.
Okay,
So-
I haven't matched them up yet.
Okay.
All right, if you'll call your first witness.
This time, we call Judge Shermela Williams.
All right. You can swear your own witness. That's fine. Yes.
You have your right hand raised. Judge, do you swear or affirm the testimony you will give in the matter now pending before the Judicial Qualifications Commission's hearing panel will be the truth, the whole truth, and nothing but the truth to help you God? I do. All right, Judge, will you please spell your first and your last name for the record?
Yes, ma'am. Shermela, Shermela. Last name Williams, Williams.
Judge, I want to start off by discussing with you your background prior to taking the bench. What year were you barred?
You said barred?
Barred.
So I actually have been barred in 2 different places. So my very first year of being barred was in Pennsylvania. That was 2008, I believe. And as far as the state of Georgia, forgive me, I don't recall. I think it was 2011. I think it was 2011. I moved from Pennsylvania to my very first job was as a prosecutor at the Philadelphia District Attorney's Office. And then I worked in civil law at a law firm in West Virginia. I actually passed the bar right before I moved back to Georgia. And so I never did follow up with the process to get sworn in West Virginia. And then I moved back to Georgia, but because I was less than 5 years out, I couldn't waive in, and so I had to sit for the attorney's portion of the bar. So I moved back to Georgia, December of 2010, and was sworn, and took the February bar pass, and was subsequently sworn in, I think it was June or July of 2011.
Judge, you mentioned you were in civil practice before relocating to Georgia. What kind of civil practice?
So both plaintiffs and defense work. I am probably one of the few folks who have both plaintiffs and civil defense experience, and both of my times in civil have been at hybrid firms that did both. So in West Virginia, I worked at a firm called Bailey and Glasser. We actually, the firm was based in West Virginia, but both of the partners and the owners, rather, were Harvard graduates. So literally all of the work we did was outside of West Virginia, with the exception of one. I represented Shoney's Big Boy, akin to Atlanta, Ray's. That's the Schoenbaum family.
Once you passed the bar and were back here in Georgia, what was your first job here?
My very first job was the Fulton County District Attorney's Office.
How long were you there?
I'm sorry to interrupt, but just it's hard to hear if y'all aren't talking directly into the mics. The sound kind of drops. So if you can just be mindful of that, and you feel free to bend that.
Yes,
You know how
ma'am.
courtroom mics work.
Yes,
So
ma'am.
Just talk right into that mic.
How long were you at the Fulton County DA's office?
Approximately 3 years, and then I went to the DeKalb County District Attorney's Office while in Fulton. I was only in the complaint room for 2 weeks, and then I was in the trial division for probably about 6 months, and then I went to the Crimes Against Women and Children unit and finished out my career in Fulton DA's office in the homicide unit. At that time, I was the youngest person in homicide, and then I left and went to the DeKalb County DA's office. DeKalb County structure, of course, is different than Fulton, and so I was at DeKalb for approximately 3 years.
Who was the DA then?
Robert James. And DeKalb, I assume you meant.
Yes, ma'am.
Yes, sir, Robert James. And then, I'm assuming you're going to ask me what my next position was? I don't
Yes,
want to get
ma'am.
ahead, though. Pardon?
Yes, ma'am.
So my next position after the DeKalb County DA's office, and there I ultimately ended up in the Crimes Against Children unit. So that's where I finished out my career in the DeKalb DA's office. I then was presented with an opportunity to go back into civil law. And so I went to Thomas Kennedy Sampson and Tompkins, which is a hybrid firm here in the metro area. It is also the oldest minority-owned law firm in I believe the Southeast, but definitely in the state of Georgia. There I practice both plaintiffs and civil defense work.
All right, and it was from there you launched your bid to run as a Fulton County Superior Court judge, correct?
Yes, ma'am. I was born and raised in Atlanta. As I oftentimes say, I was grown here, not flown here. No offense to those who were flown here. And then, of course, my next thing is I jokingly say I'm a Crawford Long baby, not a Grady baby. Nothing wrong with Grady babies, but I'm a Crawford Long baby, a.k.a. Emory Midtown now.
When did you announce that you were going to run for a seat on the Fulton County Superior Court bench?
I declared October, it was mid-October. I want to say it was somewhere around maybe the 15th, 16th, 17th, somewhere in there. I declared October of 2019, and I actually qualified to run March 6th of 2020.
And as we've heard, you ran against an incumbent, and that was former Judge Rebecca Reeder, correct?
Yes, ma'am.
Okay. Did you know Judge Reeder?
No, ma'am. I had a case in front of her, but I did not know her personally or professionally beyond that.
Judge, I don't live in Fulton County, but your counsel in opening explained how contentious that race was.
It was.
Is that how you would characterize it?
Absolutely.
Okay. What can you tell me why it was contentious?
Well, one, of course, it is widely thought to be a cardinal sin to run against an incumbent or a sitting judge. So that was one of the first reasons. Literally, there were folks who told me I was committing career suicide by running against a sitting judge. As we all know, folks who have been on the judiciary, much of the campaign funds are funded by lawyers, right? And so because I was running against a sitting judge, there were several lawyers who were like, we support you and we think you'd be a great judge, but we are not touching that hot button. And so that was one issue. So I ran a very grassroots campaign. If you look at the ballot from that year, more folks voted in the Reeder Williams race than any other race on that local ballot. Now, to put that in context, that was the year that DA Fonnie Willis ran against then sitting DA Paul Howard. That was the year that current Sheriff Patrick Labatt ran against then sitting Sheriff Jackson. I can't remember Sheriff Jackson's first name. Ted Jackson. That was also the Ossoff year and the Warnock year. So that ballot had a lot going on in addition to the fact that it was 2020 and, of course, everything that was going on with COVID. So that was one thing. The other thing was, of course, people became very polarized because not only was I running against a sitting judge, which folks run against sitting judges, but Certainly, there was a lot of media attention on the race between Judge Reeder and I. It was covered in numerous papers, numerous newspapers. There were lots of community events that folks wanted to hold, especially because this was a contested race of that matter. Now, in addition to that, Judge Russell at the last minute decided that she was not going to seek re-election. So her race was also on the ballot, and I think there were 5 folks in that race. There were a lot of things that were done during that race that were not appropriate towards me. However, I refused to run a dirty campaign. I refused to run a dirty race. And so those folks would come and tell me things all the time. Like, for instance, one was that Judge Reeder was calling my supporters and my endorsers, my public endorsers, and asking them to withdraw their endorsement of me and endorse her. There were all kinds of things going on. Yes, it was very contested.
Did somebody say to you, or people say directly to you, that you had stolen Judge Reeder's seat?
Yes.
Who?
Who said it? Who told me that?
Mm-hmm.
Apparently, at the Family Law Institute, Kyla Lines got up and said that the voters of Fulton County got it wrong, that Judge Reeder was robbed and her seat was stolen.
So my question was, who said that to you? Were you there to hear it?
No.
Okay.
You said, did someone say it to me?
Yes.
And I was yes. So several folks came back, including the folks who came back and told me were folks who were present and there, because this happened during one of the FLI sessions wherein Judge Reeder was given a Lifetime Achievement Award by Kyla Lines. In addition to that, when I started on the bench, literally there were folks who were my colleagues who said, people aren't happy about how you got here, and said it to me directly.
Who said that?
I would prefer not to say, but if you want me to say, I can. But it's a current member of the judiciary.
I'd like to know.
It was Judge McBurney, who was also my assigned judicial mentor. Judge Brasher intimated that I won because I was black.
Hold on. He intimated? So is this something that was said to you?
Yes,
Okay. By Judge Brasher?
yes.
Okay.
He was talking about what people were saying. So this was a meeting that he and I were having. This was actually right before I officially took it. So this was after I won, but before I officially took the bench, and we were having a conversation about, this is before, let me not say it that way. Before you actually take the bench, you go in and do your orientation and things of that nature, computers, et cetera. And at the time, he was the chief judge. We were also talking about accountability courts. And so there was this discussion about how people were saying that I won because I was black. And I made the statement, well, there were other black candidates who did not win, so that can't be true. I worked my tail off, worked my butt off in that election, and frankly, I took issue with that. In addition to that, my very first day on the bench, and I'll never forget, I actually have a picture, my office was bare because my predecessor had given away all of the furniture in the office, which is not supposed to happen. And my fellow judges actually were the ones who took the furniture. So literally my very first day in office, I walked in, I didn't have a pen, I didn't have a chair, I didn't have any furniture. And so, of course, that was an issue.
Who took your furniture?
Judge Reeder gave it away to other judges
Uh-huh.
on the Superior Court bench, which is actually not part of Superior Court policy. The furniture is supposed to stay with the chambers. And so literally I had no furniture, not a chair, not a pen, nothing. They literally had to go find me a chair from down the hall in the surplus where somebody had kind of discarded a chair that was broken and all kinds of other stuff. So that was my very first day on the bench. My apologies. Yes, sir.
Sorry, Director Veal, while I find this interesting, can we get to the portion that relates to the charges?
I will.
Thank you.
When you took the bench in January of 2021, that was the Family Law Division, correct?
Yes.
Okay. And at that time, it was Judge Farmer, Newkirk, Glanville, and yourself.
Yes, ma'am. Judge Farmer and I actually came into the family division on the same day. So he and I, it was our first day together. And then Judge Newkirk and, not Judge Newkirk, excuse me. Did you say Newkirk? I thought it was Schwal. It was Schwal, not Newkirk.
Okay.
Schwal and Glanville were already in the division.
Okay. And that family division in Fulton County handles all the domestic cases that are filed in Fulton County, correct?
Yes.
Okay. And it has its own set of local rules, right?
Yes.
Okay.
And one thing, just to also be clear, I forgot to say this. Another reason it was contested is because there were actually judges who were calling, like, to my firm and who were calling other members of the bar, telling them to give me messages from Judge Schwal, Judge Reeder, et cetera. So that's another reason that it was highly contested. But go ahead.
I'm sorry. You're saying that judges were calling your law firm on behalf of
Judge Schwal
Reeder?
specifically called my firm at that point and had a conversation with one of the partners, telling that partner, I understand one of your lawyers is going to run against one of my colleagues. You might want to tell her to stand down. No, I was not privy to that conversation. However, that's what was delivered to me as the call from Judge Craig Schwal.
And what year would that have been, ma'am?
2020, before I qualified. It was either late 2019 or early. No, it had to be early 2020 before I qualified, because in 2019, I had not told my firm yet that I was going to run. I just filed a DOI.
Did it occur to you to file a complaint on any of these communications from judicial officers?
No, because they were not said directly to me. They were said to other folks who then came and told me.
Would that be a requirement to file a complaint, that it's directly to you?
I don't know, honestly, and at that time,
Okay.
like I said, I was trying to run a clean campaign.
I get it.
And even since then, on my last reelection, Judge Schwal it was told to me that Judge Schwal was calling folks, soliciting them to run against me. But again, because that I was not present for that call, I don't know anything about that call, this is just what was told to me. And they, that it is what it is.
Okay. Well, you didn't stand down, correct? In 2020, you ran and won.
2020, correct, yes,
Mhm.
ma'am.
And nobody ran against you most recently in 2024, correct?
Correct.
All right, I want to start by talking about complaint 22102, which relates to the Carey versus Alexander matter.
Can you tell us the paragraph in the complaint on that, please?
Yes, sir. It is in the 2024 charges. And it begins on page 2 at paragraph 2.
Thank you.
All right, Judge, so let me direct you, September 14th of 2021, a petition for modification of parenting time and contempt was filed in the Superior Court of Fulton County by Mr. Carey, and Miss Brandy Alexander was the respondent in that matter. Is that correct?
Yes, ma'am.
Okay. The way petitions such as Mr. Carey's are assigned is that they are filed with the clerk of Fulton County Superior Court, and they are randomly assigned to one of the 4 family division judges at that time, right?
Yes and no. Would you like for me to explain?
Sure.
So Fulton has the one family, one judge rule, even though the judges rotate in and out of the family division. So we serve 2-year terms in the family division. At the end of your 2-year term, you have the opportunity to extend for another 2 years. You may not serve more than 4 years in the family division pursuant to our rules. So the reason I said yes and no is because certainly though the judges rotate in and out, the divisions stay the same. So FAM 1, FAM 2, FAM 3, and FAM 4. And in this response, I'm specifically talking about the domestic relations side, as we call it. The family division actually has two sides. The domestic relations sides, the vital record sides, and TPOs are on the other side. As the chief, at one point I was the chief judge of the family division, and so I oversaw both sides. But at all times during my time in the family division, I was the judge assigned to FAM 3. So the reason I give that distinction and that background is because if a case previously was assigned to FAM 3, that case automatically goes back to FAM 3, even if the original judge was Judge Bensonetta Tipton Lane, who's been off the bench for 10 plus years. However, if it is a new case, then it is randomly assigned on the will, and it just goes to whoever's next on the will.
Okay, so absent that circumstance, you said it's randomly assigned. Was Ms. Alexander's petition randomly assigned to you?
I don't know the answer to that question because,
Was Ms. Alexander's petition assigned to you?
yes, it
Okay.
was.
All right, and at the time that it was assigned to you, Ms. Alexander had a handful of cases before you where either you had appointed her and selected her as the guardian ad litem, or the attorneys had identified her and asked you to select her as the guardian ad litem, correct?
Yes, ma'am.
Okay. When did you first meet Ms. Alexander?
January of 2021, when I took the bench. She contacted my chambers and asked to meet with me because she wanted to introduce herself as a Gaul, and she wanted to talk to me about getting some Gaul work. There were several other folks who did that, so I was new to the family division.
Getting what kind of work?
Gaul, guardian ad litem, my apologies.
Yeah.
So when you hear me say Gaul, I'm referring to guardian ad litem, I apologize. And so that, from what I understood, was a common practice that when a new judge came in, Gauls would contact the chambers and ask to talk to the judge to see if they could get appointed on cases.
Okay, and Ms. Alexander did that, correct?
Yes, ma'am. And I met with her via Zoom in January of it was February of 2021. She contacted in January. We met on Zoom February 2021.
Okay, and you guys had a pleasant conversation, correct?
Yes, ma'am.
Okay. It was identified during that time that the two of you are members of the same sorority.
Yes, ma'am.
And what is that sorority?
Delta Sigma Theta Sorority Incorporated. I believe she had on a Delta garment, if I'm not mistaken. I think that's how it came up.
Did she ever give you a campaign contribution?
No, sir.
All right, at this time, Judge, I'm going to show you one of the exhibits that's on our joint exhibit list, and I have prepared for the panel as instructed hard copies of all of our exhibits on that joint list, and they're right over here.
Thank you. I assume you heard that.
Are these the same documents you're going to put on the
Yes, sir.
Google here? Okay.
That's yours. All right, Judge Williams, what I have pulled up is Exhibit J1, and so from what I understand, once a petition is filed, the clerk's office generates this initial hearing notice, such as the one in J1 that I've got pulled up. Is that correct?
You agree with me?
Mm-hmm.
In these types of cases, if it is a post-family judgment matter, the clerk's office does not generate a 30-day notice. But in all other cases, yes. All other cases on the domestic relations side. And let me qualify that all of my answers, unless otherwise, are only regarding the domestic relations side.
Okay, so who generated this notice?
The clerk's office, that's why I said in these types of cases.
Okay.
Yes, ma'am.
Okay, good. And so this hearing, the 30-day, the 30-day status was set for October 28th, 2021 at 2 o'clock via Zoom, correct?
According to this notice, yes, ma'am.
Okay. Do you have some reason to dispute what's in this notice?
No, I said according to this notice because I did not set it or see it, so.
Okay.
So the judicial officer you mentioned, that's not a real judge, is it? It's some lawyer that comes in that y'all hire to help you?
You're trying to get me in trouble with them?
No?
They
I
would,
just
they
don't know
would,
what they are.
the judicial officers, their official title is judicial officers. They are not sworn, constitutionally sworn judges. However, they do sit in designation for us only in the family division, though.
But they're not elected by anybody?
No,
or
sir.
appointed by the governor?
Correct. And in fact, litigants can file what's called a Rule 1004, which will take it away from the judicial officer and automatically put it in front of the electorate.
Gotcha, thanks.
I want to talk to you about that. So the local rules I referenced earlier that pertain to Fulton County's family division, they set forth the duties of judicial officers, correct?
In part, yes.
Okay. Are you familiar enough with those rules in order to be able to answer these questions?
I will try my best, and
Okay.
if I don't recall, I'll tell you, or if I don't know, I'll tell you.
Okay. Rule 1000-4 sets forth the duties, and you'd agree with me that one of the duties of judicial officers in Fulton County is to preside over status conferences in this kind of case, correct?
It can be. I don't remember what the specific wording is, but yes, they do preside over the status conferences. Generally, they preside over 30-day, 60-day status conferences, and they also, depending on the division, some judges have them provide over pro se hearings, as well as motions, etc. But I don't recall specifically, as I sit here now, what the rule says that is a definite for them versus at the discretion of the judge.
Okay, so would it help refresh your recollection to review a copy of those rules?
1004, yes, ma'am.
May I approach?
You may.
All right, and I direct you to 1004.1A, if you could please read that for us.
Okay. Did you want me to? A, just A, you said?
Yeah.
Okay.
Could you read it?
Oh, I apologize. I didn't hear you say you read it. 1000-4.1, the judicial officer shall have the responsibility of ruling and presiding over the following matters, issues. A, status conferences.
And so in this kind of matter, a petition for modification of parenting time and contempt, the 30-day status was set for October 28th of 2021, and that would have been heard by a judicial officer, correct?
Yes.
Okay. I know you mentioned earlier in reference to Mr. Hyde's question that the parties can file what I believe you all refer to as a 1004 request.
Well, no, it's just a 1004. It's not a request. Once they file it, as long as it's timely filed, we have to honor it.
Okay, so but the 1004 is a request that has to be filed, and that request is we want the assigned judge to hear all the matters related to our case, correct?
Correct.
Okay.
Well, not
How
all the
often do those get filed?
Honestly, it depends on the judge. In my division, they got filed a lot. There were some lawyers who that was their course in practice, that if it got assigned to FAM 3, automatically go on and file the 1004. There are some divisions where, the bar may not particularly care to go in front of that judge, and so they don't file them. So it just depends on the division.
In the Carrie Alexander matter, a 1004 was not filed, correct?
My recollection is that 1004 was filed at some point. Even if you look at the transcript, I referenced that someone filed a 1004. Now, did I see the 1004? No. Normally what happens is my staff, they will tell me or they'll put on my calendar that a 1004 was filed.
Okay. Did you review that case and the documents related to it in preparation for this hearing?
Yes.
Okay. And a 1004 was never filed, correct?
I don't know. I did not look through the entirety of the docket.
When they
There was no, so I'm sorry to interrupt. Normally, we'll see a flag that says 1004. I just look for a flag. I don't know what happened after it got transferred. All I can tell you is that someone told me a 1004 was filed, which is why I referenced it in the transcript, that at some point somebody filed a 1004.
Do you get informed as to which side is asking for a real judge to handle the matter, or do you just know somebody's asked?
If I look at the notice, then I know who it is, but otherwise, I generally don't look at the notices. I don't ever check them. Literally, my staff, when they're preparing the calendar, they'll just put on their 1004, or they'll tell me a 1004 was filed.
Thank you.
Okay, and so you said in what you reviewed, you did not see a 1004, correct?
Correct.
But you said you did not look all the way through the docket, correct?
Correct.
But when 1004s are filed, they're filed with the clerk and they become part of the docket.
They're supposed to be, yes.
All right, I want to direct your attention to October 18th of 2021.
Okay.
On that day, did you have court on that day?
Yes, I started a trial.
Okay. During a break in your trial, you came into chambers and you were notified that somebody had made a call to your chambers, and your staff was rather confused by the inquiry, correct?
In a nutshell, yes.
Okay.
Who is attorney KF?
Catherine Franklin.
Okay. And then who is JB?
Janelle Bowles.
Okay.
Okay, so when you come off the bench that day into your chambers, who was the first person you encountered?
My then litigation manager, Will Williams. I literally just barely crossed the threshold, and he came up to me, and this was in the center area before you get to any of the offices, and he said, "Judge, we got this message. What am I supposed to do with this?" And he puts a Post-it note in my hand. That's what I was demonstrating when I threw my hand up. Not my hand, I'm sorry, my face.
Okay, what did the Post-it note say?
Brandy Alexander, senior judge. Didn't have a case number, didn't have a case style. That's all it said. And it was a yellow Post-it note. And that's all that was written on there.
Okay, and you said this happened right when you got into your chambers.
Yes, ma'am.
Okay. Is the way that your chambers is structured, most of them are, when you walk in, there's like a lobby area, there's a desk, somebody sits there at the front, and then your actual office is off to one side or another?
Yes, ma'am.
Okay. And so did this occur like right in that general lobby area?
Yes, ma'am. It was literally, I walked through the door. I didn't even make it 3 steps through the door before he came up to me and said that.
Okay. Was anyone else standing there at the time?
No.
Okay. What did you do after he handed you the Post-it note?
I asked him a question. I said, "Well, what is this?" He said, you have to know Will to know his vernacular. He said, "I don't know. The little girl at the desk gave it to me."
Who is the little girl at the desk?
He was referring to the floating JA, Soraya. That was her very first day in chambers. So essentially, I had just finished up a jury trial on October the 15th. That was the last day for my staff attorney and for my then staff attorney, who was Tangi Bush, and for my then JA, who was Tamika Black. Tamika, yes, sir.
For these initials y'all are using, on first reference, it would help me a whole lot if you would say what it is.
Yes, sir.
Because what JA is to you may not be to me.
Oh, I apologize.
So on first reference, I would appreciate the full title.
Yes, sir. You are.
Second reference, I don't care.
I've been there. You're right. JA is a judicial assistant.
Okay.
If you hear me say LM, it's litigation manager.
Because when you're talking about lawyers, JA can mean a lot of things.
Yes, sir. You're right. As far as the formal charges, the initials are JB, who's Janelle Bowles, KF, who's Catherine Franklin, BA, who's Brandy Alexander. I think I covered all the initials.
You did. Thank you.
Okay. So I just finished up a trial. My then judicial assistant, Tamika, she had accepted a job in Gwinnett County, and they needed her to start immediately, so she wasn't able to give me 2 weeks' notice or any more notice than a week. She got a job in Gwinnett, paying her $10,000 more. She lived in Gwinnett. I couldn't match her salary because of how our system is. Tangi had just had a baby, and she went home to be a stay-at-home mom for a little bit. Again, you have to also keep in context, this is COVID. And so literally when Tangi started, I didn't know she was pregnant, but when she told me she was pregnant, she then subsequently went out on maternity leave somewhere around March, April, and was out until about June or July, somewhere in there. So I was without a staff attorney during that period. She came back. When she came back, if you ask anybody, Tangi was never on screen. It's because she was sitting at home with the baby, but she was a hard worker. She did a fabulous job. She was a fabulous staff attorney, but it just got too much for her, caring for a very newborn baby, doing the demands of the staff attorney job, which is very demanding. And then she also had an 11-year-old son and a husband. So she came in September and told me she just needed to step away and take some time away. And so she gave me a month's notice, and she initially had planned on ending her service before the jury trial, but because we had a jury trial, she said that she would stay on until the 15th, so not to leave me in a lurch for that.
Okay, you just testified that Will, initials are not in that document. You said he was your litigation manager, and you testified that when you inquired about the message, he indicated that the little girl at the desk gave the message to him.
Yes, ma'am.
That the little girl at the desk was the one who had taken the message.
Well, he didn't. I don't know if he said taken. He said the little girl at the desk gave it to me. So I don't know who took the message, frankly. I know Ms. Bowles said she did not talk to Ms. Franklin. So the only other person would have been Soraya. I also note that that was Ms. Bowles' first day. I did not see her answer the phone at all that day. Like, she was trying to learn systems and all that other stuff. So I can't tell you any of that. All I know is he said the little girl at the desk gave him the note. And she wasn't sitting there. She had gone to the restroom or something like that. So I couldn't ask her directly if she took the message or anything like that.
Okay. All right. So you then call Miss Alexander, correct?
Yes, I thought that it was referencing a Gall case. At that time, I did not know that Miss Alexander even lived in Fulton County. I thought she lived in DeKalb County because based on our conversation.
Judge, I'm going to stop you there. My question was, you then called Miss Alexander, correct?
Yes.
Okay. And were you still standing right there in the lobby?
No, I had to go to the restroom.
Okay. So where were you when you called Miss Alexander?
Well, I started in my office, and then I was in the hallway. And then I went back into my office when I asked her for the case number and the style of the case and the attorney. I went back into my office to get a pen so I could write down everything that she was telling me.
Okay. And was anybody in your office for the portion of the conversation that occurred when you were in your office?
Nobody was in my office, but the door was open. The only part of the conversation that occurred in my office was the portion while I was asking her, because I literally walked back in there to get a pen. When I came out the restroom, I picked up the phone, I called her, I was going to the kitchen. And again, this was a restroom break in the trial, so it was not a long break. So I came out from the restroom and to orient. I think most judges' chambers are like this, but I don't want to take it for granted. I have a personal restroom in my actual office. So when I say I went into the restroom, that's where I went. Came out. I was going to the kitchen, which is in the hallway across from Janelle's then office. And so I was in the hallway going to the kitchen, and I was walking up and down as I was talking to Miss Alexander. Once I got that information, or asked for that information, I noticed I didn't have a pen. I reached in my pocket, my robe pocket, didn't have a pen. So I went back into my office, which is literally right next door to Janelle's office, got a pen, came out, and went right to Janelle's office.
Okay. You say you went to Janelle's office, so did you complete that phone call in Janelle's office?
No, ma'am. I'm saying after I wrote down the information Ms. Alexander gave me, which was the case number, the name of her attorney, and the style, the call terminated. I immediately came out of my office, went into Janelle's office. And the way they're set up is, so our offices, there's literally, I can see into her office from my office. So she's literally, as soon as you walk out my door, her door is immediately there to the left.
Okay. And so you're walking around, you go to the restroom, you come back out, you're in the kitchen, and in that time, you've written down the case number, the style of the case, and Miss Alexander's attorney.
No, ma'am. I come out of the restroom, I grab my phone. I call Miss Alexander. By the time the phone connects, I am now in the hallway.
Okay?
I walk into the kitchen, but then I came right back out. So I didn't even get anything. I'm walking up and down the hallway, and that's also sometimes how I just think and walk and talk. And so I was listening to her. I was explaining to her the process. When I asked her the case number, that's when I go back into my office to get a pen because I realized I didn't have one in my pocket. I then go back into my office, write down the information, which is the case number, name of her attorney, as well as the style of the case, terminate the call, come right back out. So I was in my office maybe 30 seconds, if that. I immediately go into Janelle's office. Janelle and Will were standing there. I handed them the Post-it. I said, please email the parties. Let them know I spoke to Ms. Alexander. Let them know that she has Gall cases pending before me. And to protect the integrity of those cases, I'm going to pull it from the JO track and handle it from beginning to end.
Okay. So during the call with Miss Alexander, what was the first thing you say to her?
Hello, or something of that nature, some kind of salutation.
Okay.
And then I said, I'm sorry?
All right, go ahead.
Oh, and then I said to her, we got a cryptic message in chambers, something about a senior judge. They didn't give me any more information. All they said is that somehow the case involves you. And then I said, do you know what case this is? Because my assumption was that she was the Gall on the case. Now, I think it's important that family cases also have a lot of pro se defendants. And Miss Alexander, because her prices were lower, she was also one that I would use on a lot of pro se cases. And so I didn't even think that she was a litigant. It didn't even occur to me that she was a litigant or in any way involved in the case other than as a Gall. She had never appeared before me as a lawyer on a case, only as a Gall.
Okay. When you let her know that you got a cryptic message in chambers and something about a senior judge, according to you, how did she respond?
I said, do you know what case this is? She paused and she said, it's me.
Okay. And what did that mean to you?
Well, my exact words were, what do you mean it's you? And she said, it's me. My ex is dragging me back into court, at which point I stopped her.
And then what happened?
Oh, so after I stopped her, I said, well, hold on, because at this point I know she's a litigant. And so I said, well, hold on. So I understand that whatever this is about as a senior judge, would you like for me to explain the process? And she said something to the effect before that of she wanted to see if the case could be put before a senior judge. She didn't tell me an attorney had called. She didn't say any of that to me. Now, I don't know if she said it to somebody else. If she talked to someone else, I don't know. So then I said to her, well, let me answer the question, because again, I was trying to get back off the bench. I was trying to get back on the bench. Hindsight being 20/20, there are a whole lot of things I would do differently. One, I would have had somebody else call her, but our rules allow for the judge to talk to the Gall. So I didn't know what was going on, and I had just spoken with Ms. Alexander.
Judge, so I'd like to be able to ask you questions and then you answer that question.
I think she was attempting to respond to what happened
Yeah, that's my
next.
fault.
But I will say this, and I realize everybody's got a lot to say, and I do think, to borrow a phrase from Ms. McFadden, context does matter sometimes, but we're sort of getting a little bit granular in details and maybe a little far off field. So to the extent that you can answer her question directly, and I realize you were answering a panel member's question, but to the extent that you can answer her question directly, if it's yes or no, please do that. If it bears explanation, certainly you have the right to explain. But you have very competent, excellent lawyers who I know will follow up with you on anything they feel you need to follow up on. So I don't want you to feel like you got to shove everything into one answer. So as much as we can, let's just try to answer the question asked. Y'all are stepping on each other a little, so please give each other a chance to ask, answer, and then ask. And I will be in charge of trying to
Good luck with that.
Yeah.
No
So,
worries.
Sorry, go ahead.
Candidly, I forgot what, that was preamble for what I needed to answer for you, Mr. Hyde. So my apologies, I forgot where I was going with that.
Go ahead.
Either right before you made the call or at the beginning of the call, did Ms. Bowles express any concern to you that a call to Ms. Alexander would be an ex parte communication?
No, ma'am, I did not talk to Ms. Bowles at any point prior to making the call.
Did you, at any point during the call, advise Ms. Alexander that it was okay for you all to have the conversation because it was on the shield?
No, ma'am.
Is that a phrase you use, or have you ever used that phrase?
On the shield refers to a term in the sorority, so the shield of the sorority.
Gotcha.
I've never used that term with Ms. Alexander. In fact, I've never even used that term with Ms. Bowles, who is also a member of the same sorority. Nor have I ever used that term with any lawyer who has appeared before me who was a member of the same sorority, or otherwise, or a witness, or anybody.
What does that term mean?
On the shield? I'm trying to figure out a way to answer that without divulging sorority information. I guess on the bond of our oath, I guess that would be a good way to put it.
Did you at any point during the call with Miss Alexander reference the fact that you two were sorority sisters?
No, ma'am. And in fact, I'd had several conversations with Miss Alexander. Other than that first one, there was nothing for me to reference. It never came up. People who know me will tell you, a lot of people don't even know I'm a Delta. I'm not the person who walks around, so to speak, with it on my sleeve.
Did you ask Miss Alexander why she wanted the case assigned to a senior judge?
Yes.
And what was her response?
That because she had cases pending, she was concerned about her reputation.
Did you attempt to alleviate her concerns?
I guess you could say that. I mean, that's why I told her that I would handle it on my track versus the JO track, JO being judicial officer track, because that's how the cases, when they come in, they get assigned to one track or the other, and then it switches over to the judge's track after a certain point.
Okay, and so that case at the time you had this phone call was on the JO track, correct?
Correct. All cases initially are on the JO track.
Okay. Miss Alexander did not ask you to handle the case instead of the JO, correct?
Correct, but I've done that in numerous instances where I thought it was appropriate for me to handle the case. For instance, I had a case where
I'm
there was
going
a
to
chance.
object at this
Okay.
point, Your Honor.
Yeah, so
My-
just pause there. I don't know that we need an explanation, so go ahead and pose your next question.
You're the one who made that offer. I will handle your case instead of the JO, correct?
Yes.
Okay. And as we talked about earlier, the normal procedure for parties who want the judge to handle the case instead of the JO is that they have to file the 1004, correct?
No. They can.
Okay, explain that to me.
You said have to. I said they can. There are instances where the judge can and does take it off. That's what I was trying to explain earlier. Take it off the JO track for various reasons. So like I had a transgender case where the child was trying to go through gender reassignment surgery. The staff identified that case because they know stuff that is sensitive, then I want to make sure it comes to me. In addition to that, my celebrity cases, all of those cases from the very beginning, when the staff identified that it was a celebrity case, those cases would automatically be assigned. My staff would flag them and automatically take them off the jail track and put them on my track.
Why is that?
Well, at this time, we also were doing COVID, Zoom, et cetera, and so you can't control who's recording, you can't control screenshots. In fact, around that time, we also had a case where when I was chief judge, there was someone who was, somebody's proceedings were being live streamed on the other side, and it was a TPO regarding molestation charges. And so someone had screen captured, I'm not good with the technology, my apologies. Someone had screen captured the hearing and it went viral. And so literally we were dealing with issues with that. So when I became chief judge of the family division, I said that they could not live stream hearings. I never live stream my hearings.
Okay, thank you.
But there is a Zoom hearing that it may be 50 people on that hearing. Or more.
Why is it that there is a procedure that is set forth in Fulton County Superior Court rules regarding the filing of a 1004 if the judge can just pick and choose what cases they want to handle?
I can't answer that question for you. Those rules have been in place since the 90s, and I don't know when 1004 was added, but that is a common practice.
Did Fulton County Superior Court use JOs in the 90s?
The initial folks assigned to the family court were JOs. Yes, they were not sitting judges. So Margaret Dorsey, Vita Good, there was a gentleman, I can't remember his name, but all of the folks who initially were assigned to the family division were all judicial officers, yes. Judge Bensonetta Tipton Lane, I think, was the first elected judge who was serving in there, and then there were all of these JOs, I think, who were under her, if I'm not mistaken. And Margaret Dorsey actually served up until my term, because she served for me too.
All right, there is a written procedure in place for Fulton County Family Division that litigants and lawyers must follow if they want to make a 1004 request, correct?
Yes.
Okay. Does this sound right? If a written request for the assigned family division superior court judge to preside over a case is not filed at least 5 business days prior to the scheduled hearing or at least 5 business days prior to the date a matter shall be right for a ruling or adjudication, the judicial officer shall have the authority to rule and preside over the following matters and issues, and then it sets out the issues that they can preside over when the request is not filed. Does that sound right for the rule?
Yes.
Okay. So in the general course, if somebody does not file a 1004, the JO hears their case,
No.
at least for the 30-day.
For the 30-day, yes. I don't want to go afoul of Judge Burleson's directive. For the 30-day, yes, in general, but not for all hearings.
Okay, that was a bad question. I was only asking about for the 30-day status
Okay,
conference.
then yes.
Okay. All right, but you made the decision in the absence of a request to that you were going to pull the case from the mass calendar and put it on an individual calendar, correct?
Yes, as I had done in other cases.
Okay, but I'm talking about this case, and the benefit of an individual calendar is that that would have been the only case on the calendar, and so those people would have been the only people that appeared at that hearing, correct?
You say that for me again?
The
That they would-
benefit to it being pulled from a mass calendar and going on an individual calendar is that that was the only case on that individual calendar, correct?
Yes, that's correct, yes.
Okay, so
The second part of your question is what tripped me up. Go ahead, I'm listening.
Okay, so with your mass calendars, the one that they should have been on, that would have included a whole lot of litigants, potentially guardians, other attorneys. That's why they're called mass calendars, correct?
Correct, and it's not just the 30-day cases. There also could have been cases on there that were 60-day or pro ses.
You also told her that you would not handle her case in open court, correct?
No,
No, that's not correct, or no, you wouldn't handle it in open court? In other words, no, you didn't tell her that, or you wouldn't handle it in open court?
no. What I was saying to her was that I would not have it on the jail track, and I would handle it on my track. I always do my hearings from court. I'm sitting in court. I never close the courtroom. So I don't. So that's what I said to her, that I would, and she was familiar with my procedure. So I said that I would handle it on my track.
Is it on the clerk's calendar though?
Say again? Yes, sir. All
Hearings.
notices are filed with the clerk. There is a Zoom link. Even if it's in front of me, there's a Zoom link that's on the notice. So again, open court is, the open access rules are satisfied. Everything is the regular way, I guess is the way to put it.
Okay, so again, and I believe you said no to this earlier, did you tell her that you would not handle her case in open court?
I don't know if I used those exact words. I just explained to you what my recollection of our conversation was. If I said I would not handle it in open court, I just explained to you what that meant. So I can't tell you the exact words that I used as I sit here right now, 3 years later. But if that was the case, then yes. Open court being those mass calendars. That's why I tried to explain to you what I was saying.
Okay, I gotcha. If I may interject, since you seem to have paused in thought, I know we've been going for a little while, and I did promise you guys we'd take a comfort break, and then we were probably at that point. So why don't we take about a 10-minute stretch break, comfort break? Obviously, the live feed will be discontinued at this time. Everybody feel free to step down and stretch, and I assume everybody knows where all the different facilities are. So, okay, so we will be in recess for 10 minutes.
I have a question. Bring my
Right. Judge Williams, during the call with Ms. Alexander, did you tell her that, or did you make any remark about your ex-husband and how he had treated you?
No, not during that call.
Okay. Did you make any remarks about your personal experiences with divorce?
I said that I was divorced and I've been through, I don't remember my exact words. I did say that I was divorced, so I understood family matters. But my divorce was an uncontested divorce, so.
Director, are you on a specific paragraph, or are you just, I'm trying to follow. I guess not, okay.
Because you have no money.
In the area of 12 and 13,
Okay, thanks.
Judge, you mentioned earlier that you had handled other cases in the way that, or other 30-day status conferences in the way that you decided to handle Ms. Alexander's, and that they were pulled from the JO by either yourself or your staff, and you decided to preside over them. And you mentioned one set of cases like that was celebrities, correct?
I don't know that I said 30-day. I thought I said pull cases from the JO track, and that my staff identified them either at or before the 30-day.
Okay, do you instruct your staff to look through the cases that are on certain calendars and identify ones that should come to you?
The standing policy, yes, for lack of a better term. That goes into how the cases are prepared, but yes, for lack of a better term.
Okay, and why are celebrity cases ones that you have identified that you want to handle?
Because that's a mass calendar. The same thing I said before, it's a mass calendar. You don't know who's on, who's recording, who's not recording, things of that nature. And so to protect the integrity of the process, they just automatically move them over to me.
Okay, and so on the individual calendars, you are able to ensure that nobody else is on the Zoom watching the proceeding, correct?
I know who's on the Zoom watching the proceedings. That would be a better way. So for instance, one case, TMZ had somebody in the mass calendar and recording, and we didn't know it until after the fact. So if it's an individual calendar, I know specifically who is on. So if there is an improper recording or anything like that, I can zero in as to who it is.
Okay. What are other cases that you have decided should be handled by you?
Cases where it's the topic is sensitive, like the transgender reassignment case that I told you about. Cases that involve security, so for instance, for some of our deputies, if they have some proceedings going on, so that they are not on mass calendars, because oftentimes, of course, they'll say the children's name, where the children live, where that deputy lives, or something like that. Stuff like that. I can't think of an exhaustive list as I sit here, but those types of cases that involve sensitive security or high profile, so to speak, information.
Isn't there a law that says a peace officer doesn't have to give their address in court anyway?
There is, however, oh, yes, sir. But sometimes, they'll say the kid's school name or the kid's name and stuff like that.
That certain cases are to be pulled and heard by you. Was that just a you policy, or is that uniform across the family division?
I don't know if it's uniform, but I do know that there are other judges who do that. That's actually where I got it from.
Who'd you get it from?
Some of the other judges. I think Glanville did it. I'm not sure. It might have been someone who was just orienting me to the family division.
All right, you testified earlier.
I think Farmer did it too, I'm not sure, but go ahead, I apologize.
Okay, and that's not anywhere in these local rules or any written policy. It sounds like you all just came up with that on your own, correct?
I can't say where it came from. I know that was imparted to me when I started as a new judge.
Okay. You testified earlier that when you concluded the call with Miss Alexander, you handed the sticky note with the information that she had provided to either Miss Bowles or Mr. Williamson, who were
Williams,
in
yes.
Williams, who were in her office, correct?
Yes, ma'am.
You don't remember which one?
I think it was Miss Bowles, but I can't say that for 100% sure. Will was standing over her. She was sitting at the desk in front of her computer. So I don't remember who reached out, but I think it was Miss Bowles.
Okay, and what instruction did you give to them at that time?
I said for them to email the parties, and when I say the parties, they know that I mean the lawyers, right? Because I use that term interchangeably. But to email the parties and let them know that I had spoken to Miss Alexander, that Miss Alexander is a gall before me. She has pending cases. And so to protect the integrity of those cases, I was moving the case from the JO track to my track. And I also gave them instruction to reschedule the October 28th date. I did not know the date at that time, so I said to reschedule whatever the 30-day date is and put it before me.
Okay, and did that contact with the parties ever occur to your knowledge?
I subsequently learned it did not, but I didn't learn that until after these JQC complaints were filed.
And to your knowledge, was the case pulled from that October 28th, 21 original calendar and put on another calendar?
Yes.
At what point did that happen?
What point was it pulled?
Yes, ma'am.
I don't know. I am testifying to you based on the email stream that I subsequently read after this JQC complaint was filed.
And is that the email string that shows that Ms. Franklin reached out to your chambers on October 28th of 2021 requesting the Zoom link for the hearing that was supposed to take place that day?
I don't recall which attorney started the thread, but yes, that was the substance of the email.
Okay. And then Ms. Connor responded and provided a copy of a motion that she had just filed, and then the link was sent to the parties, correct?
That's not the email I read. So I'd have to see what email you're talking about. The email I read was an email where it started with saying, what's the link for the Zoom? At which point Mr. Williams responds back and says, this case was pulled from the calendar. And then somebody responds back and says, why or something. I don't remember the exact words, but they asked why. At which point Mr. Williams responds back and says, you need to speak to the court's staff attorney, and has added Ms. Bowles to the email. That's the email I read. So if there's an email with the Zoom link, I don't know about that one.
Did you provide the email that you're describing right now to your counsel?
I did.
Okay. If I could have just one moment, Your Honor.
Sure.
Yeah. Is this the one you sent? All right. And do I need to ask permission to approach each time?
No, you've asked, and just be respectful of the witness, but otherwise, no.
Judge, you referenced an email string, and I want to make sure that we're talking about the same one. This is the one that I received from your attorney, and it's marked P2. Can you review that for me, please?
Yes, ma'am. Yes, ma'am, this is the one I'm talking about.
Okay. And so, and this is the one that you were just testifying about?
Yes, ma'am.
Okay. I'm going to go ahead and move, I know this is your exhibit, but I'm going to go ahead and move it now.
I assume no objection.
No objection.
Okay. It's in.
Okay. You had a chance to look at it when I showed it to you?
Yes, but are you going to ask me questions about it?
I am.
Ma'am?
I have extra copies.
Yes, ma'am.
Who initiated the contact with your chamber?
FFL paralegal. Huh? Oh,
And who's FFL paralegal?
I don't know. It says, the signature line says Heather Carlson, senior paralegal, Franklin Family Law. So I'm assuming from Ms. Franklin's law firm.
Okay, and I've got P2 up on the screen now, and so a paralegal from Ms. Franklin's law firm initiated that communication with your chambers Thursday, October 28th at 10:56 a.m.
Yes, ma'am.
Correct, okay. And they asked your office for the passcode for the Zoom hearing for that afternoon at 2 o'clock, correct?
Correct.
Okay. And then you said you didn't recall seeing the Zoom link in the email that you reviewed, but...
No, I said I thought you said there was a motion. That's what I was saying I didn't recall seeing.
Okay. But your office then provides the Zoom link on that same day?
Mr. Williams responds back with the Zoom link, yes.
Okay. And then the petitioner's attorney responds indicating, or I'm sorry, she responds right here, Ms. Connor, indicating that she's attached a copy of a motion that she filed the day prior, correct?
Mm-hmm. Yes, ma'am.
All right. And then I'm assuming this is what you were referencing earlier. This is where Mr. Williams informs the parties on October 28th at 1:04 p.m., which is an hour before that 30-day status was supposed to begin on October 28th. He then notifies them that your new staff attorney, according to her, all hearings on this case must be heard by you for that case, correct?
That's in just what it says, yes.
Okay. 1 hour before the hearing was supposed to begin.
According to this, yes, ma'am.
Okay. So it's fair to say that it had not been canceled or removed prior to the actual day of the hearing?
No.
Okay.
That's what I was trying to explain procedure earlier.
Okay.
So the way the JO calendar works is, yes, the clerk's office does the initial notice. You'll notice the initial notice does not have a Zoom link. So 1 to 2 weeks prior to the actual calendar, the staff pulls the calendar, all of the cases for that day and on the calendar. They then go in and file Zoom links notices with the Zoom link for every single cases on the calendar. So the hearing was canceled in Odyssey, which is why it didn't show up on the calendar for Mr. Williams to file the notice inclusive of the Zoom link.
Okay. It is clear from this series of emails that the attorneys, the parties, had no knowledge that the hearing had been canceled, correct?
It appears that way, but like I said, I didn't get this email until you notified me by letter on February 14th. I got this from Ms. Bowles on February 14th after I told everybody in the office check their emails, phone records, etc., because I didn't know anything about what you had alleged in the complaint. So that's when I found out about this.
You didn't know anything about what I had alleged in the complaint?
Say again? That's not what I just said.
You didn't know anything about what I had alleged in the complaint when you got the letter?
What I'm saying is, it referenced the fact that there was an ex parte that I did not disclose. And that there were certain issues with hearings, et cetera. So once I got your letter, and I don't have the letter in front of me, so I don't remember specifically what you said in your letter. But nonetheless, it did not include the complaint. Once I got your letter, I asked the staff to go in and pull any and everything they had related to this case, because there were some things in your letter that I was not aware of.
How are parties typically notified when something's pulled from a calendar in the manner in which this one should have been?
Either an email or, depending on the basis of which it was pulled, there may be an order, but oftentimes there's not an order canceling a hearing.
And there was not an order canceling a hearing in this case?
Correct.
Okay.
Or a new notice, I should have said that. So sometimes there'll be a new notice which supplants the previous notice.
Okay. The next proceeding that occurred in this case was a motions hearing that was set for December 14th of 2021. Is that correct?
It was a 30-day status and motions hearing, yes, ma'am.
Okay. Can I get my computer? All right, Judge, I'm showing you what is listed on our joint exhibit list as J2. And does this appear to be the subsequent notice, or the notice for the subsequent hearing that occurred in this case?
Can you scroll down to the bottom for me, please?
It's J2 in here.
Yes, ma'am. Oh, what's that last page? I apologize. I thought that was the last page. Oh, yes, Yes, ma'am. So at that time, to go back, it was Farmer Schwal, myself, and Glanville in the family division earlier when you asked me that.
All right, so you issued this subsequent notice on December 2nd of 21, and then the hearing took place December 14th of 21. Was that a virtual hearing?
Yes, ma'am. The Zoom link's in there, so. Oh, yes, and it says at the top, conducted via Zoom.
Okay. You testified earlier that you did not realize until later that your staff had failed to notify the parties of your conversation with Ms. Alexander and the reason that the case was pulled from the 30-day status conference, correct?
Yes, ma'am.
Okay. At what point did you realize they had failed to notify the parties?
When I got your JQC letter on February 14th, 2021. It was a bad Valentine's Day.
So, okay, so you didn't realize until you got my notification letter of February 14th, and I'm going to give you a copy of that in just a second.
I assume it's in here. Maybe not.
Mark this as P3. All right, Judge, I'm going to show you Exhibit P3, and we'll get the panel copies of this. Is that the letter that you referenced, the February 14th letter?
It appears to be, yes, ma'am. It appears to be, yes, ma'am. Yes,
Okay.
ma'am.
Okay. And so your testimony to the panel was that it was when you got this letter that you realized that your staff had not notified the parties.
I think your question was when I realized they had not notified them of the conversation with Brandy.
Of the conversation with Brandy
And
the fact
correct.
that the case was moved removed from the 30-day status because she was a guardian.
Okay, so I learned with your complaint that they did not notify them of the conversation. I, at the hearing, learned that they did not notify them of it being moved, if that makes sense. At the hearing, they say something about, I think Ms. Connors said we were wondering, or maybe it was Ms. Franklin, I don't recall which one, said we were wondering why it got moved. That's when I learned that.
Okay. But your direction to your staff was contact the parties and let them know that I spoke to Brandy, and also that the case is being moved from the 30-day status.
Correct.
That was the direction to your staff.
Correct. I didn't know that they were never notified that the 28th hearing was canceled. That's what I'm referencing in the transcript. I did not find out that they were never notified about the conversation or that Brandy was a gall until you sent that letter, and then I asked everybody. Literally, I was in the office when I got it, and I was like, what is this about? And I told everybody in the office to pull their emails.
I'll move to admit P3.
Any objection to P3?
No objection.
Sin?
All right, at the February 14th, 21 motions hearing, the issue regarding Miss Alexander serving in front of you as a gall did come up, correct?
I think you meant December or January. You said February 14th.
The December 14th, 21 motions hearing,
Yes.
okay? And did you bring that issue up, or did one of the parties bring it up?
I brought it up.
Okay. Can you tell the panel why you brought that issue up?
Because she was a gall, and I wanted to make sure I put that on the record so that there was no issue. At that point, my thought process, my understanding was that the staff had already sent the email, but I wanted to make sure I put the fact that she was an active gall still on the record at that time.
Okay, and do you remember the petitioner's counsel expressing that this was the first time that she had ever heard of this
Correct.
issue? Okay. And so at that point, though, during that conversation where you, I guess, have disclosed, hey, she has cases pending before me, you don't then at that time also mention that you and she had a phone conversation, correct?
No, because I thought it had already been done. So I was referencing, as of today, she has active cases pending before me. So that's what I was referencing at that hearing. I gave my staff the directive. I thought they did it. I think that's what most judges think. So that didn't even cross my mind.
Did you not feel it was important to verify whether they had received notice from your staff or not at that time?
Honestly, I wasn't even thinking about it. I was coming off of another hearing. It had been, I think they were the last hearing of the day. So it was like action-packed. The hearing before them was delayed. So if I'm not mistaken, their hearing started about 30 minutes to an hour late. So it was one of those, you just roll right into one hearing. And in fact, they just jumped right in when they came on, and I interrupt them probably, I don't know, maybe 5 minutes into the hearing and said, hold on, I forgot. I meant to do this at the top, but y'all just started talking. So it was one of those type situations. And again, I assumed that my staff had done what I asked them to do.
All right. I am going to move to introduce an excerpt of the December motions hearing transcript, and it is the portion that is directly relevant to what the judge is testifying to right now, and also what was charged in the formal charges. And I've done an excerpt just because I think it's easier to direct attention that way. I've provided that excerpt to Respondent's Counsel, and that's P1.
Okay. Any objection to P1?
No objection.
All right, that's in.
Ms. Phil, I know you're going to put it on the screen, but may I have a copy, a hard copy in front of me, please? Thank you. Oh, thank you. Yes, ma'am, thank you.
All right, so that's correct. Judge, beginning on page 6 and through page 7 and to the top of page 8 is essentially your disclosure to the parties that, hey, Ms. Alexander is of Gaul and she has pending cases before me. And you explain that you wanted to do this or address it on the top end so that there were no miscommunications, misconceptions, and certainly no back end motions, because you say, my standard as well, why didn't you raise that at the hearing?
Mm-hmm. Yes.
Okay?
My apologies, Madam Court Reporter.
And that is then when the petitioner's counsel, Ms. Connor, says, this is the first that I've learned of that. I did send an email to your staff attorney when the case was pulled from the original 30-day conference, asking why this case had been diverted from the normal course, and I did not get a response to that. So at that point, you know that they had made an inquiry of your chambers and not gotten a response, correct?
Yes, but I didn't know that my staff did not send the initial email that I said to send.
Okay.
To me, that was a matter of word. I didn't see the email. I didn't know what it was about. And again, I'm just rolling.
Okay, but you've been told by a lawyer that they made an inquiry of your office about the scheduling of this case being diverted, and they didn't get a response, and still you didn't think, you know what, I've come out here and disclosed that she's a guardian in cases before me. Perhaps I should go ahead and put the fact that I had a conversation with her about the scheduling and the fact that I was going to move it on the record as well.
No, I was not even thinking about that because, again, I thought the staff had emailed them and told them that. And I will also say my staff was on the Zoom. Nobody at that point said, Judge, we didn't send an email. So I still didn't know. Ms. Bowles didn't say it. My litigation manager didn't say it. Ms. Ward, that's the JA, she didn't say it either. Actually, this is December 14th. That would have been Ms. Well, anyway, that's irrelevant for this, but nobody said no, an email was not sent. And even after I got off the bench, nobody said we never sent an email.
Okay, so it was your staff's failure.
For?
The complete lack of communication.
I don't think there was a complete lack of communication. What I'm saying is I directed that an email be sent. I thought it was sent. Nobody told me otherwise. I did not learn that until after this JQC complaint was filed when I asked the question.
Okay. At some point, and I'm on page 10, Ms. Connor indicates to you, based on the fact that you disclosed she had cases before you as a guardian, that her client wanted you to recuse.
Where are you?
On page 10,
Okay.
line 9.
Okay.
Did you not want to, did you have some problem with recusing from the case? Was there some reason you didn't want to?
No, it wasn't about want or not want. As I understood it, the basis was that because, well, first of all, I always make folks take their basis because that's also what the law requires. And so as I understood it, the basis was the fact that she had cases pending before me, which would have applied to all of the judges in the family division. And so literally from that thought process, that's why I asked that question.
Okay. And Ms. Connor then expresses to you, because obviously you have a favorable opinion of Ms. Alexander, not that, oh, she just appears in front of me.
That's not what it says, but I get your drift. I don't know what Ms. Connor was thinking other than what's in this, what she says.
Okay. Do you go on to, and it's in this transcript, but do you go on to ensure that everybody understands, and by everybody I mean only these parties because they were the only people there, that Ms. Alexander had cases before every judge on the Fulton County Family Division bench?
Yes, let me read it. Yes, it says that she handles cases before all of the Fulton County judges who sit in the family division and has handled cases, yes.
All right, I'm on page 12, line 4.
Page 12, 1 second.
Line
Okay.
4.
Mm-hmm.
You ask, does he recognize that she frequently appears before Fulton County judges, period, as a Gaul and as a lawyer? And Ms. Connor confirms that her client understands that, and then you want to know how you are any different. What specifically have I said or done that makes me biased? And you explain that's what he's going to have to do for recusal. Is that standard for you to walk through the why when somebody has said, I'm uncomfortable with you presiding?
On an oral motion, yes. On a written motion, it requires an affidavit. So on the oral motion, I always ask the reason why so that I can assess whether or not it is or is not appropriate. For some cases, it's because I was the lawyer on a case they had when I was in civil practice.
Okay. And you go beyond asking about judges on the Fulton County bench. You ultimately inquire about cases that she has just generally in the metro area, correct? That's on page 13.
13? Yes. Yes, ma'am.
Okay. And then you extend that to other counties, if any, have you previously practiced in but do not have active cases in. That's page 13, lines 13 through 16. So do you agree with me that you were making it very clear, you were asking all the questions you could and making it very clear that essentially Miss Alexander would be in the same situation in front of not only all the judges on your bench, but all the judges in the metro area that she had cases before?
No.
Well, what was the
Wait,
point?
say that for me again?
What was the point of you doing all of this?
Oh, because if we're doing a bench-wide recusal, there's certain information that I have to have in order for us to do a bench-wide recusal and for us to report it to the AOC to say there are certain counties that this case should not be assigned to.
But there were 152 other counties that could have handled it, right?
Correct.
Not-
Which is why I asked that, so that if we were doing a bench-wide recusal, we would have that information and they wouldn't contact those counties that she had cases pending in. And I apologize, AOC, I don't remember.
Administrative
Thank you.
Office of the Clerk.
Thank
I
you,
knew
thank
that
you.
one.
Okay.
So you're saying today you did that so that you could provide the information if there was a bench-wide recusal, but at the end of your questioning cross-examination, you ask the petitioner's counsel, so Ms. Connor, based on that thought process, how does that make me biased? That's page 13 and line 22.
Oh, 13, hold on. That is what it says. This is after Brandy is questioned.
Mhm.
Or, excuse me, yes, Brandy's the respondent, yes.
Okay. And then ultimately, there's an exchange about, by Ms. Connor with Ms. Alexander about how many of our cases in other jurisdictions is she guardian on. And then ultimately, at the end of all this back and forth, Ms. Connor withdraws her request to have you recuse. Is that correct?
Yes, after she had I gave her and Ms. Franklin the opportunity to question myself and Brandy, and after she had that opportunity, she withdrew her request.
Okay, page 15 at line 25.
Thank you. Yes, that's what I was looking
And
for.
so again, I ask, you go through that whole exercise to demonstrate essentially that Ms. Alexander would have the same issue in front of multiple judges in the metro area, but again, it doesn't dawn on you, we're having this whole question about whether I'm biased, and I'm asking the petitioner's lawyer about it. It doesn't dawn on you during that to disclose your conversation with Brandy, just to make sure that they were aware of that as well.
For the fourth time, no ma'am, that is not what I was thinking. I thought my staff did what I said, and again, this was the end of the day. Things are rolling, so it did not occur to me. I thought they did what I said. Mea culpa for assuming that they did what I said and nobody said to the contrary, excuse me.
All right, and so Ms. Franklin, who's Ms. Alexander's attorney, doesn't object to you being on the case at that point, correct?
Ms. Franklin actually objects to recusal. She affirmatively objects to me recusing myself.
All right, after that hearing, what was the next hearing in the case? Was that a temporary hearing in January of 2022?
And to be exact, part of the reason I was asking those questions is on page 7, Ms. Franklin initially brings up the issue of Ms. Alexander being a Gaul in multiple jurisdictions, and talks about, her exact statement is that Ms. Alexander is a Gaul in multiple jurisdictions, Fulton County and other Superior Court, and it would be grounds for all of them. So I think it's pointless to move to recuse, and that would be my response. So that's part of the reason why I was asking all of those questions. But I apologize. What did you ask me? I was still reading when you were asking the question.
The next event in the
Oh,
case.
the January hearing? Yes, ma'am.
And that was January 13th of 2022?
Thereabout, yes, ma'am.
And that was the temporary hearing in the case, correct?
Yes, ma'am.
And that hearing was not completed on that date?
No, they announced a 2-hour time announcement, and 2 hours in, they still had 3 more witnesses, I think.
Okay. During the course of the temporary hearing, there was discussion about 2 potential witnesses that Ms. Alexander was going to have fill out affidavits for her. Do you recall that portion of the hearing?
I recall there was one witness who had filed an affidavit. That was Nigel Hunter.
Okay. And do you know?
Oh, sorry.
Do you know Ms. Hunter?
I do.
How do you know her?
We went to high school together.
Okay. And did you disclose that at the hearing?
I did. So they had asked me to make sure I reviewed the affidavits before the in-camera that Ms. Alexander had requested that I do. And when I looked, they didn't have a hard copy, so I looked at the docket to see what affidavits they were, because they said they had been filed. And I saw Nigel Hunter's name. I asked them, is Nigel Hunter a black female lawyer? They said yes, because of course Nigel is a non-binary name. They said yes, and then I said, is she from Atlanta? They said yes, and then I said, oh, just to let you all know, I went to high school with Nigel, but I haven't seen or talked to her since 2019, 2020, and that was the extent of that. Now, the second person, I apologize, I don't recall who you're talking about.
What about Brandy Reeves?
They never disclosed anything about Brandy Reeves at that hearing.
Do you know Brandy Reeves?
I do.
Okay, and how do you know her?
Brandy Reeves was a public defender in Fulton County at that time. In addition to that, I also know her through another mutual friend. And she subsequently ran for judge in Fulton County. and was the administrative coordinator for the city of Atlanta. So I've met her in those capacities too.
All right, after that January temporary hearing that did not conclude on that date, a motion to recuse was filed against you on January 24th of 2022, correct?
Yes,
Okay. And that was filed on behalf of Miss Alexander by an attorney by the name of William Alexander, no relation,
yes.
correct? Okay.
Well, I don't know if they're related, but yes to the other part.
Do you recall at what time, or do you recall when you first became aware of the motion to recuse that had been filed?
February. And it was nighttime. I was actually walking into the Kapabwa New Year celebration.
I know what that one is too.
How did you become aware of the motion?
Miss Bowles told me.
Okay. And it was, all you know is that it was sometime in February.
It was the beginning of February. I do recall that. I don't know the specific date. I'm sure I could look at my calendar and figure it out though. But whenever the New Year is, it was literally the New Year celebration. It was at King and Spalding that year.
But you didn't become aware of it on the date that it was filed on January 24th of 2022.
No,
Right.
neither did Mr. Alexander ever serve me or Chambers with a courtesy copy of it or serve me with a motion.
Okay. It was e-filed, correct?
Yes, but the e-file system in Fulton County doesn't work the same way it works in some other counties.
And that's because according to you, you have to select individually to notify the judge's staff or members of the, or the judge themselves, correct?
For a service copy, yes.
Okay. The petitioner's attorney e-filed a response to the respondent's motion to recuse, and they did that on February 2nd of 22. Did your office receive a copy of that document?
I don't know.
Okay. So at the time you became aware of the motion to recuse, did you also become aware that the petitioner had responded and said we join in the request?
No.
Okay.
This was nighttime based on an email that Mr. Alexander sent to Ms. Bowles.
Okay.
And he referenced the motion to recuse but did not include a copy of it in his email. So then she went to the docket and pulled the motion to recuse.
Okay. What was the policy or the procedure in place in your office at that time when your staff received e-filing notifications?
I don't know what you mean by that question.
Like if they received, when they received motions and they got an e-file notification with a courtesy copy of the motion, would they then notify you, or what were their next steps?
So if they received an e-file notice of it, depending on what it was, they may or may not notify me. But generally, we relied on courtesy copies because the way it works in Fulton County is, and this is Superior Court, not State Court, there is a distinction in how it works because there are different clerk's offices. So we don't get, in Superior Court, we do not get automatic notification when motions or any pleadings are filed, which is why I require that the parties send courtesy copies to Chambers.
After you became aware of and read the motion, were you upset by the contents of the motion?
You could say that. I was irritated. You could say upset. They are sometimes interchangeable.
Okay. And that was because you felt like they had turned this matter into something personal against you?
And lied on me, yes.
Okay. What in the motion was a lie?
The motion said that I failed to disclose my relationship with Nigel Hunter. I failed to disclose that she donated to my campaign, but I did not know that she donated to my campaign. The motion also referenced the fact that I had recent contact with Nigel Hunter, which was not true. The motion also said that I failed to disclose my relationship with Brandy Reeves. However, there was never any mention of Brandy Reeves at the hearing. In addition to that, I did not have a personal relationship with Brandy Reeves. I didn't have either one of their cell phone numbers, any way to contact them outside of Facebook or something like that. It also said that Nigel Hunter had actively campaigned for me, which I was not aware of that. And again, going back to what I said about how my campaign was run, I knew the folks who actively were campaigning for me. And there were some other misrepresentations in there. I don't have it in front of me to kind of chronicle everything.
Okay. Just for the record, that is joint.
Oh, and then what she said about the conversation, the ex parte conversation, that was incorrect as to how she phrased it.
Okay.
The fact that you got a contribution from a lawyer appearing before you, what would be the violation to that?
The fact that I got a contribution.
Lawyers give,
correct.
Usually the only ones that give judges contributions.
Correct.
And they appear before you.
Correct.
What would that violate in your mind?
With regard to this motion to recuse, they're saying I failed to disclose it. I didn't even know that she had contributed, and it was a $50 contribution. I am extremely appreciative of every penny someone gives me because it's their hard-earned money. But that was the issue: is that they said I failed to disclose it. I didn't even know that she had contributed.
Oh, I assume it appeared on your public campaign disclosure.
It did.
Right, so it was in the public record.
I guess so. Yes, ma'am.
So Rule 2.11 in the commentary would cover that, wouldn't it?
You have to give me names. I apologize. I'm not
Okay.
good with numbers.
I can give you that after.
I know you were making a point, and I was trying to be with your point. I just don't know what the name of that rule is to say yes or no.
I think it's the rule that deals with disclosure of potential information that creates a conflict or an appearance of a conflict, and I think there's a commentary in the rule that speaks to the fact that if a lawyer gave you a contribution, that's deemed disclosed once it's printed on that public disclosure.
Oh,
In other
I see.
words, it's out there.
Okay.
So I assume they got the Brandy or the Nigel Hunter information off your public campaign disclosure.
No.
Right.
Brandy represented that she talked to Nigel, and Nigel told her that.
Gotcha. Okay.
For the hearing panel, both the respondent's motion to recuse and the petitioner's response to that motion are included as J3 and J4 on our joint exhibit list. And so, Judge, you've listed off, you looked through the motion and you've listed off a litany of things that you viewed as misrepresentations or just downright untrue that were contained in the motion, correct?
Yes, ma'am.
Okay. And you said that you were upset by it. You vented to your staff about your frustration, correct?
Yes, ma'am.
Okay. And you also called one of your close friends, who's a higher up in the Fulton County DA's office, Simone Hilton, about the motion to recuse, correct?
I called her to ask her if I had met Brandy Reeves, other than the one time that I recall, which was at Simone's birthday brunch.
Okay. And did you call any other lawyer or member of the bar to vent about or talk about the motion to recuse and how you felt about it?
Yes.
Okay?
Yes.
So it's May 21st of 2025, and you've answered that question with a yes today. Do you recall when you appeared in front of the investigative panel to make a statement on May 20th of 2022, and when you were asked whether you had called another member of the bar or an attorney and spoke about that motion to recuse, you said that you did not think so, you did not think so, and that you could not recall calling anybody else?
At the end, yes. I remember that question. I answered that question differently before because I was talking about my staff and other judges, and then I believe it was Mr. Boring who clarified and said other than judges and other than your staff, and I said I did not recall, yes.
Okay.
Or I said whatever you just said. I'm assuming you're reading from the transcript.
Okay. So in May of 2022, when asked that question in front of the investigative panel, when you were without discovery and before formal charges had been filed, identifying that you made a call, you said you did not recall.
I think you mean June, and yes, that was correct.
Okay.
That was June, right? I just want to make sure.
May 20th of
Oh,
2022?
I stand corrected. I thought it was June, but yes, ma'am.
Okay, so why is it that you recall today and you didn't recall then?
Because subsequent to me testifying, or I don't know what it's called, but subsequent to me sitting before the IP panel, Adidiong Aaron filed a motion to recuse, and in there is where she referenced the conversation. I had no recollection of that conversation. When I talked to her, it was late at night. I really fell asleep during the conversation, so it wasn't until she filed that motion that I even became aware of the conversation, or remembered the conversation, I should say it that way.
Okay, so on February 8th of 2022, when you now recall that you called Adidiong Aaron, who is EA, what was your relationship with her at that time?
I don't know how to describe it. I guess affiliate, associate. We had had several conversations, a couple of conversations rather, prior to that, and talked when we would see each other.
Okay.
Talked about personal stuff, talked about, life.
Ms. Aaron is a practicing attorney, member of the bar, correct?
Yes, ma'am.
Practices family law?
Yes, ma'am. I think she does family and PI, but yes, ma'am.
Okay. And so at the time that you made this call to her, February 8th of 22, you said she was an affiliate / an associate.
Yes, ma'am.
And she actually had at least one case pending in front of you at the time you made this call to her.
Yes, ma'am. And be clear, I made the call because she called me and I was calling her back.
Did you know what she was calling you about? Did she leave you a message?
No, it just said it was a personal matter, so that's all I knew.
So, I'm sorry, did she leave you a message?
Yes.
A voicemail?
I don't know if it was a voicemail.
Okay.
I just got a note from someone in Chambers saying Miss Aaron called and she asked that you call her back. It was a personal matter.
Was that same day on February 8th?
No, as I recall it, she had called a couple weeks before that maybe. And then in the discovery, it says something about a chat in the Zoom. I don't check the chat in my Zoom, so I don't know about that. But she had called and asked for me to call her back. And that's how I got her number and everything.
Okay, and she indicated...
Actually, did I have her number before that? I don't recall.
You said she indicated it was a personal matter?
Yes.
Okay. Do you remember about how long you were on the phone with Miss Aaron?
Honestly, I don't. Like I said, I
Was
remember falling asleep
You fell asleep?
on the phone. Mm-hmm. I remember talking to her in my bed. Like I said, once I saw the motion, that's when I recalled what was going on. But it was at nighttime. I was leaving work, and I remember coming home, getting in the bed, and she and I were still talking, and I remember falling asleep.
So y'all were on the phone long enough for you to have left work, gotten home.
No, I called her once I got home. I was
Okay.
saying that I left work, and
Okay.
it was late. I called her once I got home.
Okay, so you get home, and then you all are on the phone long enough that you get ready for bed, get into bed, and then you fall asleep while you guys are talking.
I recall calling her when I was in the bed,
Okay.
not get ready for bed.
So are we talking about a 5-minute phone call or an hour-and-a-half long phone call? Just give us an approximate guess.
I can't. I honestly don't know. We talked about, she had just had a baby. So we talked about her, soldiering and being a new mother, not sleeping. I can't tell you how long the conversation was. I I would just be guessing to say so, honestly.
What was the personal issue that she needed to talk to you about?
She said she just wanted to catch up. We had talked about, like I said, the new baby. We had talked about her journey with that. We talked about her being a new mom. We talked about, and this is what I recall. Like I said, I didn't even recall that conversation until I saw the motion to recuse. We talked about just being a practicing lawyer. We talked about, we talked about a myriad of things.
So she called.
Oh, weight. We talked about weight because we had a history of talking about working out and whatnot. We were both folks who heavily worked out.
So she called your chambers, left a message. It's personal for you. Her associate, or your relationship was you all were associates. Yet the things you just listed off, new mom, lawyer, you're talking about each other's weight. Those are pretty personal things. Wouldn't you agree?
Yes, if you want to use the colloquial term friend, that's fine. I don't call everybody my friend, so that's a distinction without a difference for your purposes. But for my purposes, like, there's a difference. I understand what you're saying, though.
Did you bring up Miss Alexander's motion to recuse you during your conversation with Miss Aaron?
I don't know who brought it up, honestly. What I recall is that we were also talking about, here's what I recall. What I recall is that she was talking about there was a member of AKA, and I'm going to tell you what that acronym is.
I'm going to stop you there, Judge. My question was specifically about, I specifically asked you, did you bring up Miss Alexander's motion to recuse during the conversation?
All right, well, I answered that. I don't recall if it was me or her.
Okay.
But that wasn't the context that it came up. That's why I was trying to give you context, but I understand.
At the time that you called Miss Aaron, did you know that she and Miss Alexander were friends?
I did not. I did not learn they were friends until the motion to recuse.
And is Miss Aaron in a sorority?
Yes.
Which sorority?
Alpha Kappa Alpha Sorority Incorporated, which is how it came up because she was talking about something that had happened between her and another member.
Okay, what did she say happened with her and another member?
She was talking about discord between them and something that had happened in court or publicly or something. And I said something to the effect of, you got to let it roll off your back like, water on a duck. Just because somebody's in the same sorority as you doesn't mean that y'all are going to be besties. Something to that effect.
And did she identify the person or persons within the sorority that she was having issue with?
She did.
Who?
Was
it Miss Alexander?
Miss Alexander is not a member of Alpha Kappa Alpha, no.
Okay. I just wanted
And I'm
be
not
clear
trying to
about
be
that.
persnickety, but I also don't want to cause conflict between lawyers.
I understand.
And this is being live streamed. So.
Okay, but that was not about Miss Alexander and conflict
No.
between she and Miss Aaron, okay? And so you testified that that's what led to the conversation about Miss Alexander's motion to recuse?
Correct.
Okay. How did that happen?
I think I said something to the effect of that people will lie on you even if you're in the same sorority. I'm dealing with the issue like that now. Something to the effect of that.
Did you identify, when you made that statement, did you thereafter at any point identify that you were talking about Brandy Alexander?
I did not. Never called her name, never referenced her by name, never said anything that identified her.
Why not?
What do you mean, why not?
Why didn't you identify who the person was?
Oh, because I was just talking in the general about what we were talking about, specifically about the personal conflict and navigating that. Like, I wasn't talking about the specifics of the motion or the specifics of what was said. I was using that as an example of, listen, things happen, like, you gotta woosah sometimes and just move on.
Did you-
Uh-huh,
I'm sorry,
go ahead.
we finished. Did you tell Ms. Alexander, or Ms. Aaron, that Ms. Alexander had made the matter personal by filing that motion to recuse?
No, I never mentioned Miss Alexander's name at all.
Did you tell Ms. Aaron that the person that had filed the motion to recuse, that was your sorority sister, had made the matter personal?
I don't recall using those specific words. What I remember saying is something to the effect of, people take or make things personal and it's not personal. That's what I recall saying. In the general context, not specifically.
Did you talk to Ms. Aaron, or did you tell her how you were going to handle the motion to recuse?
No, ma'am.
Okay. You did not say to Ms. Aaron that you weren't going to recuse because it would make you look like you did something wrong and that could be used against you in an election?
No, ma'am. In fact, my very first 2 weeks on the bench, I recused from the case.
Well, were the allegations in that motion to recuse similar to the way that you characterized the allegations in Ms. Alexander's motion to recuse?
No, that was a divorce where the partner, the respondent, was the partner I worked with closely at the firm, and so I voluntarily recused. I was friends with both of them, for lack of a better term.
Right, so, but that, my point is, recusal in that circumstance would never make it appear as if you had done something wrong, or, you know, the concern that that could be used against me in an election, that wouldn't have arisen from the recusal circumstance you just described, correct?
It could have. People use let me say this. People use a whole lot of stuff in an election. So, yes, yeah.
Did you say you were bothered in Miss Alexander? Did you say you were bothered in the sorority sister's circumstance because you had given that particular individual business?
I don't remember, honestly.
Is it possible you said that?
It's possible. I don't remember.
Well, do you remember that being part of why you were angry or upset by the motion to recuse?
I remember being upset because she had lied on me.
Okay.
And so there are a whole lot of folks I've given business by way of me appointing them as a gall, because as a judge, you have the right to deny that. So I can't say that was at the top of the list. Was it on the list? Probably. I'm human.
Okay, but you don't recall saying that to Miss Aaron?
I don't recall one way or the other.
Who pays the galls? The parties?
The parties.
And then who pays the JOs?
The county.
Gotcha.
Mm-hmm.
And are they paid hourly or flat fee?
Flat rate.
How much do they get?
$6.50 a day.
The JOs?
Yes, sir.
What do the gals get?
The galls, it depends on their individual rates. So they range from, back then, $175 to about $600 an hour.
And do you have to approve that?
Yes.
Thank you.
Did you tell Miss Aaron that the sorority sister seeking to recuse you had wanted a senior judge to preside over her case, so you called that sorority sister to see what was going on?
No, that didn't happen. I didn't call Brandy to ask her what was going on. In fact, I never talked to Brandy again on the phone after the October 18th conversation.
At the time that you had this phone call with Miss Aaron, to be clear, you all had broken in the temporary hearing, meaning that hearing had not yet been completed, correct?
You're talking about Miss Alexander, Brandy's case?
Yes.
Correct.
Okay. So at that point, you had heard some evidence in the case. I believe it was from the petitioner, but you hadn't heard all of Ms. Alexander's evidence at that point.
Correct. I heard from 2 witnesses on the petitioner's side, 1 witness on Ms. Alexander's side. I still had to hear from Ms. Alexander and the child.
Did you tell Ms. Aaron that you were going to show the sorority sister personal by taking or giving her child to the petitioner, the father?
Absolutely not.
Did you and Ms. Aaron have a conversation about the fact that you were viewed as a father's judge?
We have. I don't know if we had it that night, but I've had that conversation with multiple folks because they say I'm a dad's rights judge and I say that I'm a kid's rights judge.
Did you tell Ms. Aaron that your view or the way that you approached custody issues was that you start from a place of joint physical custody and tell the parties to get you away from that place or walk you away from that place?
Those were not my exact words, but those are not my exact words.
What were your words?
I don't want to run afoul of the court's instruction. You said what now?
What were your words?
So I've said this multiple times. I've said it publicly. I've said it in court. I've said it on panels as well as to individuals. My reading of the statute is that there is neither a presumption in favor of mom or dad. So to me, if mom and dad are the 2 options, then there's no presumption in either. So I start in the middle. To me, joint is the middle, and then I easily move off of that. And normally I say with even a scintilla of evidence, like that's part of my standard speech. So I start from a place of neutral, which to me neutral is joint, and then go from there one way or the other.
Okay.
Of course, using the best interest of the child standard and whatever other law is applicable to that type of hearing.
Okay, but the standard in that type of hearing is the best interest of the child, correct?
For a custody hearing, yes.
Did you tell Ms. Aaron that if the sorority sister was concerned that you were going to rule against her, she should have just called you instead of filing a motion to recuse?
I don't recall that, but again, I don't recall this conversation in whole. I do recall falling asleep on her.
Well, you just testified in some pretty good detail about how you recalled a specific part of the conversation, which is your view on custody matters, correct?
That was early on in the conversation, yes. Just like I also recall us talking about the baby. I recall her feeding the baby and the baby crying when we were on the phone. So again, I recall parts, but not all. Miss Ville, I am one step above a narcoleptic, and anybody who knows me will tell you I will fall asleep on the phone on you in a minute, which is why I generally don't talk to people late at night or go to late movies.
So you said that you don't recall, but is that something that you may have said? If she thought the case was not going in her favor, she should have just called me instead of filing a motion to recuse.
I don't believe I said that.
Is that something you would say, is my question?
No, that's why I don't believe I said it.
Why is it just no?
Pardon?
Why
I don't
is your
understand.
answer to my question not just no?
What's your objection, Mr. Banks?
I mean, she's answered the question. I don't know, she's answered the question. Ask and answer.
Okay. I don't know that I've gotten a clear answer, and maybe I'm just misunderstanding, so if you can just attempt to answer it for us so I can make sure I understand your answer. I realize it may not be a simple yes or no, but if you can just tell us what your answer is.
Yes,
so I can
ma'am.
make sure I've got it.
No, I do not recall saying that. No, it does not sound like something I would say.
Okay, thank you. And Ms. Beal, I don't want to interrupt your train of thought, but if you're sort of leaving the Aaron call piece and are we moving kind of to a new topic? I'm just wondering if this is a good point to take our lunch break so that we don't interrupt your flow if you're finished with that portion.
Okay. I just have a few questions about the motion to recuse, and then I'm going to wrap up.
Okay.
I'll be quick.
Okay.
Judge, you did not issue a decision on the motion to recuse until February 17th of 2022. Does that sound correct?
I have no reason to doubt that. I don't have it in front of me to see the date.
Okay, and the panel has that order at J5. Your order, your decision was you denied the respondent's motion to recuse in your initial order, correct?
I denied it on procedural basis as it was not filed on me, and I denied it as untimely, correct. Procedurally, I wanted to make sure I addressed the motion that was in the record, and then I subsequently, literally 3 or 4 minutes later, because I gave them the orders at the same time, filed the voluntary recusal.
Okay, and the order denying the motion to recuse, you included a footnote where you said the court denies having ex parte communication with the respondent about this case on October 18th or at any time, correct?
Yes, with explanation.
Okay. Are you aware of the line of appellate court cases in the state of Georgia that say that judges should not refute or offer information or evidence related to the allegations in the motion to recuse, because at that point, you refuting it makes you an adversary of the party seeking a recusal?
Not until this morning when you said that. Not until this morning when you said that. That wasn't my understanding of the law.
Okay.
And the footnote was that the word improper or unauthorized is missing from in front of ex parte, as I explained to the hearing panel.
You mean the investigative panel?
Oh, my apologies. Yes, ma'am, the investigative panel.
And what you stated to the investigative panel was that you misunderstood. You at the time at the time that you wrote this footnote and this order on this motion to recuse, you did not understand, the way you put it was that there were exceptions to the rule on ex parte communications. Is that correct?
No. I believe I gave the example of hearsay, how people will say something's not hearsay and it is, but it fits an exception, so it's permissible. I believe that's the example that I gave. So I was saying that, and I've never denied the phone call, even when I spoke to you on February 14th, Ms. Beal, I admitted to the phone call. What I was saying was that it was not an improper ex parte communication because we only talked about scheduling and logistics.
Okay, but in your footnote, you write the court denies having ex parte communication.
Which is why I said the word improper or unauthorized is missing. Yes, ma'am.
All right. You then turned around and entered a voluntary order of recusal a few minutes after you entered that first order, correct?
Yes.
And in that one, you state, among other things, that the misrepresentation and the respondent's motion to recuse are concerning to the court.
Correct.
All right. That's all I have
Okay.
at this
All right.
time.
Then that's probably a great breaking point for us to take the lunch break I promised everyone. So let's go ahead and break for lunch. I'm going to give you an hour and 15 minutes just to ensure that everybody has a chance to get somewhere and back if you do choose to leave campus to eat. So we'll resume in 1 hour and 15 minutes. If we find ourselves all back a little early, maybe we can get started early, but we'll see you back in an hour and 15. Okay? We're in recess till that time.
Back up and discuss with you briefly the issue related to the several complaints rated on the delayed rulings. I know that you have admitted and stipulated to the facts and then nearly all of the counts. So I believe of the 17 counts, there are 2 that you did not admit to. And so I want to cover some of that with you. So just to start off, do you agree the first time that you got notice that the JQC was investigating these delayed ruling matters was around July of 2023? Does that sound about right?
Not on. Yeah. There.
Hello? Oh, yes, yes, ma'am.
Okay. When you took the bench, you had a staff attorney. That was the one you spoke about earlier, Miss Tangi Bush, correct?
Yes, ma'am.
And she left your office when?
October the 15th, 2021 was her last day.
Okay. And then who did you hire to replace her?
Janelle Bowles. She started October 15th, 2021. I'm sorry, October 18th. It was that following Monday.
And Miss Bowles would have been with you from October 18th of 21 through when?
I believe her last day was June 5th or 6th of 2023.
So when you took office and Miss Bush was your staff attorney, what kind of internal system, if any, did you have to track your open cases that needed orders from you?
An Excel, well, I don't know if it was Excel or Word, but a spreadsheet. And I'm using the term spreadsheet loosely because I don't know if it was Excel or Word.
Okay. Did you make that spreadsheet?
Ms. Bush kept it.
Okay. Did you have access to it?
I believe so, yeah. I think it was on the P drive.
It was on the what?
P drive
Okay. Is that like a joint,
universal
a
drive?
shared drive?
For chambers, yes.
Okay.
I know it is now. I believe it was back then.
Okay. And I know that there are some judges that like to prepare their own orders. There are other judges who have attorneys prepare orders, others that have their staff attorneys prepare orders. What kind of judge are you?
All of the above.
Okay. When you were on the family division, let's talk about when Miss Bush was your staff attorney. Were you also all of the above then?
Yes,
Okay.
because you also have to understand that the family division has a lot of pro se litigants.
Okay. So what I'm hearing is it depended on the circumstances of the case, whether you would have the parties draft an order and send it in, or you would have your staff attorney draft the order.
Yes.
Okay. So is it fair to say that in most pro se circumstances, you would have Ms. Bush draft the orders?
All pro se circumstances, yes, ma'am. Unless she wasn't there. Like there was a period, like I said, she was out for maternity leave.
Okay. And after she would draft those orders, would they come to you for review?
Yes, ma'am.
Okay. Did you have any guidelines in place for Ms. Bush regarding how quickly she needed to get you drafts of orders after you presided over hearings?
Yes, ma'am.
Okay. And what were those guidelines?
My general rule is that you need to get, depending on what type of order it is, but in general, if it's a simple order, within 2 weeks. If it's a more complicated order, then within 30 days.
And so were those deadlines entered onto that Excel sheet so that you could access it and see?
I don't believe so.
Okay. So how did you all keep track of, when orders needed to get to you for review when you had Ms. Bush?
It would be the same for Ms. Bush and Ms. Bowles. Like, they knew what the guideline was,
Okay.
right? And so they would get them to me within that. Sometimes if, like, for instance, there was an email that I sent asking for an order, they would do ticklers. Generally, I would note on my calendar TB to do order or JOB to do order. Or parties to send order, and I would give them a deadline by which to send the order. But the rule was always, if the parties did not send the order by whatever date that I stated, then they needed to do they being the staff attorney, needed to do the order.
So
When-
nobody would call the lawyers and say, hey, you told the judge you'd have this, where is it?
My understanding is they followed up via email.
When you had lawyers timely submit proposed orders to you, did your staff attorneys, either Ms. Bush or Ms. Bowles, was their job to review those prior to sending them to you?
Yes, ma'am,
Okay.
as is now with Ms. Green, yes.
Okay. And typically, how long would you give them to review those proposed orders before they needed to get to you?
I don't know that that was ever a discussion. My expectation is that things are done in a timely and efficient and expeditious manner. Certainly, the family division has a lot of volume. So depending on what it is, I can't answer that with a bright line rule, let me say it that way.
Okay. We've agreed to some exhibits that have come in related to the delayed rulings, and some of those exhibits, I'm not going to go through all of them. The panel has them for their review, but some of those exhibits are emails, either from attorneys or from pro se litigants inquiring of your office, normally to your staff attorney, about the status of a final order. So did you have a policy in place or an understanding with your staff attorneys that, hey, when you have attorneys or litigants emailing about the status of an order, were they required to tell you that that inquiry was going on?
Were they required to tell me no?
Okay.
So the staff attorney's job is to keep track of the outstanding orders and to give me the orders as either they come in after they've reviewed them or as they've drafted them.
Okay. So in some of these circumstances where the panel will see that you had lawyers emailing over a span of several months, sometimes, a year and a half, a year, in those circumstances, were you aware that lawyers were reaching out to your chambers for that amount of time and either not receiving a response or not receiving an order?
I can't say yes to all. Let me say it this way. The emails that you produced in discovery that I'm assuming you're talking about, I didn't see those emails until discovery. So of those emails, I don't know that I was told that folks were emailing. Like, I know there was one instance where somebody came up to chambers.
Okay.
And so they told me about that. Mr. Storch came into the courtroom when
Okay,
I
and
was
we're-
on the bench. Oh, sorry.
We'll talk about him specifically here in a minute, but what I'm getting at is there's several...
Not always. I think that's the answer. I'm sorry to interrupt you.
So
I think
would you be
a
able-
general answer is not always.
Okay, would you be able to tell us if I pull the emails up, which ones you were aware of and which ones you weren't?
I can try, but I can't say that I can.
Okay.
When you say which ones, you mean which cases or which emails?
Which cases you were aware of that the lawyers were reaching out repeatedly on?
I can try, but I don't know if I will be able to.
All right. I'm going to start on, and this is in the charges of...
Let me say it as a general principle, they did not tell me that folks were emailing as a general principle.
Do you realize how awkward it would be maybe for a lawyer to have to call the judge's chambers and say, this order's 6 months late?
Yes, sir. I've actually done it many times myself as a litigant. Excuse me, as a litigator.
So I want to start with, in the 24 charges complaint, 23223, and Judge, I know that probably doesn't mean anything to you, but I've got questions about that one because it's one where there is a charge related to Rule 1.1, which is failure to respect and comply with the law. And that is one of the delayed ruling charges that you have denied. And so I want to talk about that case. It is the one where the original petition for modification of custody and motion for an emergency hearing was filed in August of 2020. And I understand that you inherited Judge Belinda Edwards' caseload. Is that correct?
Yes, ma'am. May I
Okay.
interrupt you? I have a chart with the names. I don't know what case you're talking about, but I have a chart where I went through and put down the complaint number with the names, because I don't know them by complaint number.
Oh, are you saying it would help you with just sort of
Yes.
assisting answering questions?
Yes, ma'am, because
That's
she's
fine if
asking me
you want- If you
about
want to hand
a
that to her,
complaint
that's
number.
I
fine.
don't think that's the chart that she used. Maybe it's this one.
It's the one that I
Do
gave
you know
you
them?
all.
You said you know them by name.
I know them by name. I don't know
Okay.
them by number.
I-
So if
I-
you refer to them by name, that's fine too.
I can give you the name.
Okay.
It's Green versus Green, Slade.
Slate
Green.
and, yes, Catherine.
Okay. And I asked about Judge Edwards because at the onset of that case, I know that she had entered some orders and presided over the temporary and whatnot.
Yes, ma'am.
But you get on the bench in January of 21, and you preside over the final hearing, and I'm at paragraph 51. You preside over the final hearing September 23rd to 24th of 21. And you have agreed that 9 months after that hearing, the respondent filed a motion for emergency hearing and modification of custody and parenting time, correct?
I agree that it was filed. I did not know about it. We weren't served with a courtesy copy in chambers. That goes back to what I said about we don't automatically get notifications of motions being filed.
So is that an ongoing issue, or was it an ongoing issue for you in the family division, that people are filing motions and you just didn't have any idea?
That's the way Fulton County works, period. Even now in the criminal civil division, unless somebody specifically like clicks on Judge Williams or clicks on Brittany Green or my litigation manager, we don't get notification, which is why, and I tell the lawyers this all the time, they need to send courtesy copies. And in fact, on my status calendars, I would start with that announcement almost every single calendar.
Okay.
That's
So-
also how cases got scheduled. So if you didn't send a courtesy copy of the motion, we didn't even know it was pending to schedule it.
Okay. So based on your representation that you weren't aware of the motion, it makes sense then that you did not hold a hearing and never decided this motion, correct?
Is that the one where the respondent objected to the motion and a hearing needed to be, I don't know, I'm sorry.
Well, it makes sense if you didn't know about a motion, you wouldn't have had a hearing on it, correct?
Okay.
Do you agree?
Yes, ma'am.
Okay. This is also the case where, do you recall that a motion for final order was filed on April 17th of 2023? Do you remember that?
I learned it after your letter, when we went to the docket.
Okay. So the first you were aware of that motion for final order would
Well,
have...
is that the one where there was an objection filed? There was one of the motions where the response files an objection. Is that it?
So, Judge, I'm not, if there's a way I can ask the question better, that's fine, but I'm not going to answer any questions. So, this motion for final order was filed in the Green v. Green case on April 17th of 2023.
Okay, so my recollection, as I sit here now, not looking at the docket, is that the response that was filed objected to me entering a final order and requested an evidentiary hearing.
Okay.
And therefore, I could not enter one because there was a request for a hearing and it had to be scheduled.
Did you schedule a hearing?
Yes.
When did that hearing take place?
If memory serves me, I believe that's the case where it was initially scheduled for November the 27th, but my mother died November the 23rd. And so, of course, that hearing was canceled and rescheduled for January, maybe 11th? January of 2024, either way.
Okay. good memory, January 11th of 2024. Do you also remember hearing the respondent's motion for an expedited hearing on that date?
I don't remember what I heard on that date. I just know I heard the case on that date.
Okay. As a result of the January 11th, 2024 hearing date, did you enter any orders?
Yes.
Okay. Do you know when you did that?
I believe it was March of 2024 because I had given my staff attorney the edited orders from the January hearing sometime in February, and she said that the lawyers said they were working on a consent order. So I told her not to enter my order because they were working on a consent order which would resolve all matters. And then once they submitted the consent order, I reviewed it, signed it, and entered it. I believe that was March 5th. If not, it was sometime early in March. Let me say it that way.
So you entered a final order in the case on March 5th of 2024, correct?
I entered their specific consent order, yes,
Okay.
which resolved all issues is what they told me.
Where did they tell you, or when did they tell you that?
Say again? I'm sorry, your voice dropped.
How did they tell you that? Like, when did they say that to you?
Well, they sent Ms. Green an email saying that email the consent order resolved all issues. Because as I also recall, after I had that hearing in January, the gall on the case sent another email asking for another hearing. This was like literally a week or two after the hearing that I'd already had. And then subsequent to that is when they sent the consent order.
Okay. So you presided over the final hearing in September of 21,
Mm-hmm.
and then
Yes,
you
ma'am.
referenced being notified by the investigative panel. Does July 20th of 2023 sound correct?
Yes, ma'am.
Okay. So during the time that you presided over the final hearing in September of 21 to July of 23, why wasn't a final order issued?
So that one was right before Ms. Bush left, and so I think it got lost in transition between Ms. Bush and Ms. Bowles.
I understand. I'm just interested in the why, since I think you guys are going to be presenting some mitigation evidence. And your testimony is that your understanding is that the final consent order resolved all outstanding issues on that case.
Yes, that's what I was told.
Okay.
That was the party's representation.
Do you have a copy of that email that you said the party sent to Ms. Green?
I do not. I personally do not. Literally what Ms. Green does is she prints out the orders and hands them to me, because the other thing is parties will say all kinds of stuff in email, so stuff that's not appropriate for me to know.
Okay. You testified that that matter was one in which Ms. Bush was around the time of her leaving, which I understand. Do you recall, through your counsel, responding to the JQC's notification and indicating as to that case that it was one that you would have a final order issued on by August 18th of 2023?
Yes, ma'am. And then when we checked the docket, we saw the pending motions.
Okay, so after you got that notice, you heard the motions on January 11th of 24, and then you got a follow-up correspondence from the JQC regarding the final order, correct?
Say that for me again?
Through your counsel, you received a follow-up correspondence from the JQC regarding the outstanding order, correct?
No, the beginning of that. When I said, say that for me again, please, the beginning of that. You said I had the hearing and then got another notice from the JQC?
Yes, do you recall that?
I recall having the hearing on January 11th or so. Are you talking about the January 17th? No, the January 17th letter?
So you would have received the first one in July of '23,
Correct?
correct? And then you indicated after receiving that, you noticed that there were outstanding motions, and so you scheduled those, and those were heard on January 11th?
Yes, that's the one that was supposed to be heard in November, but it got rescheduled because my mom died.
Okay. And so your recollection is, or do you recall getting a second notice from the JQC on that matter about outstanding orders?
Yes, that's why I said the January letter.
Okay, so do you think it was before the hearing?
I don't have the letter in front of me. My recollection says January 17th, but that may not be correct. I'm not disputing that I got a letter. You're asking me about the date, and that's what I'm saying. I can't say with specificity. If it was January 17th, the letter came after the hearing.
Of 2023.
The letter is actually, the letter is wrong. The date on the letter says January 2023, but that letter was sent in January of 2024.
Right.
That's the one I'm talking about.
The follow-up in January of '24.
Yes, ma'am.
Okay.
I just don't recall the specific date. So I think it was the 17th. It might have been the 20th, but what I recall is that I got the letter after the hearing.
Okay, and then what you're saying is you would have completed that case based on the parties representing that everything was taken care of with that final order before you got that JQC notice?
No, that's not what I said.
The subsequent one?
The January one?
Yes.
No, ma'am. Okay. The hearing was scheduled for November. It was canceled. Let me go back. I got the first letter July 20th, I think it was. That's when we go to the docket and see the motions and the response requesting a hearing that were never sent over as a courtesy copy. I did have them double check to make sure a courtesy copy was not sent. We then schedule the motions for a hearing. That hearing was supposed to take place November. Like I said, it got canceled. So then they rescheduled it for January. I believe it was January the 11th. My recollection is that the JQC letter came after the hearing, like a week after the hearing. I gave the orders to my staff to enter, and that's when Ms. Platt, the gall, emailed and said that that she was asking for another hearing. So then Ms. Platt, in short order, emailed back and said that the parties had come to a resolution and they were working on a consent order to submit. So the orders that I had done did not get entered because of that email correspondence with Ms. Green. Correspondence with Ms. Green.
Okay.
And then once they sent the consent order, which I can't tell you when they sent it, but I can tell you I entered it March.
Okay.
I believe it was March 5th.
2024? 2024?
Yes, ma'am.
All right. All right, I want to show you some of the emails that I referenced earlier, so I'm going to pull up Joint Exhibit 13, 14, and 15. I've got J13 pulled up here. So in this email from Eric Chambers, who is a family law attorney, he indicates that he is sending along the proposed order that he's been attached to prepare. That goes to Ms. Bush, and it looks like he has also attached the briefs that had been filed previously in this matter, and this is complaint 2021 CV 344581. The 24 charges, paragraphs 58 through 62. Did your staff attorneys understand that when people contacted your chambers about the status of their cases, especially lawyers, that they were supposed to respond to those inquiries?
Yes, my rule is everything gets a response. I'm big on customer service.
Okay. So I'm scrolling up, and we're at Tuesday, October 5th of 2021, and it looks like somebody is following up on the below emails and the attached orders. So in a situation like this, where you have several months that have passed, is this something generally that you would have been notified about? Because it seems like the party submitted the orders and then several months have passed and they're inquiring again.
No, they generally didn't tell me, like when people were emailing. So, not necessarily.
So in this circumstance, you said earlier that generally you would want, proposed orders to get to you after your staff attorney has either prepared them or reviewed them within 2 weeks to 30 days, right?
Generally, yes, ma'am.
Okay, and we agree that this one is well outside that timeline.
Based on those dates, yes, ma'am.
Right here, so Ms. Bush responds, and this is October 5th of 2021, and she lets the parties know that she has received their correspondence and re-forwarded the proposed orders for Judge Williams' review and consideration. So that seems to indicate those proposed orders had been sent to you previously and that they were with you awaiting decision. Is that correct?
I have no reason to doubt that.
Okay. Do you remember this case specifically?
The facts of the case?
The Miller versus Miller case?
Yes.
Okay.
I believe this was a declaratory judgment case, is that right?
It was.
Mm-hmm.
Okay. And are you able to tell the panel for how long those orders sat with you without decision?
No, ma'am.
Okay. Was this a common occurrence where you had proposed orders and they would sit with you for a few months without decision or much longer?
I don't think so, no. Has it happened? Yes. And I will also say, there was a point where I switched to telling them they needed to print them out and give them to me because of the number of emails that we get. I will say that there are some emails I didn't see or that got just kind of caught up in email, and so I did not see them. You're looking, we had, the way the system works, and especially this was during COVID, for instance, if I check my email at home, it doesn't necessarily show that I checked it at work. And so, like, there were, like, all of these different variants, so to speak, depending on where I was checking the email from and which computer.
Okay. All right.
Did you not ever instruct your staff attorney and say, hey, this is a 6-week, from October 5th to November 22nd, looks like about a 6-week time frame. Is your staff attorney not instructed to say, hey, Judge, I've received now 2 emails about this. Maybe it's time that we look at it and issue orders? Or did you just rely simply on email communications that you may have missed.
No, we did. I believe that time period is when the change between Ms. Bush and Ms. Bush and Ms. Bowles.
Okay, but,
Did you say October 5th and November?
yes.
Yes, that would have been during the time change between the two of them. So that's why I said I will say a lot of stuff I later found out that transition was not as smooth as I hoped. Ms. Bowles actually started a week early unofficially so that Ms. Bush could train her.
Okay.
But I don't know what happened with the documents. I was told that she was given a list, but then I was subsequently told by Ms. Bowles that she wasn't given a list, so I don't know. But that was my instruction, was to give a list.
All right, let's talk about Mr. Storch's case, and for reference with the charges, this is the 24 case, page 24, beginning at paragraph 92. And Judge, I understand that this is one of those cases that you inherited, and Judge Edwards had presided over the original final hearing and entered the divorce decree, and then part of that came back from the Court of Appeals. And so with this line of questioning, I understand that piece of it. And I think those are all things that you've admitted to. You inherited the case, and you ultimately presided over a hearing on a second motion for new trial that was submitted, correct?
I believe so, yes.
Okay.
I remember something about a supersedious, too.
Okay. And in that circumstance, the respondent actually pro se, on April 26th of 2022, he filed a motion to enter judgment, correct?
I believe so.
Okay. At some point during the time that Mr. Storch in that case was awaiting a final order, did he inform you that he had filed a JQC complaint against you?
No.
Okay. Did he inform a member of your staff that he had filed a JQC complaint against you?
I believe so.
Okay, so let me ask it this way. Did you at some point become aware that he filed a JQC complaint against you prior to receiving notification from the JQC?
I believe so.
Okay, but you don't remember who told you or how you found that information out?
It would have been from one of my staff members. I can't tell you which one it was.
Okay.
It's information overload with those three. Well, four, including my court reporter.
I certainly understand. And you mentioned that Mr. Storch came up to the court, correct?
Yes.
And was that on more than one occasion?
I only interacted with him on one occasion, so if he came more than once, I'm not aware of that. And I do recall sending Ms. Bowles an email asking her to review the orders that he gave me. He was pro se, and we'll draft the appropriate orders. I do recall sending her an email saying that.
Okay. All right, Judge, the email you just referenced was actually provided to me in discovery by your lawyer, but because I have questions about it, I'm going to go ahead and enter it now. And,
Okay.
So I'll walk up and show you this is
No objection.
P4.
Okay, then without objection.
And is that the email that you were referencing in your testimony?
Yes, ma'am.
Okay.
P4. Not in your notebook. Those are just joint exhibits. But it's coming up here.
Oh.
All right, so I want to direct you to this top portion of this email.
Mhm.
And it's cut off the way that it printed, but this is from,
I'm sorry, can you not put my email address up there?
is your email address not public record?
No,
It's not on the state bar directory?
I don't believe so. Is it? I don't believe so.
Well, the exhibits aren't, I mean, they're only people who can see them right now are us.
Oh, okay.
And I'm the dumbest guy in the room, and I could figure it out, but if I didn't know it, I could figure out your email address.
You'd be amazed how many people swear they can't find my email address.
Well,
But go ahead. I'm sorry, I didn't know that we could only see them. Go ahead.
I would take issue with you being the dumbest one.
Maybe the second dumbest.
Yes, ma'am. What was your question?
All right, so this email from Ms. Bowles on Sunday, November 6th of 2022 at 4:09 a.m. She lets you know, hello, please see the proposed order that Mr. Storch submitted. Mr. Storch was a pro se litigant, correct?
Yes, ma'am.
So you all had him prepare proposed order?
No, ma'am. Mr. Storch prepared those orders on his own accord
Okay.
and presented them subsequent to the hearing.
Okay. So you then in response, I guess it's November 10th of 2022.
Uh-huh.
You respond to Ms. Bowles and you say, please review this case and draft all appropriate orders. Have it to me no later than 12/2. What prompted this email to Ms. Bowles, giving her this deadline for when to get these orders to you?
Her email?
Okay. Did she get them to you by the deadline that you put in there?
No, ma'am.
All right. So did you then go follow up with her about the status of the orders?
No, ma'am. Well, not at that time, not 12/2. I subsequently did follow up with her. I don't recall when that was, but not immediately after 12/2.
Okay, so how did you keep track of, when you gave your staff a deadline like this, you tell her 12/2, have it to you, how did you ensure that those deadlines were being met?
Normally, I would ask them about them. If I didn't get it and I had a tickler, I will tell you this time period is after my mother gets diagnosed with cancer. So my mother got diagnosed November of 2022, and they told her she wouldn't live to the end of the year, through the end of the year, excuse me. So that period is a little bit of a blur, and I fully admit that I did not follow up on things as I normally would have, or as I had done in other situations. She began her chemo treatment shortly after this email.
You know, Judge, I'm certainly sympathetic to that, but what I'm trying to figure out is how much were you supervising your staff and following up on the things that you had assigned to them when they weren't being done?
It depends on what time period we're talking about. Candidly, when my mom was going through chemo, like, I trusted my staff to keep things moving. I was spending the night in hospitals. I never once canceled a court hearing. In fact, some court hearings I did from the hospital, just with a blurred background. So I can admit that during that time, I was not laser focused on the caseload. I was laser focused on my mom.
When you met with the investigative panel, I'm assuming you met with the investigative panel or the director
Yes, ma'am.
more than once?
No, ma'am. I mean, I'm sorry.
That's all right.
Yes, sir. No, sir.
Yeah.
No, no, sir. I only met with them once, and at that time, the only pending issue that I was made aware of or that I had received any correspondence on was the issue with Miss Brandy Alexander.
Okay.
But you were notified in writing of each of these complaints and asked to respond to them in writing, correct?
That was after all of this, but yes.
Right,
I think your notification came July of 2023, if I'm not mistaken.
okay. My point is that you were given the opportunity to respond in writing to every complaint that's contained in these formal charges.
I'm not disputing that. I didn't dispute that. I believe Mr. Hyde's question was if I met with the panel
I
after that.
understand.
Just so you know, Judge, your email is on the Georgia bar.
Oh, is it? Okay, thank you for letting me know.
All right, so ultimately, you get around to entering an order in Mr. Storch's matter, and that was on May 30th of 2023. Do you recall Mr. Storch coming in person to your court before you entered that order, and you saying to him that him continuing to show up and ask about the status of the order was not helpful to him?
Yes? I had not seen him before. The staff told me that.
But you saw him at some point and you told him?
That day, whatever day that was, I don't know what day it was, let me say that. But whatever day he came literally into the courtroom.
Okay.
And then they came from the back and told me that he had come up there before.
Because he was trying to get an answer about the status of his case?
Yes,
Okay, and you told him coming up there was not helpful to him?
no,
You didn't say that?
I did say that.
Okay. What would you have somebody in his position do?
I'm not quite sure.
Well, he sent emails that the panel has. He's come up on more than one occasion, and then you tell him this is not helpful.
And I believe, to answer your question, what I believe I said to, and what I know I said, not believe, is that I was working on the order and that certainly I was trying as fast as I could to get the orders out. That's what I recall saying to him. And that it was not helpful for him to continue to come up there because the staff also said that he had some not so nice comments to them. And so I also told him that he was not to threaten my staff, that he was not to be rude to the staff or anything like that. I understood his frustrations. However, that was not appropriate conduct. And if I remember correctly, the deputies had to escort him out because he got a little bit belligerent then.
All right, so you said you issued your final order May 30th of 2023.
I don't know the date, but if that's what the file stamp copy says, yes.
Okay. And that is Joint Exhibit 28, or I'm sorry, that is Joint Exhibit number 27.
Now, what I can
For the
tell you
panel.
about that is May 30th, that's the day before my birthday, so I promise you I did not give that order to them on that day. I probably gave it to them a week or 2 weeks prior because I'm generally not in the office on my birthday or the week thereof.
What do you do for the whole week for your birthday?
Take it off
Every year?
every year and have done so since I started practicing law.
Interesting. This order says that it was signed by you May 31st of 2023, and I'm showing you J27.
I don't have it on the screen, so I can't answer. Scroll down, if you please.
We agree it was filed May 30th of 23.
Do you authorize others or your staff to sign your name or use
Yes,
it?
sir. And you can tell that that's not my wet signature. That's my signature that they have on their computers.
Okay. So you issue that, and was your understanding that concluded all of the outstanding issues in Mr. Storch's case?
Yes.
Okay. So on the same day,
I issue a recusal
right, a few hours later, why did you issue a final order and then a few hours later enter a voluntary recusal order?
because of the one judge, one family rule. And so to the extent that he filed any further motions, pleadings, et cetera, based on his conduct, the JQC complaint, et cetera, I thought it would be best to recuse off the case.
So the appearance of bias, prejudice, unequal treatment, and impropriety, what was the evidence of any of those things, if there was, that you were trying to avoid?
Isn't this after I get a JQC notice? Or maybe this was after the threat, but I did that after something happened. So either it was either the JQC or he threatened somebody in my staff, on my staff rather.
So when he threatened somebody on your staff, is that what you were referencing, where the deputy came and told him to leave?
I don't recall if that was that day, because I don't recall when he came up there. What the staff informed me is that he was always belligerent and that he would certainly say some things to them that were of concern.
So essentially your testimony is you, after deciding all the issues, a few hours later, you decide to voluntarily recuse just in case there was some other filing that would have normally come to you.
Correct.
Were you aware that there was a subsequent filing that went to Judge Ellerby and she ultimately entered an order vacating your order on the motions?
I became aware of that in your letter.
Have you read her order?
I don't remember if I read her order, honestly.
Do you remember it? Do you remember anything about reference to you should not have entered that final order in that matter and then turned around and recused yourself?
Pardon? Say that again?
Do you remember that being part of the order?
I don't remember reading her order.
Okay.
And in fact, I remember as a result of your letter that's how I found out that she entered an order. And I remember my thought process being judges can disagree. So that's her opinion. I disagreed.
When a judge recuses from a case, does the matter start over with the new judge, or do you pick up where you left off?
You pick up where you left off. I've received many a recusal.
All right, Judge, I want to now talk to you about the Molly Dennis situation.
Yes, ma'am.
That's complaint 2024-691 that's contained in the set of formal charges that was filed in 2025.
May I pause you one moment? I think we've got a request for a quick comfort break before we start into another big chunky thing. So let's take about a 10-minute
Thank you.
Stretch break, comfort break. Okay? Yeah. Okay. So we'll be back in 10 minutes. Thank you. These two have eaten lunch, so just, pick up the pace here. We're ready to turn on the live stream. Go ahead.
Is this what we're talking about next?
No. Oh, yes.
Is P5 up next? Is that why it appeared on my?
That's correct.
The transcript.
I asked that copies of that be placed up there.
Okay.
All right, Judge, want to talk about the Dennis versus Dennis matter. That's complaint 24-691, contained in the 25 formal charges, and it starts on page 2, paragraph 2. All right, Judge, in that matter, there was a complaint for divorce that was filed back in June of 2022, and that matter was assigned to you, correct? All right, you presided over the final hearing on October 25th of 2023.
Yes, ma'am.
All right, and during that final hearing, the party's daughter, Molly Dennis, testified, correct?
Yes, ma'am.
Okay. And would you agree, based on the information that was presented during the course of the hearing, it was apparent that Molly and her mother had a good relationship, but that her relationship with her father was rather strained?
Yes, based on the evidence presented and my own visual observations.
Okay. All right, I want to talk to you about closing arguments. During closing arguments, Molly Dennis was seated in the gallery. Is that right?
Yes, ma'am.
And during the arguments, something came up about the father's house or his apartment being trashed, which prompted you to want to address Molly from the gallery at that time, correct?
Yes, ma'am.
Okay. Why was it at that time you chose to address Molly Dennis?
I meant to do it at the close of evidence before the closings because I wanted to make sure the evidence had been closed. And so when they said it, it was one of those things of, and while we're talking about that, let's talk about it now. It was prompted by whatever counsel said.
All right, Judge, and just in case something comes up, much of this you've admitted in the formal charges, but I've got an excerpt of the transcript of the relevant exchange that's been marked as P5.
Thank you.
And then this time I've moved to tender P5.
All right, it's in.
All right, and there was some testimony during the course of that final hearing that at least what came out was that Molly had broken some things in her father's apartment. Is that correct?
To put it mildly, yes. She broke some things, like she literally testified to taking glass or ceramic things and throwing them on the floor, cutting up his mattress, cutting up the curtains or wall treatments. She talked about, I think she talked about like slashing the mattress, the bedding. She took his Rolex or a couple of pieces of jewelry. She also took some paperwork that she was trying to get for her mother and things of that nature.
And based on my reading of the documents related to that case and the portion where you were speaking in the transcript, it was apparent to me that you suspected that the mother was perhaps more involved or was actually present, and there was some testimony that she was not. Is that accurate?
Yes, the testimony was that mother was in the car while Molly was in the apartment. Dad was out of town. Molly had called and asked if she could go to his apartment to get something. He said yes, and then she went in and did all of that.
Okay, and you said you wanted to address Molly at the conclusion of evidence, but you forgot, and that's why you did it when it came up in closing, right?
Correct.
Okay, why was the first thing that the second thing that you said after you asked Molly to stand up in the gallery, why was it instructing the deputy to put her in custody?
Shock value.
You wanted to shock Molly.
Yeah, so again, you've got to take into consideration everything. During the course of the trial, Molly was very flippant. Molly was very, what's the word I would use? She was flippant. She and her mom kept looking back at each other, even though I'd admonished them to stop doing that. They would be laughing and giggling during the course of testimony, and especially when Dad was up testifying. They were making faces. Molly was sitting in the back. Mom would literally keep turning around and shaking her head, and Molly would, be making gestures and whatnot. And so it was conduct that was not appropriate, and I'd admonished them several times, hey, stop doing that, and they did it a couple of times. And so, again, because I didn't want to be disruptive to the proceedings, I was just going to wait until everything closed to speak on it.
Do we have the part of the transcript where you were reprimanding them? Was that,
No, it's not in this, sir, no.
okay.
The transcript is, I think, about 400 pages long, if I'm not mistaken, correct me.
If the panel wants us to pull out that portion of the 400 pages,
I'm not trying to tell you how to prosecute, I'm just wondering what it says.
we can certainly do that.
Page 298.
Yeah.
But like I said, she was really flippant, defiant, and just unruly.
Okay, and she was 22 at the time?
She was 22 at the time.
Okay, and so you viewed it as your role to shock her by having her placed under arrest while she was sitting in the gallery of the courtroom.
I did not place her under arrest,
Okay.
but I was trying to help her understand the consequences of her actions, what she said, what she did, how she was acting, etc.
So when you tell the deputy, put Molly in custody for me, you don't think you're stopping her freedom of movement and so the deputy's putting her under arrest and you had nothing to do with it?
No, that's not what I'm saying. What
Okay,
I said,
you said you had nothing to do with arresting her.
I didn't think I said that. Did I say that?
She said she was not under arrest.
Oh, yeah. she
Oh,
wasn't
okay.
arrested.
I was like, I'm sorry, I didn't mean to
So-
say that.
So if you order a armed agent of the government to take into custody a citizen, what was the deputy going to do if the citizen had said, I'm not going with you?
So I said that for shock value, like I said.
Okay.
It was not my intention to put her in custody. And if you read through the exchange, I actually, at the end of it, I said, show her the cell, right? And so then they show her the cell. She subsequently comes out, listen, the hindsight being 2020, I wouldn't do it. I was really trying to help her understand the consequences of her actions. There was a whole lot that happened during that trial that is not encapsulated in P5. This family was in a position of turmoil, in a position, it's one of the most high conflict cases I'd ever seen. Part of the issue was that mom was a psychologist who had a rumored sexual relationship with two of the son's friends, and the son also testified. The kids weren't talking to each other or talking to the other parents. So there was a whole lot more going on than P5 or the charges
Judge,
talk
you
about.
understand she was under arrest the minute you told the deputy to put her, take her into custody. You understand that?
That was not my thought process, that she was under arrest. I brought her to the front, actually, so she doesn't even go immediately to the back. I brought her to the front. She was standing at the lectern, and I had a conversation with her. So, like I said, hindsight being 2020, I would not have handled it that way, but my intention was not to put her under arrest. My intention was not to take her into custody. My intention was not to hold her in contempt.
Your words are, put MD in custody.
I don't disagree with you, sir. That's not what I'm saying.
Okay, hold on.
And that's,
Hold
okay,
on.
sorry.
Hold on. She is not free to go from the minute the deputy takes her into custody till how long was she in the holding cell?
There's a dispute about that.
Is it how, okay, what's your understanding of how long she was in the home?
That she was in there maybe 15 minutes, but that's not what the formal
She's
charges
not free
say.
to go, I'm gonna take your 15 minutes, I understand the charges are 30 to 45 minutes, but I'll take your 15 minutes. She is not free to leave for the entire period, from the time you say take her into custody to the time that she's taken to the holding cell to the time she's being brought back. She is not free to go, correct?
No,
Okay. That is an arrest.
I understand what you're saying. What I am saying is, in my mind, there's a difference between a detention and an arrest. So when we talk about arrest, that's why I just said, no, she was not under arrest. She was being detained, yes. But again, it was not my intention to hold her in contempt because I was trying to avoid that. I was just trying, go ahead.
That's my next question. Then what's your authority to even take her into custody for any period of time? You were a prosecutor for a very long time. I think you understand the rights of a criminal defendant in a courtroom. She wasn't given her Miranda rights, correct?
No,
She was not afforded an attorney, correct?
no.
She was not told what she
Oh,
did.
wait, sorry.
Oh.
Let me re-answer those because I'm answering them in an ambiguous way. Correct.
Okay.
Sorry.
Right. She didn't have an attorney. She was not told, I'm going to potentially hold you in contempt. Here's notice of a hearing. Go get a lawyer who might be able to represent you to answer these charges. She was not given any of those rights.
Correct, because I wasn't trying to hold her in contempt. I was not trying to take it that far.
I understand that, and that's
But contempt would have been illegal, wouldn't it?
that's
Isn't that the
point.
procedure the legislature gives to judges for that type of conduct?
I didn't hear the first part, I'm sorry.
Contempt would be the appropriate handling, as I would think. If somebody does something in your courtroom in your presence, you have a tool to use, don't you?
Yes, but I was trying
But
not
it
to.
is not false imprisonment of a citizen, is it?
No, but that's why I keep saying that was not my thought process, that was not my intent. And if I had it to do over again, and that situation has happened, and I don't do that. I have not done that. And again, hindsight being 2020, I really was just trying to help her understand, listen, you can't do these things. You can't act the way you've been acting. You can't do those things in court. There was no intent to deprive her of her liberty, to violate her rights or anything like that. Literally, I was just trying to. The road to hell is paved with good intentions.
I'm not questioning your motive.
I understand that. And so, it's like Judge Russell used to say, when you try to fix things, that's when you get in trouble.
I've heard her say it 100 times.
And that's where that came from. I was trying to help her understand, hey, you can't do certain things, right? You can't act certain ways. So again, I was wrong. I don't dispute that. I was wrong. But that wasn't my intention.
Gotcha.
Judge, we agreed that you could have given her a speech on her behavior, the way she conducted herself in front of you, and the fact that it wasn't okay, without calling her up and reading down a list of criminal offenses that you claimed that she admitted to committing, and then intimidating her by suggesting that she could have gone to prison for 35 years, right? None of that was necessary. You could have made your point and given your speech without doing that. Do you agree?
I think the speech was part of that. I would say was not necessary is me saying show her the bag. But I do think that it is appropriate that she understand, hey, based on what you got up here and said, these are the things that you just said you did, right? I need you to understand the consequences of what you just got up here and said. Again, I could have dealt with the situation differently. I would have dealt with the situation differently, hindsight being 2020. I apologize to Molly because that, at the end of the day, it was my intention, it was my desire, it was my thought process to try to help this. And there were some other things that happened in the trial. She had dropped out of school. It was a whole lot of other stuff that's not encompassed in this. So all of that was in my head and really trying to come from a place of like, Molly, you can't do this. You're a good kid, but you got to make better decisions. Just like I'm saying to me, hey, you're a good judge, but you got to make better decisions. And so that's where that was coming from.
What are we to make of this woman, this girl having committed these crimes that you talk about? Did you notify the police or the district attorney that there's a woman here that
No,
committed all
absolutely.
these crimes?
Absolutely not. That wasn't my thought process. I didn't want Molly to go to jail.
So if somebody in your courtroom gets up and says, I killed so-and-so, You don't think you should have them report that to the prosecutor?
Well, that's a little bit different.
Well, it's not to me.
I killed so-and-so.
Pick the crime, whatever, burglary. Somebody
This-
says, I burgled so-and-so's house. Do you have an obligation to get it reported to the police?
In this context, no, I don't
Okay.
believe so.
I don't know
If
what
I recall
context you
correct,
mean.
pardon?
I don't know what you mean by in this context.
If I recall correctly, there was a police report and it was reported to police, I
Gotcha.
believe, but I would need to see the transcript. But I do recall that there was some report to the police.
Okay, good.
I'm sorry, you all asked some of my questions. Oh, Judge, you indicated that you apologized to Molly.
No,
You just testified and said that you apologized to Molly.
no, present participle. I apologize.
Oh.
Current, now, like, I apologize, like, that was not my intention.
Okay, so now today you apologize.
I don't understand your
You're
question.
apologizing here today.
When she gets here, I have no problem apologizing to her.
Please don't. All right,
Oh, hold on, sorry, I'm confused.
That's so argumentative, I don't know.
Which part are you saying argumentative? The please don't or the question? I do agree with that, and so I would sustain an objection. So just so we're clear, you have not ever apologized to Molly. When you said, I apologize to Molly, you mean you're saying, I now apologize to Molly.
Yes, ma'am.
Today, here, May 21st.
Correct. And what I was saying, what we're trying to say was, I have no problem when she gets here apologizing to her, because again, it was not my intent to do any harm. Let me say
Okay.
it that way.
Yeah, no, I just, thank you for clarifying
Yes,
that, because
ma'am.
I understood
I
that you,
understood too,
the same
yeah,
way,
same
yeah.
way.
So, okay, got it.
And I think when she comes back out, I have another conversation with her, and I talked to her again about why I did certain things and did what I did, and how she needed to make better choices, et cetera, et cetera. I'm not gonna go through it, y'all have it, but after she comes, I think that's in this, is that in this portion?
I don't know, but if you want to ask your next question, Ms. Fields, we can try to get ourselves kind of back on track here.
yep. You agree you had no legal authority to do what you did and have her detained and placed in the holding cell?
As I stated, I agree. I was wrong. I would not do it again. I have not done it again. I'm not going to do it again.
But what are we to do? I mean, if this was the only thing you were charged with, what would you propose an appropriate sanction, if anything, would be from the hearing?
I think an appropriate sanction would be for me to have a reprimand. I think an appropriate sanction would be for you to say, hey, you need to apologize to Molly. Like I said, I have no problem. Like, young people are my passion, y'all. Young people and old people. So that's where I was operating from. I have no problem doing that.
We have to look at it. We've had other judges come through here that have been charged with similar conduct
Yes, sir.
of detaining people with no authority. I mean, there's precedent for it, so that's the thing I'm the most troubled by, is that conduct.
And I understand that completely, and I would be too, if I'm just looking at it in a vacuum. And in no way am I making any excuses, in no way am I saying I wasn't. That's why I tried to unequivocally say I was wrong. I would not have done it again, or would not do it again. And had I, hindsight being 20/20, I would not have done it that way. But again, I was just trying to, it was shock value, and I was trying to help her understand, listen, but y'all got it. I'm not going to repeat myself, so.
I don't question your motives, but I use the trooper standard. If a state trooper did the same thing on the side of the road with a citizen, what would the state patrol do to the trooper?
Were you asking me? I'm sorry.
No,
think
I'm
that
just.
was
Oh,
spouting
okay. I was like, was it rhetorical? I didn't want to not answer your question.
Next question, Ms. Field.
My last question on this subject, you just said you are troubled by this too. At what point did you become troubled by it?
I was troubled from the beginning by everything that was going on. Like, you had to be in that
No, no,
courtroom.
no.
Huh?
Troubled by your having her jailed and detained without any legal authority. At what point did you become troubled by that?
Are you asking me at what point I saw issue? Is that what I don't understand your question. Because I just tried to answer how I thought you were asking it, and you interrupted me, so.
So, Mr. Hyde was telling you that he was troubled.
Correct.
Very troubled by this allegation, this conduct. You said that you are as well.
Mm-hmm.
And I want to know at what point you became troubled by your own conduct.
I became troubled by my own conduct after all of this came about, before all of this came about, during all of this being about. I don't really know how to answer your question. It troubles me that Molly feels, and I'm just going based on what you said, it troubles me that Molly feels victimized. It troubles me that Molly feels, all of that troubles me because none of that was my intent. So all of that troubles me. And it is never my intention for any person to leave my presence, whether it is as a litigant, a lawyer, etc., feeling not in a safe place. In fact, that's one of the things I try to do in all of my hearings is make sure when folks leave, they leave in a safe space. So you will hear me say, do you have any questions? I routinely do that because I don't want, and I routinely overexplain as I say it to litigants because I try to treat people the way that I would want to be treated if it were me on the other side of me.
Did you think a safe space for her was the holding cell?
If you look at that's not what I just said, Ms. Field.
Okay.
I said I try to leave people in a safe space. And if you look at my conversation with her after she's brought out of the holding cell, I think that gives you more context as to that exchange and that interchange, so to speak, between Molly and I, and me explaining certain things to her.
You have said here today, that you, in hindsight, you would have done things differently. At what point did you have a thought, ooh, you know what, that wasn't good, I should do that differently? At what point in time, the timeline of events, this hearing happened and...
After I got off the bench.
October 25th of 23. So right after you got off the bench, you felt that way.
I didn't say right after I got off the bench. I always am introspective. Like, what could I do differently? How could I be a better judge? That's just the type of person I am. I'm always seeking to be better, do better, etc. So literally after almost every hearing, I sit and think, okay, what's going on? What could I have done different, better, etc. In this whole space with the formal charge, not the formal charges, the failures to rule, I have thought about what could I have done better. With the situation with my uncle, again, I've thought about what could I have done better, what could I have done differently. In the situation with Ms. Alexander, same thing. Like, I am ever growing and ever evolving. I want to be a good judge. I am a good judge. I want to be a better judge.
Okay. So
And I strive to be the type of judge that I would want to come in if it was me on the other side. That's my heart.
Okay. So if you started reflecting in that way after the hearing involving Molly in October of 2023, I'm a good judge. I need to make better decisions. I want to do better. Let's fast forward to April 22nd of 2024 and a complaint involving your uncle's contempt case. So that is complaint 24-960 on page 6 of the 25 formal charges, beginning at paragraph 17. So, on that day, April 22nd. Okay. Yeah.
She just, I just want to get her some tissue.
Oh, that's
Yeah,
fine,
of course.
sure, please. There usually is a box up here, but I don't see any.
Thank you.
Is this court?
I do. Hopefully, this one real good.
Did you get your water? I think there was, do you need a bottle of
It's
water?
on the left of that computer screen. Do you need to, Judge, are you good to proceed, or do you want to take a recess?
I'm okay.
Okay. April 22nd, 2024, did you call the shoemaker firm?
I did.
All right? And you're familiar with that law firm, correct?
I am.
They do family law here in the metro area?
Yes, ma'am.
Okay. What prompted you to make that phone call on that day?
An issue with my uncle. My grandmother was literally transitioning. Sorry. They called me at work and told me that she wasn't going to make it through the night. I was the presiding judge that week. Literally dropped everything I was doing and went to her house. She lived at the time about 5 to 7 minutes from the courthouse. Didn't leave her side. While I was there, the papers came in. They handed me the papers. Like, I literally did not leave her side, didn't sleep. Like, was just next to her hospital bed the whole time. First time I left her side was when I went to court to start the jury trial, because I didn't want to continue the jury trial. That morning, it was just a lot going on. Family was in and out the whole time. People were coming to say their goodbyes, etc. And it was a really hard time for my family because my uncle died June of 2023. My mom died November 2023. And now my grandmother was transitioning. So I can tell you, like, in that space, I was just trying not to fall apart. And everything kind of like falls on me. In fact, those were the first words my aunt said to me when I told her that my mom died. Her very first words to me were, you know, everything falls on you now. Because my mother was the one who took care of all of that stuff. And so, speaking of reflection, hindsight, like, I recognize that my mother was very much a barrier and a buffer, so to speak. She was the person who, like, when folks would call, because, you know, it's natural for folks to call and say, oh, you know, this is going on, what should we do? My mother was that person who always was the barrier between me and other people, and this was the first time that barrier wasn't there. I just came to this realization last week as I was sitting preparing. I was like, what the, excuse my language, but what the hell was I thinking? And it was just a lot going on. It was a complete lapse in judgment. I should not have made the phone call. In my mind, I was really just trying to, going back to that fix something, I was trying to just fix it because everybody was just, he was distraught. Like, it was a lot going on. I can't describe it other than that. And my grandmother and I were very close. My mother and I were very close. And realistically, I recognize that I haven't even really had the time to grieve. So that's why it's hard for me to talk about anything with regard to my mom or anything with regard to my grandma without crying.
And I understand it. In fact, I think I shared with you that my mother was diagnosed with cancer out of nowhere and died 6 weeks later, Judge. So I'm certainly sympathetic to it, and I'm sure the panelists are as well. You said that when you were with your grandmother, somebody brought in some papers. Are you talking about a family member brought to you a petition that had been brought to that house, the petition for contempt?
Yes, the doorbell rung. My aunt and I were both walking to the door at the same time. Like I said, this was that time period where folks were coming in and out of the house to visit her. My aunt got to the door first, so I turned around and went back. And then she brings the papers in and she hands me the paper and she was like, you know, she said something about legal papers. And again, because I was my grandmother's power of attorney and she's handing them to me, that's what I thought. It was something regarding my grandmother. So I opened them up and saw that it was regarding my uncle. He was not there at the time. He didn't even live there. So I called him and I said, hey, these papers came for you. And he said he was on his way back. Came back and I gave him the papers. Excuse me. He told me what was going on and I was like, oh, okay, because he read the papers, so that's what I mean by he told me what was going on. He said that he had not gotten the papers prior to that. And I said, well, it looks like your time to respond is coming up in a couple of days, so you need to do something. So again, it wasn't my intent to do anything nefarious or anything like that. And in fact, literally after I talked to Ms. Stinson, I didn't even know what happened to the case. I didn't call her again. I didn't call Judge Farmer. I didn't talk to Judge Farmer about it. I didn't even ask my uncle what happened about it. Like, I didn't. So I didn't even know what happened until these JQC charges came and I saw the disposition in the charges, and that's how I found out what happened. So I had no clue that he didn't even follow up or do whatever he was supposed to do. I didn't know. And to this day, I still have not talked to him about it.
Okay, and so in relation to the day that the papers were served and the day that you just described, how soon after that did you call the shoemaker firm?
Like a day or two. He said that he had called the VA and he was trying to get the documentation, but he couldn't get the documentation. And so I told him he needed to keep trying.
Okay. Do you have reason to dispute that the date of service on the docket is March 24th of 2024?
I didn't look at the docket. I didn't say the papers were served that day. I said the doorbell rung and my aunt brought the papers in. It was the return of service. That's what it was, along with the papers. That's why I said to him, your date to respond is in a couple of days. You need to get going on this. He had not gotten the papers because, again, he didn't live there. But that's where they were served.
All right, and the call to the firm was April
Monday.
April 22nd of 24. Does that sound right?
If that was the Monday, yes.
Okay. When you glanced over the papers, you saw that Patricia Shoemaker was listed first as the attorney at the bottom, correct?
I don't remember who was listed first. I would assume so, just by partner or associate, but Bonnie's name was the signature on the papers.
Regardless of which one you saw first or which one was first, we agree that you recognize both names were on the papers, Patricia Shoemaker and Bonnie Stinson, correct?
Yes.
And both of those attorneys had appeared in front of you, correct?
Yes, multiple times and in various capacities. Ms. Shoemaker is also a Gaul, so she'd been before me as an attorney and a Gaul.
Okay. And you knew that Ms. Shoemaker was the partner on the case, correct?
I know that she is a partner. At that time, I did not know Ms. Stinson's categorization, so I didn't know if it was two partners, one partner. I didn't know. But I knew Ms. Shoemaker was a partner, yes. I really should say owner. It's Shoemaker and Shoemaker. It's she and her husband.
All right. So you call the law firm that day and you tell the associate that you would like to speak with Bonnie Stinson, correct?
I didn't speak to an associate. I spoke to the
I'm sorry, the receptionist.
Yes. Mm-hmm.
So you specifically requested to speak to Ms. Stinson?
Yes, ma'am.
All right. Why did you pick Ms. Stinson to ask for instead of Ms. Shoemaker?
Her name was the signator.
All right. And you asked that she call you back on your personal cell phone after 5 o'clock, correct?
Yes.
And did you tell the receptionist what you were calling about?
Yes, I said it was a personal matter. That's why I gave him my personal cell phone number.
At the time that you called, the shoemaker firm had at least one case pending before you, correct?
I believe so.
Did Ms. Stinson return your call?
Yes, ma'am.
Once the two of you ended up speaking, about how long do you recall that call lasting?
I don't know. Like, I can't even give you a ballpark. I know it was after court. It was after my jury. I released my jury, so I don't know.
Okay. What did you tell Ms. Stinson when you all began the conversation?
I told her that I was not calling in my official capacity as a judge or my unofficial capacity. I told her that my uncle had gotten served with the papers. I told her that I don't remember the order of the conversation, let me say that. At some point, she asked me about my mom, because it was widely known. We talked about my grandma. I told her that my uncle, that I was given the papers, that my uncle was trying to get together whatever documents needed for them to have whatever conversation they needed to have. And based on what he said to me, this is what it is. And I specifically said, I don't know. So here's his information. I told her that he did not live at that house. However, he said he was not going to challenge service or anything like that. I gave her his information. I asked her if it was okay if I gave him her information. She said yes, and that was the gist of it, high level.
So you didn't call as a judge,
In my mind, but I now know you can
But
never
you-
take your judge hat off.
but you called while you were judge, not as a judge.
Oh,
but while
yes,
a
sir.
judge.
Yes, sir.
Did you look up the case before you made that phone call to ensure that it had not been assigned to you?
I didn't look it up. I had somebody else look it up.
Okay. Because you recognized that since it had been filed in the Superior Court of Fulton County, it had to have been assigned to you or one of your colleagues on the Family Division bench.
Yes, ma'am. It was a contempt action.
Okay. And it was assigned to Judge Farmer, correct?
Yes, it was. I don't know if I knew that. I just knew it was not assigned to me, though. I don't recall if they told me who it was assigned to.
All right. So you summarized what, I guess, what you recall to have occurred during the conversation. During the conversation, did you request an extension on behalf of your uncle for the time frame to file his answer?
It's not my recollection. What I recall is that I said he may need an extension, and I said that he was trying to get the documents from the VA. That's my recollection.
Do you remember asking for 60 to 90 days, giving a specific number of days for the extension?
I saw that in his email. I don't remember if I said that to her. So I can't tell you one way or the other. What I said was that he was trying to get documents from the VA. That's what I remember saying to her. And I did not know how long that was going to take. And I also remember giving her the name of the person and the information, the phone number or email, I don't remember which one it was, for the person he said he spoke with at the VA.
Okay, so I just want to be clear. You said it was not your recollection that you asked for an extension on behalf of your uncle.
I recall saying he may need an extension.
After you used the word extension, did Ms. Stinson advise you that she did not have any authority to discuss extensions or to agree to them?
I don't have that recollection. That's not what I don't remember her saying that. I'm not saying she did or she did not. I don't remember her saying that. I heard you say that in the opening. what I recall her saying is, I need to discuss this once I get the information from him. That's what I understood. Bless you.
Bless you. During the course of the call, did Ms. Stinson ask you whether you were representing your uncle?
I don't remember she asked me that. I remember saying that I was not representing him and I was not calling in my judge capacity. So I don't remember her asking me that. I remember saying that at the beginning of the conversation when she gets on the phone. And saying, I'm calling you about a personal matter. And I also told her that my grandmother was transitioning. I told her all of that. So I said, so I don't know what he's going to be able to do given this short period of time.
Did you tell Ms. Stinson that her law firm had a reputation for being reasonable?
I don't know if those were my exact words, but I probably said she. I don't know about her law firm.
Well, why is it relevant that she's reasonable if you weren't asking her for anything?
Pardon?
Why was it relevant that she was reasonable if you weren't asking her for anything?
What I recall is telling her what I said to my uncle. I recall telling her that I said to my uncle, hey, she's reasonable, so if you need time, she may be willing to give you time. That's what I recall relating to her, what I said to my uncle. And that once you get the appropriate paperwork, y'all may be able to work something out. I don't know.
So did you say to Ms. Stinson that y'all should be able to work something out?
I recounted to her the conversation that I was having with my uncle. So yes, I said to her, I told my uncle X.
Judge, as you sit here now, do you think that was a good idea to make that phone call?
No, which is why I said I don't have a concept of time right now. I tell you, in this moment, it feels like I've been up here for 3 days.
It feels that way to us too.
Yes. And I'm not used to doing this much talking or sitting. As I said, whenever it was, no, I should not have made the phone call. No, I would not make it. In fact, there have been other situations since then with family members, and I have not done anything. And some of the judges I know, I have not done anything. Some of the lawyers I know, I have not done anything, and I'm not going to. And that's part of what I was talking about having the revelation that my mom was the barrier. I mean, the buffer, the barrier. And so part of this whole JQC process, I will tell you, like I'm someone who tries to see the positive. Part of this has been to help me grow in a lot of aspects. And so I put certain things in place, and there are certain things I just don't do. Like even my family, I was like, listen, everybody has to be an adult. Everything does not fall on me.
During the conversation with Ms. Stinson, did you argue the merits of the petition
No,
to her?
no, I told her what he said.
Which is?
He said that he had called the VA, and the VA said that he could not transfer over the benefits because he was on reserve. He was not active duty. And at the time that they made the agreement that he was a reservist, he and his ex-wife had been in the military. And so she got out before him. At the time of the divorce, he was a reservist. And so I told her that he said that the VA told him that because at the time of the divorce he was a reservist, he could not transfer over his GI. I'm sorry if I said VA benefits, it's his GI benefits because it was about the education bill. I told him he needed to get you some documentation if that's true. And I don't know how long it's gonna take him to get the documentation, which is why I gave her the name and number of the person he said he talked to. I said, I don't know.
So all you did was relay to Ms. Stinson, this is what my uncle told me about what's going on.
Correct. I don't know anything about the VA other than the horror stories I've heard, right? So I didn't know if that was correct, not correct. I didn't know anything about the GI Bill. So I just relayed to her what he said to me and said, here's his information, gave him her information.
Did you tell Ms. Stinson that if a petition like that came before you, it would get dismissed?
No.
Did you know this woman?
Yes. Yes, sir.
Did you get along with her?
Yes, sir. Yes, sir.
I mean, if she told you something, would you believe it?
Yes, sir. Well, I mean, not not just carte blanche, but like she was not someone known to me to you know how there are some lawyers that say stuff and they speak in hyperbole and you're like, oh, okay, and so it's like, oh, I need to, and versus some lawyers who have always been really straight with you, and so you're like, oh, so she was that type of lawyer.
Did your uncle ultimately email the shoemaker firm and ask for an extension?
Yes, I saw the email and the discovery you all sent. He sent the email on the 24th. My grandma died on the 25th, so I don't know what happened after that.
You said you saw the email and the discovery I sent.
Yes, ma'am.
Is that the first
I'm sorry,
time?
let me get back to the mic. I apologize.
Is that the first time you saw that email?
Yes, ma'am.
So you didn't help write it?
He wrote down what I said. But no, I did not help write the email to that extent. But did he write down what I was telling him? Yes.
So you didn't write it, but you told him what to write.
No, I didn't tell him what to write. Essentially, when I was explaining the situation and I told him about the phone call, etc., that's my assumption. He was writing as I was talking. Writing, typing, I don't know. Let me say it that way. I was not in his physical presence to see.
All right.
Judge, I want to show you Joint Exhibit 31. Is this the email from your uncle to the shoemaker firm that you were just referencing?
This is the email that I saw in the discovery. I was not copied, BCC'd, or anything on this email, so I don't know if this is actually what was sent.
Yeah, I understand. This up here, CAFN, what does that mean? What does that stand for?
Civil action file number.
Do you often see pro se litigants use CAFN in their writings?
Yes, because it'll be on the complaint. Sometimes folks note it as CAFN, sometimes folks note it as something else.
What was the education level of your uncle?
Military, I think he's a sergeant. I think. I know he had some kind of rank.
Postgraduate, what?
No, he went straight to the military from high school.
Because he writes like a lawyer.
I mean, like I said, he was writing what I was saying.
Right.
I didn't dispute that. What I said was I didn't write this email. But I don't know if he was typing, writing, I don't know. I was talking to him. I was not in his presence.
If I could have just a moment, please.
Sure.
I don't have anything additional at this time.
Okay. Question, because I've seen it done both ways. Did you all want Judge Williams to step down and move on to their next witness and save your examination for your case presentation? Or would you like to go ahead and examine her now? And I've seen it, I was going to say, I've seen it both ways, and I've seen it now and then. So what do you want to do?
I'd like to do now and then.
Okay.
If that's okay.
Yeah, sure. As long as we're not double covering, plowing the same ground both times, but feel free to go ahead and examine her now if you'd like.
Okay, thank you. If I could just have a moment.
Sure.
Yes, Phil.
She had water.
There's like 3. You still have water over there, right?
Yes,
Bottles?
yes, ma'am.
Okay. If you need more, just let us know.
Thank you. I'm trying not to drink a lot so I don't have to go to the restroom. Tap or tab? The soda? Where did you find that?
It's in plain view in this.
It is a new building, so how did that get in here? I digress. My apologies. Oh, okay.
Thank you so much. Judge, I just have a few questions for you, and then at some point we'll recall you again. We can talk a little bit more about your background and all that other stuff. I want to get to the delayed rulings first, okay? Whose responsibility, Judge, is it to ensure that timely orders and entries after final hearings are promptly decided?
Mine.
And why is it important, if you could share with the hearing panel, to enter timely orders and to make sure that after you have a hearing, why is that important?
It's important for a myriad of reasons. One, these are, especially in family law cases, these are folks who are in a position of turmoil. Generally, they're high conflict to the point when they come to trial or motions or whatever the case may be. And so it's important that the parties have some understanding of next steps going forward if it's a motion, which is why I also try to rule from the bench on most of my hearings, motions and trials. And I've always had that practice to the extent that I can. And if I can't, I try to tell them as much as possible before they leave. Because what I also recognize, I mean, even having gone through this myself, it can be daunting waiting to get to that point. And then once you get to that point, to feel like, oh, nothing happened today, that can be deflating, right? So that's one reason. Another reason is because, family law cases in particular, unlike some other type of cases, the older they get, the stinkier they get. It's not generally the case that people come to a space of kumbaya. It's generally the case that if they don't have some direction, that things can get worse. And then last but certainly not least, so the parties can close this chapter, so the family can close this chapter, heal, move on to whatever is next. Now, you're going to have your frequent flyers who are going to come back, right? But at least if they're coming back, and that's why I try to also put so much attention into my orders and be meticulous with them and make them common sense orders, such that you don't have parties coming back because they're fighting over the order says you can FaceTime the child and nobody has an iPhone, right? So that's just some of the reasons. And then at that point, like, some of those cases were so old that these folks have been in turmoil for years. And so when I first took the bench, I think my oldest case at that point was like 2014 or so. But when I left, literally, my oldest case was less than 18 months old.
I know you've talked about some staffing challenges, but who is responsible for managing the staff in your chambers,
Me.
Judge? When there is a late order or a delayed order, notwithstanding the staffing challenges, who does that fall on?
Me. When anything happens with my staff, it's my responsibility. There are times where lawyers or litigants have said stuff, and I apologize to them not knowing what happened, and then I go deal with my staff on the back end. That's not their job to deal with them. That's my job to deal with them and rectify a situation one way or the other, depending on what's going on.
I want to talk a little bit just about the uncle situation and just ask you one question concerning that.
My knee is locking up. May I just stand up? I don't need a break. I just need to stand.
Sure.
Okay, go ahead.
I know it was talked about that they had at least one case in front of you at the time that you made the call.
Yes.
Were you aware of that fact when you made the call?
I wasn't thinking about it. I'm not going to say I wasn't aware. I wasn't thinking about it. And actually, when I went back and looked, I had already had that hearing. So that was just awaiting an order.
Already had that hearing and ruled from the bench and awaiting an order, or already had that hearing and had taken it under advisement to rule?
I ruled from the bench,
Okay.
and they asked if they could submit additional briefs,
Okay.
and I gave them that opportunity.
Should a sitting judge ever make a call on behalf, no matter what the circumstances, no matter what's personally going on, should a sitting judge ever make a call on behalf of a family member to a lawyer on a pending case?
No.
All right. I want to talk to you about the mass calendar versus the smaller calendar. You talked a little bit about how sometimes you pull cases from the mass calendar to a smaller calendar, or a different track.
Correct.
What is that track?
Concisely. So when cases come into the family division, there are two tracks when you're on the domestic relations side. There's the JO track, and then there's the elected track, as I'm going to call it. The JO track is generally for literally small matters, like, so for instance, the 30-day hearing is more so about service, but especially with a lot of pro se's, they will have issues that have come up if both of them have been served. So sometimes the JOs will, handle matters there. And then the 60-day is more so about discovery. And so in Fulton County, unlike other counties, we have a set schedule in place. So every case that is not a post-family judgment matter automatically gets the 30-day. That is assigned by the clerk's office. Once they have their 30-day, then it is up to chambers and the litigation manager to schedule it for a 60-day. Now, this is where different judges will do different things. If you look at the rules, it says that the JOs handle status conferences, right? In my division, I handle all 120-day statuses with a lawyer on it. In my chambers, because I didn't see the need to have, or my division, I should say, I didn't see the need for a pro se litigant to have a 120-day status calendar. So my rule was that after the 60-day, pro se's automatically get set for trial. Of course, there's a mediation order that gets put in place in between there. So that's the JO track. Pro se's generally stayed with the JO unless somebody filed a 1004 or unless there was an issue that needed to come to me for some reason. Sometimes it was a matter of the JO may have represented them in private practice or something like that. So on my track, I handle any 30, 60, 120-day or anything beyond that status calendars. I also handle, of course, motions. My JOs also handle motions. I handle protracted motions, though, because of the volume of the JO calendar. I also handled trials that were not pro se's unless there was a 1004 filed.
In your opinion, when you pull a case from a mass calendar to your track,
Well,
from
the
the JO track to your, let me finish my
Okay.
question, Judge. I know you're a judge. But,
No, that's
I'm
not what I
gonna
was
give-
gonna say.
right
I have
now
mass
you're a
calendars,
witness.
too.
Right now you're a witness. So let me finish my question. When you pull cases from the mass calendar and put it on a different track, like you talked about in the celebrities and the transgender and the security issues, in your mind, is any party in those cases getting any more favorable treatment over the other?
No, and what I was trying to say is that my 120-day status calendars are mass calendars. That's why I was correcting that language.
Okay.
So both the JL track and my track have mass calendars. However, that's my status calendar that I do a mass calendar on. So 120-day and forward. My motions hearings, some of the status hearings I schedule separate and individually, so to speak.
Do you think it's appropriate for a judge to have anything with the nomenclature of celebrity calendar?
I don't call anything a celebrity calendar.
Well, I'd never heard the phrase before I came in here today.
I said that? I think the lawyer said that. I didn't say that. I don't call them celebrity calendars.
Okay.
I said that I removed celebrity cases on Zoom from the mass calendars.
Okay, well then, same question, celebrity cases, I don't know what that means. Those are important people?
Everybody who comes before me is important. It's more so about, like I said, people are recording it and putting it on
Okay.
YouTube, selling it to TMZ, selling it to the media. Even though we say you cannot record, it's hard to control Rule 22 on the Zoom when something is.
Freedom isn't free. I'm just
Say again?
wondering, I just have never heard a judge use anybody in our industry say a celebrity calendar, celebrity matter.
Oh, I didn't
Seems
use
like-
the term celebrity calendar, but what I was saying is that celebrity cases cases where there are sensitive subjects and cases where there may be some safety issues made known to me or known to me, those cases I remove from the mass calendar, regardless of if they're on the JO track or my track, and I schedule those cases individually. They are still in the courtroom. My status calendars are all on Zoom. So the only time I bring in folks in person for a status is if there's some other issue, like I know that this party can't use Zoom, and so I will have them come and appear in person versus trying to force them to figure out how to use Zoom.
And was that your purpose?
And I will say a lot of judges do that. It's not just me. Go ahead.
All right. And what ultimately was your purpose in removing Ms. Alexander's case from the mass calendar to the smaller track?
To protect the integrity of the Gall cases that she had pending before me. Again, as I have been on the family bench, they get really messy. They be in those cases. People file motions on stuff to remove the Gall for various reasons, motions for a lot of stuff for various reasons, right? And so what I did not want to do, not knowing what this case was about, I just knew it was a modification, because that's what she told me. I did not want for anything that was going on in her personal life to impact the integrity of the investigations that she had going on. The Galls are the eyes and ears of the court. And that's part of the reason why I have a conversation with Galls that I routinely appoint before that, because I need them to understand this is what I need you to make sure you're doing. This is what I am looking for. And part of that also comes because I used to be a crimes against children prosecutor and a sex crimes prosecutor. So in a lot of these cases, I say to them, I need you all to do more than just say, hey, I talked to the kid once. That's not acceptable in my division.
When you talked to Ms. Alexander about moving it from a mass calendar to this track that you're talking about, did you ever talk to her about the substance or the merits of her case?
I never discussed the substance, merits, facts, or anything about the case.
As you sit here today, would you have made that call?
Absolutely not. I would have given it to Will or to Janelle or to Soraya and said, please call Ms. Alexander and see if she knows what case this is about, or have done like I know some other judges do, who say if they didn't give a good message, then they'll have to call back.
During the call, did you invite Ms. Alexander to have her attorney join the call?
I did.
For what reason?
Because again, I wasn't trying to do anything nefarious. I was trying to explain the process for why we could not transfer the case to a senior judge. We don't transfer cases to senior judges. Either there's a bench ride recusal wherein it is the case, meaning that it is transferred to another jurisdiction to handle, and we have nothing to do with that. With senior judges, we bring them in for a discrete task. We pay them by the day, as we discussed earlier, and so they are literally handling whatever's on that day, that calendar for that day. They are not overseeing any kind of case or case management of such.
You made a comment, if I can go back to your testimony. On the bond of our oath, I think it was in response to Mr. Hyde's questions concerning what the shield meant. And so I need to kind of ask you about that, because I don't want to leave them with the impression of a wondering mind about what that really means. What does that mean to you as a member of Delta Sigma Sorority Incorporated? Delta Sigma Theta
I was going
sorority.
to say, did you really just
I'm
not
sorry.
get it?
I'm
right?
sorry.
He's
Look,
also a member of a Greek organization.
I'm
That's why
sorry.
I said that.
And I just made it, you know. Okay, I'm sorry. But what does that mean to you?
What does on the shield mean to me?
What is on the shield? I mean, at some point you described it on bond of our oath. I mean, what does that mean?
So that was when I was trying to impart to Mr. Hyde, like, without saying the sorority secret, so to speak, of what it means. But I'm trying to, like, I don't, that's.
Let me ask a
okay.
better question. Is there anything about this oath or your membership in a sorority that is going to influence your decision as a judge?
Absolutely not. I have deltas appear before me all the time as litigants, as lawyers, as jurors, and there's nothing about that affiliation that impacts anything that I'm doing. There's nothing about the fact that you may go to the same church as me. There's nothing about the fact that, even with now, with the lawyers who appear before me, I was a practicing attorney in Fulton County. And so defense attorneys, prosecutors, et cetera, like just because I know you or just because we have some kind of similar affiliation or whatnot, that doesn't necessarily mean that I am going to rule in your favor. In fact, I've routinely ruled against people who I used to practice against, who have come before me, who are members of same organizations, et cetera.
Doesn't every judge do that?
I hope so.
Well,
I don't know.
I mean,
But I will say if one of my friends or someone like that came in, I would recuse myself from the case voluntarily, much like I did for the partner who my first 2 weeks.
doesn't every judge do that?
No,
Okay.
no. They should. And that's my humble opinion. So let me just say that.
Let me jump back just for one moment to the delayed rulings. In the charges, in case number 24, the 24 case, the first set of charges, you have admitted essentially all of the delayed ruling violations with the exceptions of count 7 and count 10. There are a couple 1.1 violations. Do you understand that?
Yes, you're speaking technical jargon to me right now. But yes, I understand.
Okay, you've made some admissions to some of the 1.1 violations, have you not?
Yes, I think there are 1.1s and 2.2s or something.
Without pulling up all the emails and all the pleadings and, did we go through the 1.1 violations in the complaint against you?
Yes.
And what is your understanding of the statutory provision that requires a judge to make a ruling within 90 days of the filing of a motion? What is your understanding?
My understanding is that if you are in a county of 100,000 plus people or more, that you are supposed to rule within 90 days of the motion, unless it requires an evidentiary hearing. But 90 days of it being submitted to you. Now, given the fact that if you don't send me a courtesy copy, I don't know, but that's a whole side issue. But that's my understanding.
Isn't there something in that about the parties can agree in writing to extend that?
They can, and then there's also, I'm a sesquipedalian, I was spelling bee champ in school, something about providential reasons.
Does the code have any sanction to, if you violate that?
The judicial code?
No, the law, the 15, is it
Oh, the
15621?
Honestly, I don't recall offhand.
You don't remember a penalty?
I don't recall offhand. If you give me a copy of it, I'd be happy to read it.
I don't practice law. I just
Oh.
thought you might know.
I don't remember there being one. I just remember it saying that this is what you're supposed to do.
So to the extent that you have not admitted the violations in count 7 and in count 10, the 1.1 violations alleged in those accounts, why haven't you made those admissions?
Can you give me names?
Green?
Green was because of what I said. The motion required, the response to the motion asked for an evidentiary hearing. So I had to schedule an evidentiary hearing. And then what's the other one?
I'm getting there.
And on that one, I did rule within 90 days of the hearing.
Klein versus Klein.
Oh, Klein versus Klein. Wait.
That's count 10.
Okay, Klein versus, and what's the question again?
Those are, count 7 and count 10 are 1.1 violations to which you haven't admitted.
Okay.
Did we go through those and did you discern that there were motions filed and something else was required?
Something else happened in Klein. As I sit here, I don't remember what it is. And I apologize. Sometimes with these FTRs, they're bleeding together in my head, which documents I looked at, because I had to go through after and look at the docket for the FTRs for the 1.1 purposes and 2.2 purposes, which of course are different standards.
Let me ask, so you've admitted to some 1.1 violations, true?
Yes, sir.
Had you gone through count 10 and 7 and determined that there was a motion filed, it didn't require an evidentiary hearing?
Oh, yes, Klein did have a motion filed, which required an evidentiary hearing.
Okay, all right. Those A little harder than what I thought it was gonna be.
Again,
But either way.
I've been up here for 90 years, so.
I understand, and I'm not going to be too much longer. I know Judge Burleson asked or made some comments about the presumption of what's in the public record concerning your campaign disclosures of Nigel Hunter. Not that it's a big deal, but Nigel Hunter made a $50 contribution. Is that true?
Yes.
Now, some people do it differently when they do campaigns. To the extent, do you have an understanding of what your requirement is when placing someone's name on your disclosure, the amount, as it concerns the amount of contribution that they have to make?
Yes, sir, $101 in the aggregate or more. Part of the reason that I listed every single campaign donation that I received was because I wanted to show community support. And on top of that, I thought it would be easier for the folks who were doing the disclosure so that they didn't have to go back to previous disclosures to see if somebody had contributed or if they had, if it was $25 versus, $30, especially because much of my campaign contributions, when I say my money, was coming from the community, non-lawyers, folks who were making $25, folks who had set it up such that every time they got paid, they would give me $50, et cetera. So I was trying to also make it easier.
Okay, I'm almost done. I just want to address your conversation with the name I'm going to butcher, I hope, Didion Aaron.
Yes, Ms. Aaron, yes.
A friend of Miss Alexander.
Yes.
When you had a conversation with her, did you ever reference Brandy Alexander's name?
No.
Did you ever tell her how you were going to rule?
No.
Okay. Would that have been inappropriate had you done that?
Yes, absolutely.
Those are my questions at this time.
I have one question.
I'll let, age
Judge-
before beauty.
Do what?
Age before beauty.
What about both? How much money are you wanting from the director and the investigative panel?
How much money am I wanting?
Well, it says you want all costs to be assessed against the JQC. I'm assuming you don't mean the hearing panel.
Oh, no, not y'all. I'm sorry.
That's
I
what it
didn't.
says in your answer.
Yes, sir.
What does that mean?
My legal fees. I'm paying my legal fees.
So you want the director and her half of the commission to pay you whatever rates they have? You think, okay.
I think that's what that means. Yes, sir.
I'm what?
I said, yes, sir. I believe that's what that means. Yeah.
Okay.
Judge, I have one question maybe.
Oh, and I'm sorry. Hold on, Mr. Hott. Part of the reason for that is because I have literally been trying to resolve this matter since day one. When I got the notification, I called Miss Veal that day, spoke to her that day. She had to get off the phone because she had an event with her children, or something was going on with her children. I think she was picking them up or something. Either way, I talked to her that day. She told me she would call me back, and I knew Miss Veal. Her husband and I used to work together. We had been out to dinner together at PAC. When I say we, I mean Miss Veal and I. And so I called her day one to say, hey, what is this about? What's going on? I think it was a day or two later, she called me back. And I spoke to her again on that day. And I even gave her Ms. Bowles' number. I told her she could talk to Will. I told her they were both still, Will was not employed with me, but Ms. Bowles was. I told her she could talk to those people. So literally from day one, I have been trying to resolve this issue. I have, from day one, said, yes, I made the phone call. From day one, even in the answer with the rest of the formal charges, I've never disputed the failures to rule. It is what it is, right, as far as the documents. What I've always done is give explanation and context. From day one, I was never given the opportunity to resolve this short of removal. That's why I am here today. That is why I have to go to trial. Because at the end of the day, it's like a death penalty case. If you telling me the only thing that I'm offered is a death penalty, or a murder case, and all I have is life in prison, that's your only offer, and I don't believe that's appropriate, then I have no choice but to bring it to you all and say, listen, I am admitting my wrong. I am taking responsibility, and I've tried to take responsibility from day one. But when you're told the only thing that's on the table for you is removal, I don't have a choice but to come to you all.
Well, you said a reprimand for the, I say false imprisonment, you say in custody, whatever. What do you think the appropriate sanction would be for the failure to rules that you admit to?
My understanding is that for, in general failures to rule, the JQC has recommended private reprimands, and depending on what was going on, public reprimands,
See,
right?
we would not know about the private reprimands.
Right. I'm just telling you what my understanding of the history and pattern has been. So that's my understanding what the history and pattern has been. And I don't want to go too far, but like we even sent a letter to the JQC saying, here, this is what I'm willing to agree to in exchange for us resolving all issues. That letter was sent, I mean, the conversation has been had multiple times. The letter was sent last year. And the response we got was, nope, no counter, no anything else. So when I ask for my legal fees, it's because I am here because the JQC has stayed steadfast to, nope, removal's the only answer. And I know Ms. Veal says that's not true, but to this day, even this morning as I understand it, Mr. Banks tried to work something out. To this day, I've never even gotten a counter to what my proposal was.
Well,
And I'm sorry if I'm getting passionate. I don't mean.
no, I mean, you understand the distinction when you say JQC, you understand there's two panels and we have nothing to do with them.
I apologize.
Okay.
IP versus hearing panel. You are absolutely right.
Understand.
I am not talking about
I'm just
the hearing
prickly
panel.
about it. That's
It's
okay.
okay. I understand. I understand. I get prickly about the JO track versus my track, so I get it.
Here's my trouble with the failure to rules, assuming, let's say I said public reprimand would be appropriate. The penalty for willfully and persistently failing to rule, according to the legislature, is impeachment and removal from office.
Mm-hmm.
So how do I say you get a public reprimand, but the people of this state, for whatever reason,
Yes, sir.
have
Mhm.
said the penalty is impeachment and removal from office?
Absolutely. I get.
So-
Uh-huh. One, I would say that it was not willful and persistent. Certainly, given the volume of what we deal with in the family division, and Fulton is the only jurisdiction in the whole state that has a family division. I literally got in 100 plus cases a month on average, closed out 100 plus cases on average every single month. Even when all that stuff was going on with my mom, even though all that stuff was going on with my grandmother, you will not see where I was not working. You will not see where.
I'm not questioning your work ethic. All I'm saying is I am in a quandary, and I want your counsel and everybody else to understand that if I agreed with a public reprimand,
Yes, sir.
how do I get around the legislature has said, no, it's impeachment and removal from office?
So I would need to see I'm not familiar with that
It's
statute.
in the
If-
code section about the 90 days, 15.621.
Oh, the one I said I didn't know if it said it? Okay. I would need to see it and look at it to see
I would
how it's.
encourage you to do that.
I will, yes, sir. How it's struck, and I meant as I sit here right now, right today, because I also think it says motions, and I'm not trying to quibble, because certainly a delayed ruling is a delayed ruling, but I believe that code section refers to motions, not to trials and resolution of the case as a whole. I don't want to quibble. But my point in saying that is, I have put in systems. I was having staffing issues, and I even sent over to the JQC emails from me to Ms. Bowles, emails from Ms. Bowles to me to Ms. Bowles. I sent them over a corrective memo that she had. I disciplined her when I would find out things, and certainly I got a new staff attorney ultimately, right? And so there were a lot. It's not like I wasn't doing anything to try to rectify the situation once I found out that there was an issue.
That actually, the question I was going to ask, what are the systems you have put in place to remedy this situation or mitigate it from happening in the future?
So one is, number one, they print out all orders, because there was a time when we were having some email issues, right? And I think that was, I know that was countywide, because the county went through and switched out its system and it affected emails and whatnot. So they print out all orders and give them to me. And in fact, the way we do it now is they pull them, if it's a proposed order, they give it to me literally when the trial starts, when the hearing starts. And so they give it to me at that point, and they give it to me in hard copy. I generally hand edit, even though they say I'm a millennial by age, I'm still old school. So I hand edit all of my orders. Excuse me. So that's one thing. If it's a motion or something that does not require a hearing, they literally go through, they being Ms. Green in particular, she goes through and she does a sweep of the docket monthly. She's very meticulous. I mean, she's an amazing staff attorney. But she goes through, and to the extent that she sees motions that have been filed that have not been sent to us, she will reach out to the parties and ask them to send a courtesy copy over and to ask them to send proposed orders if it is appropriate and necessary. To the extent that, and then she gives them to me in a binder. We have a sheet. And I don't know if she does it in Excel or Word, but literally we go over that literally every week, every month, depending on what's going on. So those are some of the systems. I'm trying to think of an exhaustive list, but also trying to be concise in my answer.
Do you find that they are working now? In other
Absolutely.
words, since the last round of JQC failure to timely rule complaints, whatever those dates were, have you had any issues where you've had a late ruling or a late order, or one that you've missed or something, or have you found that the systems work?
I found that the system is working, and it's working perfectly. Well, let me not say perfectly. It's working well. It's working effectively. I've also found, and she and I also have regular meetings to talk about, okay, what is this, what is that. The other benefit to having Ms. Green come on is that she was a former family law practitioner. So when she would unlike Ms. Bowles, and again, I'm not trying to disparage Ms. Bowles. Ms. Bowles was a 25-plus year practicing attorney. However, she didn't have a family law background. So when she would review the proposed orders before sending them to me, she doesn't know what she's looking for. And so literally there was way more editing and way more things that I had to do to turn them around and get them back to her. That wasn't the case with Ms. Green, because she had been practicing family law for 5+ years. In addition to that, another reason I would argue that it's not willful, it's not persistent, is that there were times when Ms. Bush was there that she was out on maternity leave, and I didn't have a staff attorney. So I was also operating as my own staff attorney, plus hearing cases and all the other stuff. With Ms. Bowles, she'll tell you, there were times where literally I sat there and I was like, listen, no, we need to go through the docket, we need to do this. And I would sit there and not be doing what I needed to do, because I was trying to help get her on track and help her, and this is early on, help her adjust to the job, right? Because I do understand that it's a lot. It's very, very high impact. And then in addition to that, what else did we put in place? So then at one point, Mrs. Bowles went out on leave. Her father died, and she had some other stuff. So again, I was operating as my own staff attorney. And then of course the situation with my mom and my grandma. Like, I was not absent from work, but was I literally like every single day looking at orders? No, I wasn't looking at orders every single day. I was at the chemo treatment plan or whatever the case may be, but I was looking at them every week, and I was actively putting out orders, closing cases, approving orders, etc., during the entire time of all of that happening. So that's what I mean by, if you look at my numbers, I wasn't saying that I wasn't commenting necessarily on my work ethic. I was saying that to say that even in those areas, those times where my personal life was on fire, I was still working. I was still issuing orders. I was still ruling on cases. I was still doing all of those things. So again, it's an oversight. It's my apologies because that's not my intention. And especially, I see how this has affected me. This has been going on for 3 years. So that's why I think you should not vote for impeachment or removal, Mr. Hyde, because I do believe that there are mitigating circumstances here that are not just, I'm on the golf course. In fact, if you look at my golf clubs, they're dusty.
That is what the House of Representatives.
I understand, yes, sir. But I also find, and this is no disrespect to the legislature, sometimes the laws that are getting made, nobody takes the judiciary's opinion or even asks them their opinion into consideration when putting certain laws in place. There are certain laws that I don't agree with, but that's the law, and so I enforce it. But I think that if the legislature were to come down and sit with us, some of those laws may not be put in place. Or hopefully they wouldn't, but I digress.
Anything else? Did that raise anything else you needed to follow up on, Mr. Banks or Ms. McFadden? For now?
We're good.
Well, I
Okay.
need to stand up either way.
I was about to say, did you have any follow-up based on that?
I'm used
And
to being
yeah,
under
if
the
you need to
skin
stand
of
for your
the-
knee, that's fine.
My apologies. I have a torn meniscus, so. Oh, I wasn't leaving.
I think she's just stretching her knee, is what she said.
Judge Williams, you just referenced two different occasions where you had staff attorneys that were out for whatever reason it was, and you said you were your own staff attorney. It's true that Fulton County has utilized ARPA funds to provide floating staff attorneys to the judges there, correct?
That's not how that quite works. They are, you said ARCA?
ARPA.
We call them ORCA, so I don't know if that's the same fund you're talking about. But, so for instance, Judge Emerson, Judge Dempsey, et cetera, they hear cases on the criminal and civil side, and you can send family cases over there, but I don't find that to be a good idea, given everything that's going on. So those staff attorneys are assigned to the ORCA. This was back when ORCA was going on. Those staff attorneys were assigned to that ORCA program. Certainly, there was one point where I had a staff attorney come in, but she was splitting her duties between, I think that was another time that I wasn't referencing, when somebody was on leave or not out. But when Ms. Bush was out on maternity leave, that was not available to me. And Ms. Bowles was out twice. So I think it was only one time
But
that.
you're saying things that happen to every judge in this country, probably. They all have tragedy, they all have birthdays, they all have staff that's sorry, they all have staff that's good. I mean, what makes you different than every other judge? Because what you're saying, I hear from judges all over, is what I'm saying.
I don't know how to say this and not sound flippant, because I'm not trying to be flippant. As I see it, there are two types of judges, the reported and the not reported. Even when I was a judge, when I was a litigant, I had cases where we didn't get orders for a year plus. And I'm not saying that makes it right, that still makes it wrong. But I don't think it's fair to say I should be removed when this is not a Judge Williams specific issue, and given the circumstances.
Have you filed complaints against any of those other judges that have done the same thing?
No.
Okay.
Honestly, I didn't even know that was a complaint when I was a litigant.
Well, you've known for the past 3 years, right?
I'm a judge now. I said when I was a litigant.
Okay. But multiple times during your testimony, you have talked about how other judges do a lot of the things that you do.
That's not what I said. I believe I was talking about the failures to rule.
Okay. Judge Burleson asked you about your new systems, and you indicated that they're working really well. To be clear, you're no longer assigned to the family division, or you're no longer on the family division, correct?
Right, but those systems were put in place as of July of 2024 before I came out, no, 2023, before I came out of the family division. I came out of the family division December 31st of 2024. So one of the things that I had Ms. Green, my new staff attorney, do, literally her first month was dedicated to walking the docket and literally looking at every single case to determine if there was anything outstanding. So that's part of what we did the very first
Walking
month.
your new docket, like your new regular docket? Or
No, this is when she started with
prior?
me when I was in the family division.
Okay.
Because candidly, after I got the JQC letter, it was apparent to me that there were some things that I was not aware of that I thought had happened and had not happened. But certainly, I can't go back and change the past. The only thing I can do is go forward and try to rectify whatever issue there may or may not be.
And I realize it may be slightly different to adapt it for a regular caseload versus a family law caseload, but do you have a similar system in place now in your, whatever your assignment is now?
Yes, ma'am. So my staff attorney is primarily assigned to managing, and when I say managing, I don't mean she's completely there without oversight, but the civil docket. My litigation manager, the way at Fulton County, litigation managers handle the criminal docket. And so literally they have a division of labor. And so the way that the criminal cases are handled is different from the way the civil cases are handled. I will tell you that somehow I always get the challenge dockets. So I will tell you that upon assuming this role in the general jurisdiction, that's what we call it, the general jurisdiction, I literally in December, when I knew which docket I was going to be getting, I had them pull the civil docket and I also had them pull the criminal. We literally walked through every case to see what the status was, where it was, etc. I had a meeting with all of the lawyers, the prosecutors and the defense attorneys, the PDs, when I say all of the lawyers, the PDs, the conflict defenders, as well as the prosecutors and folks. I told them I introduced myself to them. I said, this is our system. This is how it will work. I told them that certainly I had pulled the docket and saw that we had some very old cases that we needed to get resolved. And so I told them that the structure was going to be that at the end of January, we had what I affectionately call the rocket docket speed dating calendar, for lack of a better term, where literally every single criminal case that was 760 days and over, every single criminal case I statused. Every single civil case that had an answer filed as of that date, I also statused every single one of those. And so what we did with the criminal cases is the ones that were 760 and over, after that status, they automatically went to a trial calendar. The lawyers were told about that 2 months in advance. So what I did for the criminal lawyers was I gave them the month of February off so that they could focus on those criminal cases and getting them ready for a trial. And I told them the trial month would be in March. During the month of February, I focused exclusively on civil, with exception of some emergency motions that I might have had to hear on criminal. And then we moved a lot of civil cases. March, when we came back for trial, any of those criminal cases that were still remaining from that January calendar, we started trying them back to back to back. And so now we're doing the same process with cases that are 365 and older on the criminal side. So that calendar, and we gave the lawyers advance notice, so they had about 2 or 3 months notice. And so that calendar, I believe, is in July, where I'll call that calendar for all cases assigned to me that are 365 days and older. I will note, and I'm extremely proud of the fact that, like, literally, we only had 5 cases that were 760 and over to carry over. And candidly, those were because of lawyer leaves. Like, for instance, I have one lawyer who is on a very high-profile case right now, so I can't get him in right now. So that case, though it was specially set, it had to be continued. So I only have 5 cases remaining that are more than 760 days over. And then the civil cases, like I said, we did the same thing. And I have regular case management conferences with the civil lawyers. Ms. Green's instruction is that at 60 days, if there's an answer before 60 days, she's to bring them in for a case management conference. If there's not an answer before 60 days, then she's to bring it in for a status conference. And so she literally goes through the docket monthly, updating it and seeing what's going on with the civil cases.
Okay, thank you.
You referenced the phone call you and I had at the very beginning of your dealings with the JQC.
The IP, not the hearing panel.
That's correct. And you talked about that phone call and some of the things that you did. I think as an example of your representation that you have been trying to resolve this matter from the beginning. Do you recall how you first initiated contact with the JQC staff after you got that complaint?
Email or phone call, I don't remember.
Okay.
It was Miss Birch, is that her name?
Okay, so you remember her name. Do you remember calling the main line of the JQC, speaking to Miss Birch, and immediately saying, this is BS?
I probably did.
Okay. So do you think calling up the JQC that has just noticed you of an ethics complaint and immediately out of the gate saying this is BS, do you think that the people there making recommendations to the investigative panel, do you think that would make them comfortable that the judge is wanting to resolve it and everything's good?
Ms. Ville, I cannot speak to what was articulated to you from Ms. Birch. First of all, I did not raise my voice at her. I did not scream, yell, curse at her, or anything like that. So that's first and foremost. When I spoke to you, I told you what happened. From the very beginning, in my conversation with you, I told you, yes, I had a phone call with her. No, I did not discuss the merits of the case. No, I did not talk about the case. So from the very beginning, and even though there are folks who said, don't go sit before the IP panel, they're just going to try to trick you, I still came, and I still was trying to be cooperative. I immediately engaged Mr. Banks to try and resolve this situation, because what I also recognized was that as a lawyer who has never had an ethics complaint in her life, never had that issue, it was traumatizing for me. And I think you will recall that, as you stated, we talked on the phone, and you shared some things, I shared some things, and I said, listen, I don't know what's going on, but that's not correct. So that's what I mean by from day one, I've cooperated, I've tried to resolve this. After Mr. Banks got involved, he had numerous conversations with you trying to resolve this.
Okay. Did y'all ever talk about the fact that...
Who is y'all?
I'm sorry, let me withdraw that.
Okay.
So, you also know that in the midst of all this, before the investigative panel voted on how to proceed, you came before them, you made a statement, and you conveniently could not remember the phone call with Aditi and Aaron.
It's not conveniently, ma'am. I just told you I did not know about that phone call or I did not remember that phone call until Miss Aaron filed the motion to recuse. So it was not a lie. I did not remember it, which is why I answered it the way I answered it. That as I sit here now, no, I don't remember. But just like today, having literally spent the last 2 weeks going through dockets, preparing for this, reading that, there are a lot of things that I now recall because I've done those things.
Okay, were you ever informed that when the investigative panel voted to file formal charges that an option for you was a public reprimand?
No. Nobody's ever told me that, so.
Okay. Well, she opened the door to negotiations and represented that.
Can we just pause 1 moment? Let's take about 10 minutes. And then I think if maybe we can convene for just a minute, and then maybe we'd like to talk to you guys before we reconvene, okay? So let's just take about 10 minutes. Everybody just take a breath, take a walk, and we'll meet back in 10 minutes, okay? Thank you.